Rock and rolling time. Okay, we're on the record. This is good morning. This is the New York City Board of Standards and Appeals. Mic's on for the Board of Standards and Appeals for February 5th, 2019. We'll begin with the appeals calendar. Item number 1, 10379BZ, 2530 44th Street, Queens, and item number 2, 2017-144A, both for 2530 44th Street, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth? And your testimony before this board and respond to the board member questions? Yes. Sign that one.
Good morning, Lisa Orantia from Ackerman LLP for the applicant. So we received a letter from the fire department listing objections and recommending that these be cured before the CO revocation case is dismissed and the amendment to variance granted. Most of the objections are based on building code and MDL, which DOB will review at the time of the filing of the legalization application. The applicable law, the objections in the fire department's letter cite to 2014 code and Article 6, Section 170 of the MDL. These are not applicable. The building was constructed in 1980. Review is requested under the 1968 building code, and DOB's objection sheet that gave rise to this CO revocation case cites to 1968 building code.
Sorry, so when the fire department is citing to, so you're saying because it's citing always to the 2014 code, the fire department doesn't have the authority to be imposing these kinds of requirements on this property?
Well, I'll go through each of the objections. Often, substantively, it will mean that the plans will show compliance with these requirements. I just want to be clear that the requirements are established in the 1968 code, and certain sections of the MDL are not applicable. As we submitted to the board in the last letter, the MDL defers to 1968 building code and states that certain sections of the MDL are not applicable.
Right, so that's the argument that you made the last time, right? So, of course, unless asked quite specifically by DOB, we're not the reviewers of the application of the code, right? That's the Department of Buildings and Fire Department's determination on how they apply the code to your project, right? So if you want to pursue with those two agencies the applicability of the code and so on, that's your decision. But this is a legalization. With all legalizations, we require that the work be done first, right? So unless there's something that prevents the work from being done first, for instance, DOB won't issue a permit until.
Yeah.
But DOB would issue a permit to install sprinklers in the house, for example. Anyone can install sprinklers in their house. So
I'm not sure, and we can hear from DOB as to whether the applicant can undergo plan exam right now, given the pendency of these cases.
Well, so the plan exam, for instance, DOB wants the installation of the sprinklers. That's their, yeah, it's DOB. So DOB states that the lack of sprinklers is not merely a code violation that arose after the C of O was issued, but rather is a defect in the issuance of the C of O, as the job application never identified a sprinkler and there was no sprinkler installed. So I suspect that DOB would allow the sprinklers to be installed prior to our decision on the variance. We don't know. We'll find out from DOB.
Yeah, it's a tricky issue because the sprinkler requirement is triggered by the three-family occupancy.
Yes.
And so the question is, what do you do first? You file plans, you get them reviewed by DOB that call for the installation of the sprinkler. DOB accepts them, and then the BSA will allow withdrawal of the CO revocation case.
No, so the thing is, those sprinklers are required, according to DOB and the fire department, for a three-family. You can install sprinklers in a one-family, right? So they won't object to you installing sprinklers in your house.
But the reality is you're not going to install them unless you have the three-family occupancy.
Well, but so that might be the terms under which the board is willing to consider the application. So it kind of goes like this. This is an illegal use, right? That you're trying to legalize, your client is trying to legalize, right? And if we were to grant this, what then requires forces the property owner to actually comply with the law? The property owner has no history of complying with law, so what's to say that any of these safety measures will ultimately be installed? And you can't say, you could say, oh, it's not fair to assume. Well, we don't need to assume. We've observed this owner converted illegally this building and didn't follow the requirements. And now we're asking them to do it. And if they're not willing to do it, then that from my perspective, that's why I kept asking about the compliance with the multiple dwelling law. The 3 units have to be safe. And if they're not made safe, then.
Yeah, we agree.
Has 3 units.
We agree. And, we're here today because the applicant did file for a permit, obtained a C of O for the 3 families. And unfortunately, there was the oversight of not coming back to the BSA for approval of that conversion. But it's not as if the owner simply disregarded the law and just went ahead and did conversion illegally and didn't even attempt to comply. So this is an applicant who has come to DOB and BSA in an attempt to legalize. But if I can just go through the objections, we can then decide what procedure could be followed as the next step. So the plans, and I have a revised set of plans, we do have to do one more correction. These were revised last night, but it's missing one change. So I'll start with number 1, enclosure and separation of enclosure and separation of the stairs and hallways, means of egress. So the plans show the following notations of compliance with, again, it's 1968 code, but the building will be fully sprinklered, and the plans show a 2-hour fire resistance rating.
Where are you? Where are you looking at, actually?
I'm reading against the fire department's January 25th letter to the board, number 1.
There's no extra.
That requires enclosure and separation of the stairs and public hallways, providing a required means of egress. And it calls for a 2-hour fire resistance rating. So the plans reflect that the building will be fully sprinklered.
Where do the plans reflect that?
Floor plans, proposed floor plans.
Is there a page of the
But is there a
plan?
page? Do you not have a set to look at while you're talking? Is that the problem? Okay.
Oh, good. So one to the fire department. He's got it. That's what's.
So P002, basement, first floor, and EP003, second floor plan. The note is on the lower left, says building to be fully sprinklered.
The lower left. Okay, now I see, building to be fully sprinklered. So these are proposed plans.
Those same sheets show a 2-hour fire resistance rating for the stair and hall enclosures.
So, one of my problems is I can't tell what's in place and what isn't. It makes it look like this is a total new construction job. So it doesn't show us that they're adding a wall or whatever, right? So you can't find out. Is the boiler room already enclosed? I don't know. Is there already a bedroom? It says existing bedroom, but I don't know if there's an existing alcove. Like each one of those things, you can't tell whether it's existing construction except for the bedroom.
Right, you'd have to compare it to the existing plan sheet. But we can
Which is
revise
The first page.
Where's the existing?
E002
E002.
existing. But I can ask the architect to revise the proposed plans to show a change.
These are EPs, not E00. No. So E002 makes it look like there's already a sprinkler in place.
E002,
What is that dash? Those are sprinkler heads. What's the dashed line?
I think that's a fire egress extreme.
Sorry to speak up.
Oh, I think that dashed line on first floor, if I understand it, is the longest distance from the corner of the room to the fire stair.
No,
I
not
think.
that one. On
one?
basement floor plan, there is a dashed
Oh,
dot
that
line
one.
that seems to, it's either going to lolly columns, it's going to lolly columns. So I don't know where the sprinkler, there's no sprinkler heads actually shown on P002. It just is a statement that says building to be fully sprinklered. Looks to me.
so on proposed plans, you'd like those sprinkler heads indicated?
Yes, and also yeah, I mean, it's indicating that there's not even a smoke detector in the building currently. It's showing as a new installation in P002, and it's not shown on the existing drawing. All this is really cause for concern with that this is occupied at all. Is this occupied currently?
Yes, occupied.
Right, so it's a danger that it's occupied.
It-
Why is it occupied?
It could be a issue with the notations on the plans. They weren't drafted with code compliance in mind because it's not a DOB set, it's a BSA set. But whatever you'd like indicated, I can let the architect know.
Well, it should be reflecting what the existing conditions, so when the fire department says it needs to have X, maybe that's already installed, and you could say, oh, it's already installed, but if it doesn't even have smoke detectors, you've got something that's
Okay,
really dangerous.
I'll let her know to show the existing smoke detectors.
Smoke detector, sprinkler heads, fire rated walls, whatever there is, show it as existing, and show us what will be added, because for instance, if you look at P002, it says boiler room enclosure to be 2-hour fire rated with 1.5 fireproof self-closing door. The layout didn't change at all, so does that mean the boiler room is already enclosed? Or does it mean that they're going to be adding a layer of sheetrock and changing the door? It doesn't indicate what the scope of work is.
I'll have that clarified. Number 2 on the fire department's letter, no door opening shall be permitted from a garage, and the door from the garage to the stair hall or public hall will be eliminated. The set that I handed out still shows the door, so that's the correction that needs to be made.
Sorry, where, I don't know. Tell us where you are in town.
Proposed plans, P002.
And
You see the door,
the door to the garage.
garage to the towards the meter room,
Yes.
so that will be closed off. Number 3 on the fire department's letter, boiler room and furnaces must be enclosed and separated. The plans will reflect the boiler room enclosure.
So the boiler room is already shown as enclosed. Is that an existing condition?
We'll clarify.
Okay.
Number 4 on the fire department's letter, automatic sprinkler system that meets construction requirements shall be installed throughout the building. P002 indicates that the building will be fully sprinklered.
So you're going to revise the drawings to show the sprinkler heads and the smoke detector locations.
Is the fire department seen?
No, so we'll have the fire department speak.
Number 5, the proposed dwelling unit must contain smoke and carbon monoxide alarms.
That's
Those will be installed.
shown on the drawings where, right?
Number 6 on the fire department's letter, all sleeping rooms in the proposed dwelling unit shall have at least one exterior emergency escape and rescue opening. Again, this cites to the 2014 code, and we're using the 1968 code. So the plans contain a notation. P002, 1968 code, section 27366-1D. That allows only one exit because the building is fully sprinklered.
So, but here's my question. The request by the fire department is only that there be, what's the language, one opening to the exterior?
Oh, well, it calls for one exterior emergency escape, fire escape, according to the 2014 code. So an interior means of egress and an exterior is what this objection is asking for.
So I don't know the details, we'll let the fire department speak to that, but my experience has been that the issue is, are the windows large enough for egress, right? So, and if the windows are too small, then they need to be enlarged, and we've had some really terrible stories where people cannot get, it was a really terrible story, I think it was 2 summers ago, where the family couldn't egress and they were all on the top floor, right? And so the idea of having a window that your body can sit through doesn't seem to be a very large request.
We'll provide the dimensions of the windows. Number 7 calls for guides and notices required by the fire code to be distributed and installed, and the plans do note that P002. Number 8, all fire protection systems are subject to inspection. We agree, and that the plans note that as well. And number 9, no, there won't be any storage of combustible materials in the boiler and meter rooms.
All right, so then I'd like to hear, I know that fire department hasn't had a chance to review the drawing, but if we could have Chief Daly come and speak to us.
Good morning, John Daly, Fire Department. As you had just stated, I have not had an opportunity to review the plans. I do want to make a note regarding the sprinkler system, especially because we're going to, the building has to be fully sprinklered, we do require a fire department connection on the outside the building. That's most important. Showing the sprinkler head is great, but we also would like the fire department connection to also be shown. Thank you.
And then in terms of, did I understand it correctly, that comment about the egress from the sleeping rooms? What is the actual requirement where it says all sleeping rooms in the proposed dwelling unit shall have at least one exterior emergency escape and rescue opening, meeting the construction requirements of section 1029 of the building code and 1025 of the fire code?
Okay. On that section, we were describing that the window from the interior of the bedroom, the window, the sill height has to be a certain distance, the window opening has to be a certain size, and once they exit through the window, we do need clearances for a person to exit out through the window and for fire department personnel to enter through the window.
So it's not a fire escape that has to, there's no landing, it's just allowing fire department to remove people from the room.
That's correct, right. There is no fire escape system.
Okay, great, thank you.
You are.
Yeah, and Department of Buildings?
Good morning, Madam Chair, Commissioners. Andrew Wallace, representing the Department of Buildings. I attended yesterday's review session. There weren't any comments directly to the Buildings Department. You do have the letter of prior representative on this, Jennifer Kim, January 14th, requesting that should the board grant the variance, we would request that the application for revocation remain pending until the issues are corrected. Ms. Arancia has described pending plans or plans that have been drafted. We have not seen these plans either this time.
Right. So this is a question about how we might actually handle this. So as you know, sometimes we ask that the work be done before a decision is made on a variance. And the problem we sometimes have with DOB, which isn't always, it's just sometimes, and it's not really clear how the decisions are made, but sometimes DOB says, well, we can't grant a permit unless there's already an approval, right? And in the case of a pending revocation case, not really sure how you even grant the approval, right? Because the goal of everyone would be to make the unit, the building safe, right? So the question, I know you can't answer it just standing there, but if that is a question to DOB. How, you heard Ms. Arancia's list of things that need to be done, all of which will require permits, right? So, or most of which will require permits. So the question is, would DOB be willing to issue permits based on basically a two-family house, because that's what would be allowed, and they're just going above and beyond what's required for a two-family, so installing sprinklers and closing the boiler, which anyone can do, that kind of thing. Could we get permits? Could the work be done before the BSA decides on both cases?
Okay. As I said, Madam Chair, excuse me, I'll have to take that back and can certainly report back.
Okay.
It might be helpful when Ms. Arancia revises the plans, if I could have a copy of those as well.
Mm-hmm. Yes.
Thank you.
Great, thank you. Thank you. Okay, speakers.
Good morning. My name is Sarah Maria Vaccaro. I'm the owner of the property next to Mr. This way?
To you, because we can't hear you.
Okay. Again, my name is Sarah Maria Vaccaro. I'm the owner of the property of 2528 44th Street, which is next to the property in question here today. It's clear that Mr. Nastasi's attorney are not being forthright with the conditions of the BSA's reason why it's deed restriction. It's clear on the minutes, and which was already submitted. I'd like the board to read and know why it's deed restricted. In R5, it's a requirement to have an 8-foot side yard, and he presented information to the board, not letting him know there is an easement, an existing legal-sized driveway, and the board did not do its due diligence by site examination at the time. And in 2014, the board was made known by a deputy borough commissioner, Mr. Adam Wampanak, that Mr. Nastasi is in violation of the BSA ordinance of changing his occupancy illegally in 2003. And since he built the house in 1980, he never complied with R5 zoning regulations. No one oversaw or entered to see what was in compliance. This has been an ongoing situation. It's over 40 years. And every time we would complain, it would get mysteriously disappear. It's very clear that the board needs to uphold the decision that was made in 1979. In order for him to be able to build what he wanted, there was conditions placed in place that the occupancy cannot be changed. It's 2-family occupancy limit. That was the trade-off for a 4-foot side yard. And now to come with dirty hands to illegally change his occupancy and now want it to be thrown away and continue is unbelievable. The board needs to do its due diligence and respect what was decided and do its findings. Not take face value of what the attorneys are saying, because attorneys are not mentioning anything about the easement. Its easement is a driveway. It's not a maintenance, it's a driveway, which he clearly eliminated. So the hardship he caused and detrimental to my property, because the variance should never have been granted without seeing the property, how it would impact our property. That variance was given under fraud. It's continuing being under fraud. By him changing it, saying it was a mistake, it was calculated. Because he never went to the BSA or the building department to change it, because he knew they would have caught this. He went to pre-certification, self-certification, and did this. And now, because he wants to keep his illicit income, he's still destroying my property. It's clear in the minutes that I handed in March of 2018, and also Mr. Wampanan made the board and the BSA and the DOB aware of him being in violation. And I'd like the board to read the minutes so they have a clear facts on why the property is deed restricted.
We actually have a copy
I know,
of the
but
resolution.
apparently every time I come to the meeting, no one discusses why. They seem oblivious to why it's been deed restricted. It's very clear. It's very clear. You can't come to the board doing something fraudulent and expect the board to, close it and agree to it. It's very clear. He was not allowed to change the occupancy. And he did. From day one, there were 4 families living there. In an extreme, dangerous condition.
So I just want to clarify, just so we have this on the record. The application was to build a 2-family house that had a substandard side yard, right? So
No, it was
side
a
yard-
variance for a 4-foot side yard, I'm sorry. Sure.
Right. So there was a variance request here to reduce the required side yard from 8 feet to 4 feet. The board granted that variance. So it has, the owner has the right to construct the 4-foot side yard. And we've talked about this previously, that side yard complied with the easement. Because
Didn't comply with the
is-
easement.
I'm sorry, if you're going to interrupt, I'm
Okay.
speaking. And that the easement allowed for a 4-foot side yard, so it was in compliance with the terms of the easement, and that it's true that the board limited the property to a 2-family, okay? Now, it's true that the applicant went to the Department of Buildings, and though Department of Buildings shouldn't have done it, it issued a permit to convert the building to three-family, which is permitted as of right in an R5 zoning district. It's true the owner should have come here first, didn't, and that's the reason that DOB is here now with a revocation application on the C of O. However, the board now has the authority, and the applicant has, the property owner has the right to ask for an amendment to the variance to increase the unit count to 3.
May I speak?
And that's what we're talking about right now.
May I speak?
Can you finish, please?
Yeah, I'm asking her.
Let her finish, Mrs.
Yeah, okay, and that's what we're talking about now. So I just want to clear the record, so when you hand out a resolution, the resolution does state the facts of what occurred back in 1979. However, we are here now with an amendment to the variance, and that's what the board considers.
But that's not the board, it clearly states, in order for him to build these two buildings, that's what had to be in place.
Yes.
So he already built the buildings, so in other words, he's had his cake and eating it too. That's what you're doing, because he wasn't allowed to change his occupancy. And you're not taking that in consideration, how you gave a variance without doing a property site, how it destroyed our driveway. Nowhere does it say that they waived his built house not to have a legal-sized driveway, and he took that away from us. He detrimentally destroyed our property from day one, and it's continuing. And the board is not taking this serious. What the board is doing is having dirty hands, just like Mr. Nastasi, because what the board decided then did not do its findings, and the board today, the Deputy Borough Commissioner, Mr. Admin Wampanak, clearly states he's in violation and needs his C of O to be revoked. A Deputy Borough Commissioner, you're not taking into fact that he did his due diligence and saw there was a serious situation here, and you're not taking it serious. For the attorney to lie about the easement, to lie about the reason why it's deed restricted, because it's common in the area. The properties in that area were built before he built. That's number one. And number two, the easement clearly states, a law of record, it's for a driveway to access of garages in the back, which he clearly eliminated his garages and mine. And that's a violation. And you're not seeing that picture, because if anyone on the board actually went to the property site, they would understand what we're going through. And you're not taking this in account.
Thank you.
All you're doing is pacifying me, and I think it's wrong.
Thank you, Ms.
No, I would like a member to ask me questions, to have them justify how they agreeing with his findings. I'd like a copy of his findings.
Excuse me, I believe your 3 minutes are up. Thank you.
And I came last time and you didn't hear me speak.
Because we adjourned the hearing. Okay, we've heard your testimony before, and
But no one seems to understand the findings.
we do understand our findings. I think we've heard your testimony. Thank you very much. And
Okay.
we appreciate
And
it.
I guess it's going to go further. Thank you.
All right, Mr. Ranthia? Okay, so I think you know what we need to see, and we know what DOB needs to give us, so, I don't know.
How much time do you need?
So let me just get some clarification. So the architect will revise the plans to show compliance with the list of objections the fire department has raised.
Yes.
And document what exists today and what will be added. And to make certain additional clarifications as to location of sprinkler heads, et cetera.
Correct.
And then the applicant is directed to file an application at DOB for a permit to install and do this work
Yes.
with a two-family occupancy.
So that's what we're asking DOB, because we don't know what the process would be. So we're asking DOB now to go back to its technical division and ask them how this would be handled. And then we can give instructions on that, and we can give instructions through council if we find out this answer quickly. It's just that I don't know, we don't know how it would be done, right?
Yeah, so the timing is going to depend on how much we need to do.
Yes, well, we also have a hearing schedule that determines the timing also, so.
Sure. I guess the question is whether you need to see the plans
Yeah, we
before
do need to see
you
the plans
go
before you do
and file. So maybe there should be
Okay.
an interstitial
Yes.
Right,
before you go
okay.
permits.
And fire department needs to review them, DOB needs to review them, DOB's also had objections, so we need to make sure that they're complying with both agencies, and then we'll find out how work would be done, and, right. Okay.
So how much time would it take your consultant to revise the drawings, Mr. Rentia?
Let's do a week.
Way fast.
We can do this in a week. Well, we can't do this in a week, so.
Oh, sorry.
This is just for submission.
Yeah, this is for submission. Oh, then fire department has, and DOB have to have time to look at it, so we shouldn't, chop because they need time, okay?
So are we going to submit to the board first
You'll
or
submit-
share it first?
You're going to submit it to the board and
Simultaneously.
share.
Okay.
Right?
How do you feel about March? She could still submit and then give the fire department DOB time afterwards to give their own kind of like a reply. So March 19th, or 1, 2, 3, 4, 5, 6, 7, 8, or March 26th.
Let's do March 26th.
Okay, so
Seems like enough
if
time.
you can, in a week, sorry, that would be February 13th, 1, 2, 3. Okay, so Mr. Rentia, if you would submit by February 13th, simultaneously to the board, the fire department, and Department of Buildings, and the Department of Buildings and Fire Department, you could review and submit any comments or follow-up by March 6th, and then the hearing would be March 26th. March 26th? Does that work for everyone? Mr. Rentia?
That's fine with you?
So the applicant will submit on February 13th, and the agencies will submit on March 6th, and the hearing on March 26th.
That's right.
Thank you very much.
Thank you.
So I just want to, because I don't want the record to have this kind of be open-ended, I'm going to be reading the section in the easement that was discussed, okay? Which we talked about many times, and I want to close, just have the record follow with that conversation, right? This is from the easement of the subject property, so it's the easement that burdens the subject property, right? It's part of the deed. It says, together with an easement for a private right-of-way and driveway over the northerly 3 feet 5 inches of the premises immediately adjoining on the south, extending easterly from 14th Avenue, 80 feet more or less to garages built or hereafter to be built on said premises, and this conveyance is subject to a similar easement over the southerly 3 feet and 5 inches by 80 feet more or less in depth, extending easterly from 14th Avenue, or westerly from 14th Avenue of the premises, hereby conveyed said two strips of land to constitute and be a private right-of-way and driveway 6 feet 10 inches wide by 80 feet in depth to be used and maintained in common by the owners of the respective premises and by their successors in interest. So we're talking about a 3 foot 6 inch easement, and
4
the
foot
board,
side yard.
and there's a 4 foot side yard that was granted by the board. The board was aware. The drawings show, the approved drawings back then show the awareness of the 3 foot 6 inches on the other adjacent property and 4 feet on the subject site, just to clarify. Okay. All right.
And that is how it stands today.
And that's how it stands today, right? Okay, so just, all right, so I think that's. No, I'm sorry, you cannot. I'm sorry, we're done, okay? All right, let's move on to the next. Thank you very much, everyone.
Item number 3, 2017-249A, Major Deegan Expressway and Van Cortlandt, the Bronx.
Good morning, Madam Chair and Commissioners. Patrick Kilduff, Tartar, Krinsky, and Drogan. I attended the review session yesterday, and I listened with great interest to the board's comments, specifically those calling for the tidying up and additional sleuthing that would be required in connection with this application. Again, as a threshold issue, the question before the board is whether or not the signage at issue enjoys non-conforming use status pursuant to zoning resolution 4255, subparagraph C2, in that it was established prior to October 31st of 1979. Since our last appearance, we did submit an amended statement of facts, and the timeline, as was specifically requested by the board. We do appreciate the chair's comments that timeline was helpful. Again, in support of the establishment prior to October 31st, 1979, we did submit the Conrail application document 13579, dated from July 28th of 1977. We also noted the approval by Conrail of that application as of November 30th of 1977. In addition, there was the 1978 correspondence, the TDI memo also referencing that approved application. There was some other correspondence that is dated post-1979 that we believe also confirms the establishment prior to October 31 of 79. Specifically, there was the November 16, 1982 TDI correspondence and the February 27, 1989 correspondence to Conrail, which specifically indicated that the signage had been in service since July of 1977. Now, we noted that, again, one of the comments that DOB again raised is why we didn't submit any DOB applications or permits, but as I think we had addressed in our last appearance, DOB had long taken the view that the signs on railroad property were not subject to their jurisdiction, and was only in the face of the Clear Channel constitutional challenge that the city abandoned this position and then claimed that it could exercise jurisdiction over all signs on railroad property. And as this board is well aware, between both this board and the Supreme Court, exemptions were established with respect to signs located on Amtrak and MTA property, leaving this discrete subset of railroad signs on Conrail CSX property for which no exemption was found to be applicable. So therefore, we're now back in a traditional analysis of nonconforming use under 4255 based on establishment prior to 79, and that's how we proceeded with respect to our arterial registration submission. Also, in an attempt to establish nonconforming use, we did provide a series of photographs. I know there were some comments about the photographs yesterday, admittedly, especially the historic aerials photographs. I mean, they are somewhat grainy and blurry. I mean, they are by definition aerial photographs. I know there was specific comments specifically directed to the point of, well, you can't discern what actually would be on the sign itself, what type of copy would be displayed. In that regard, I would just offer that it's reasonable to infer that the text in this case would be advertising copy, unlike a traditional case where you're talking about, a warehouse building or a roof sign along an arterial, where there could reasonably be a prospect that the signage could be directed to an accessory tenant occupying X amount of square feet in a building. Here, this is a lot, which is basically used for railroad purposes. There is no other building or structure on it. It is the subject of these agreements with TDI Outdoor Advertising Company. I believe under the circumstances, it would be reasonable to infer that this is not a case where you'd be looking at a traditional accessory business sign. There really is no other business activity. We think it would be advertising purposes.
But none of that's in your submission.
Sorry, we're not
the microphone towards your mic.
None of that's in the submission. And what I'd like to see from the next submission is a very tidy argument of showing evidence and how this evidence is sufficient pursuant to 4915, and why you believe that the indicia together would show that this has been a sign that has been established on such date and has been continuous use. I'd also, if there are other ways, there are other cases where we've had other evidence that can only help you to start digging around for other photographs on this majorly used expressway.
Yes, and I take your point, Commissioner, and I know you had made that point yesterday at the review session. Again, we had, of course, endeavored in our amended statement of facts to give a further description, but I do take your point, and we will do what we have to do to walk the board through our proof and our arguments in order to make that clear. Again, we're here to try to convince the board that this is a legitimate non-conforming use. There is a sign that's there. Unfortunately, with these types of cases, when you're involving railroad signs, when you're not proceeding from the view that this is a location that was subject to jurisdiction, we don't always have the same amount of documentation that we would if we were talking about a traditional non-conforming use case for a sign on the BQE or the LIE, where it's always been a private property owner at play. Again, I think there was, this understanding or this appreciation of the fact that no one needed to necessarily keep all of those records tidy, and that's why it's been a challenge in terms of trying to marshal all of that evidence. But that being said, I mean, we have, looked at other, third-party sources and New York Public Library digital collections and Skyview surveys, and we are, still going through the process of trying to, shake the tree, so to speak, to come up with any other photographic evidence that would support our position. But at least to date, again, because of the aerial photographs, we believe it is reasonable to infer from those that they do depict a sign. Admittedly, you can't tell what the text is, but again, we believe that it's reasonable to infer that that text would be advertised.
They demonstrate the presence of a structure. They don't demonstrate the presence of a sign. That's one of our problems.
And yes, I think that there is, I think, obviously an inherent limitation with the aerial photography, unless you're coming in on a certain angle, and I have seen that in some other cases with some of our Skyview surveys photos. If it comes in on a certain angle, you might be able to depict a copy. Again, a lot of the historical aerials, it seems like it's just a true, straight down, bird's eye view, so it's hard. I'm sorry, Vice Chair Shana.
Following up on Chair's comment, there might be other documents that might connect the dot between the structure being there and that structure being leased for a particular sign company and agreements that were signed that the sign was put up. I mean, there are a lot of other ways of connecting those dots, and there's at this point, maybe one can say, yes, there was a structure, but we don't know if that structure was used at all for any signage.
And just to add to that, so TDI was the lessor at the time, or licensee at the time, and sometimes they keep records for a really long time about what copy was up, right? They know that they had a bulletin board or whatever it is, and that they were advertising Clairol. They just, right? And they keep logbooks.
Yes, and actually that is something that we have been going back and trying to track that down. Actually, TDI is one of the corporate predecessors in interest to Outfront. Outfront Media is the current operator of the sign, so we have had people, trying to go back into the archives to try to find those records, if there was anything that we could tie into in terms of copy. Chair, you mentioned the specific reference to Clairol, and I know you're talking about that wonderfully grainy, Xerox photo that we had in one of the files for this location, which had a Clairol sign. As I think the board might note, if you can make out the little ID tag underneath the text of Clairol, that was actually a Foster and Kleiser sign. Now, Foster and Kleiser is a different outdoor advertising company. I know that Foster and Kleiser actually only...
in the lower right-hand corner, that little blob?
No, the picture has, like, the center of the picture is the Clairol ad, and then it's got a little tag underneath it. Which is the ID tag. Again, it's what I've always been accused of when I look around, the city of New York. I don't look at the signs, I look at the tags. So I look to see which ones of our clients are operating the particular sign. So I focus right in on the tag underneath, and I saw that as Foster and Kleiser. I know that Foster and Kleiser was one of the celebrated old outdoor advertising companies, over 100 years old. But as of 1986, they were sold to Patrick Media. So my first take in terms of the specific question of trying to date that sign, date that photograph, is based on the acquisition by Patrick Media in 1986. I don't believe that picture could be later than 86, because clearly one of the things that the companies will look to do is update the tags. If there's a new name of a company that's operating a sign, that's going to be reflected on the tag. So again, I will try to pinpoint the date for that, because I know that was something that was specifically
Okay, so you see
referenced.
Foster and Kleiser, we have a terrible image. So if you're going to say it's Foster and Kleiser and then take the argument, you need to give us a
If
close-up
there,
of
if,
that,
yes,
right?
well, again, that's when, the image that I, in preparation for this, as I looked at the image, it made out to me as Foster
No,
implies.
but what we're seeing is
If your
black.
image is,
Right.
if it's not clear, then we'll obviously try to get you the best possible resolution.
But the other
of the
thing
picture.
that, and one of the reasons I brought this up, because we learned how someone did it with respect to a Marlboro ad, right? I did an image search for the Miss Clairol product, and it does send you back to like 1950s ads where there was always a woman photographed with a child for hair coloring. The connection always confuses me, but never mind. So there was probably a period where that was the approach to advertising for the Clairol product, and that might be something worth researching. That
The creative campaign that they were using at that one given time.
It may not have extended into the 80s, in which case then you have established that the sign, the back of the sign anyway.
The back, yeah.
So that's the problem, it's just the back of the sign. And it's not 100% clear that that's the sign in question, so you need to be able to also establish that that's the sign in question, the one with the little asterisk above,
Yes.
right? So, but it seems to me that by the same token, the advertisers who were on the subject sign had the same kind of records, right? Or that sign might have shown up, again, in photographs of high-speed chase scenes in movies or whatever, and that you should be able to.
And we've been searching all sorts of, like Major Deegan repair projects and other work, because obviously this is, situated right as southbound on the Deegan at the quarter-mile mark before exit 10. It's usually right next to exit 10. So we've been looking for old historical photos of exit 10, the exit 10 sign, anything where we can find, our sign in the background, since it is located relatively close to the exit sign.
And just a question, are you doing this work in your firm, or is your client doing the work who, that's the thing, a law firm only has so many
Yeah, that's,
skills
there
and
is,
assets.
obviously, there's some of this legwork that we're doing because of our familiarity with it, but there are people at Outfront who are trying to track down some of this information as well, people who have gathered this type of evidence for us when we argue our cases down at oath, when we have to argue non-conforming use. There are people who, they know what to do in terms of searching. It's just, again, it's the railroad cases, again, it's a little, seems to be a little more of a challenge as opposed to the traditional non-conforming use cases, but we do have people searching. We do have the relationships with the aerial companies such as the one I mentioned earlier, Skyview Surveys. We have seen, other archives of New York State archives, New York City. There are other New York Public Library photo archives that we've looked to. I know, the board has talked about other things in movies and in film. We really find particular chase scenes or other ways with old National Geographic articles. Anything that can give us any other image of that sign in place. But again, as we stand here today, my argument would be with respect to the structure, that the structure was in place, that it's admittedly grainy, and that the reasonable use of that structure, unlike a structure placed on the roof of a building where you could talk about an interior tenant, would be for advertising purposes. The railroad was looking to derive revenue, just as MTA was, just like Amtrak was. This wasn't going to be for Amtrak or Conrail to say, like, ride the rails or promote the railroad use. So believe me, we understand the mission that we're charged with and the challenge that we have, and we want to do whatever we can to give the board as much information as possible to validate this use that our client sincerely believes dates back pre-79.
Okay, so then the other question is, I made the leap that agreement, or whatever that thing is, that was signed in 1977, might be the equivalent of a lease.
The application.
But you need to make that argument and explain to us what we're looking at and how, if a lease is one of the proofs that DOB accepts under Rule 49, how that thing is the equivalent of a lease, because it doesn't look like a lease, right?
Again, I think it's a function of the unique relationship between the outdoor advertising company and the railroad as opposed to a private property owner. And we had thought from our submission, we said that this was the document that we were relying on, but we will spell it out why in the context of 4915.
So 4915 is basically choosing these documents because they're reliable. And these are the type of, so if you can make an argument as to how this licensing agreement or whatever other evidence you have is as reliable and akin to it being these special circumstances that you're claiming,
Yeah.
that would be helpful, but we need to see it.
And we can articulate that, Commissioner Giobetta, in writing. Again, I would argue that, just as you point out, the agreement, you are talking about it is a document that is signed by both parties that indicates the specific location of the sign. It is something which I think gives the same type of core information that you would find in the license agreement. And again, this is like the same, corporate family of outdoor advertising companies that have had it, so it's not like this has gone through different third-party outdoor advertising company hands. It's basically been a franchise that TDI, Infinity, CBS Outdoor, now branded as Outfront Media, has operated for all of this time. Obviously, Conrail is not disputing the fact that the sign is on their property and has been, operated, continuously, consistent with the zoning resolution. But we will articulate that and why this falls within the parameters of 4915 or should be treated as an equivalent to the specific items that are listed in 49.
And to help us with this is, there isn't any, it doesn't show how much is paid for this license or anything, so we don't really understand how this thing works, right? Maybe there's a way to find out what the relationship, obviously, there's still a relationship, right? There's still some kind of monthly payment made to the railroad or however it works, right?
It's clear that the document you submitted was part of a larger agreement, which would include the fee and there was no amounts paid or anything on like that in this agreement, which you would find in a lease. But it's clear that this document is part of a larger agreement. That would be helpful, especially if you're trying to say it is equivalent to that of a lease.
So,
And if you were able to find that agreement from 77, you would think there would be some history of the bigger deal that was made. Or of the logbook that's related to it, or et cetera, et cetera.
The board might also take into consideration the economic climate at the time. For instance, in other board cases featuring prominent signs by the Holland Tunnel, there was an 80 by 90 foot sign at 111 Varick Street that the New York Times reported in 1983 had sat vacant in 1975. And so it's very important that the board receives evidence that this was actually in use for advertising purposes as of the date.
Good point, right? So that's the thing. Today, you drive and we see many empty signs, right? They have a black board in front because obviously they're under scrutiny of DOB.
that could be a whole nother conversation that would take hours, Madam Chair.
Yes, exactly, but nonetheless, it indicates the absence of the required use, right? So there might be that nobody was renting the sign in the late 70s, for example, or something like that. You put the structure up, but there's no tenants.
Right, and even if it's rented, it's not being used. There needs to be a sign on it.
Understood.
Okay, great. All right, anything else to go over with this? All right, so DOB?
Thank you, Madam Chair.
Thank you.
Pat, come sign. It's okay.
Good morning, members of the board. I'm Michael Zoltan on behalf of the Department of Buildings. I think the board mostly understands the department's position and why the department felt that the evidence submitted and the arguments made fell short of proving non-conformance of the sign. Just to touch upon a few points again, the Rule 4915 talks about acceptable evidence to prove non-conforming signs. Photos and leases are put together for a reason. They are distinct from permits. So we understand sometimes you can't always, special circumstances exist where there aren't permits. There are other routes to go. You can bring photos and leases. Now, photos and leases together will show everything that needs to be shown. It will show that the sign was there in the relevant date. it will ideally also show that it's advertising sign as is required by the rule. You need both together. So as a reminder, in this case, we don't really have photos pre-79. We're looking at ones a little bit later that are aerial and maybe show a structure. Okay, it's a bit off. So we don't have the advertising sign satisfied. So the argument is that we are making logical leaps as far as it was advertising because it was in OAC, but OACs will also put up accessory signs. So that's not conclusive. These are leaps. It doesn't really satisfy what's required by 4915.
But you wouldn't have an accessory sign on this property where there's nothing to be accessory to.
Well, it could be accessory to the railroad, right?
Okay.
Exactly. So it's not impossible for it to be accessory to the railroad, and the rule requires that it be proven that it's advertising. And a leap isn't exactly what's satisfying 4915. The only other thing I wanted to point out is, in addition to the fact that the documents are not leases, these are just documents that indicate that there was some sort of agreement. Specifically, I did want to reference the 1989 one, realizing the date is 89 and not and later and after the 79 relevant date. But it does mention that there was an approved application for the above location, which has been in service since 77. Just wanted to point out that it said application, doesn't say anything about that an actual advertising sign was up, and the fact that this is after the date. The other point is, in the subject line of that 1989 memo or letter, it describes a 14 by 48 sign. The sign at issue is 19 and a half by 48. So even in 1989, it wasn't referencing a sign of the same size, which is required by Rule 49. So
19 by 48? Is it
it's 19.6.
abnormal bulletin size? That's weird.
It wasn't my sign. But pursuant to zoning resolution 4255, this is a 55A2. This is a advertising sign, allegedly, that is within 200 feet of an arterial highway. And 4255A2 says that no advertising sign shall be allowed. But obviously, if it was there before 79, then under C2, that's okay. But it also says, nor shall any existing advertising sign be structurally altered, relocated, or reconstructed. At some point, that 14-foot became 19 and a half, which is a reconstruction. So it would not have non-conforming status based on that. And also can't go back to 14 because it was discontinued as the 14 sign. Just another point to throw into consideration. So overall, we're looking at something that doesn't have clear photos that it was existing, doesn't have proof that it was advertising, more logical leaps, wow. And we don't have leases. We are looking at documents that indicate an application, but nothing further.
Right. So that part of our problem, it's our problem too, right? Is we don't really so the railroad arguably doesn't issue leases to people. Arguably, it issues license agreements to people. So, but a license agreement, what does that look like? That's part of what we're trying to get to. Is that object that we see where there's a signature on the bottom from the railroad and it's very clear where the sign is located because there's a plan of it and it tells you it's a 14 by 48. No, it doesn't actually say anything. It says on it 30 height to bottom 30, footage of space 48 feet. So that's the square footage. So we don't actually know the dimensions.
I wonder if that's actually just the structure. I'm not sure what the 30 by 48.
We don't really know the specifics of this. Obviously, it would be the structure because that's what they're putting on the property, right? And then the right to keep changing copy might be somewhere in the backup agreement. So, because, again, this is making leaps, but it seems like if TDI Outdoor had dozens and dozens of deals, or maybe even hundreds of deals with the railroad, they wouldn't be executing separate agreements for every single one. It would be like one big agreement, and then they're constantly adding and subtracting with these very simple documents. And that's what we're trying to figure out. And the idea that it says in Rule 49, lease, that's the most standard way that someone gives you access to their property, right? But there are also license agreements which can be viewed as the equivalent of a lease, and that's
Yeah,
kind of where we're going there, right?
The DOB isn't suggesting that a license agreement isn't equivalent to that of a lease, is it? As far as Rules 4915, whether or not something that should be held in consideration as something as a reliable, I don't believe that that's the position.
No, I think you're right. But it would have to be a
It would have to
license
be-
agreement that is equivalent to a lease, not
Of
a
course.
single-page
Understood.
document, right?
Understood, that's reasonable, yeah, okay. All right, thank you very much. Are there any other speakers on this one? Okay. So, yeah.
I'd just like to add before we,
Yeah, so I think there needs to be one, did you want to add
Just,
something?
I think that in your response, you should also respond to the discrepancy that DOB just provided with the 14.
with respect to the
14
sizes,
and
yes.
19. That would be fatal if that.
Because the 48, actually, now that I look at it, if it's a 14 by 48 sign, right, that was part of the license agreement, that 48 on it, there's something that says 48 feet, but it's in the footage area as opposed to the linear area. So is that sort of as the term got presented to us the other day, a scrivener's error? Or what? Like, what does the 48 feet refer to? Okay. All right, so I think we need to give you time to finish your research, but I do want to say we gave you a lot of time the last time to do your research. So that was November 8th, right? And I'm concerned that you're taking too much time to do the research. So we need you to rev this up, right? Not sort of wander in and a few days before get what you have, right?
The machine is revved.
Okay, good. So, because I do want to say that the board shouldn't be filling in all the blanks for you, so that the next submission really should be every imaginable photography source photographic source that there is having been tapped, which includes film footage, all of those things. And if necessary, hiring an outside consultant who specializes in this so that they can do it faster. And then, of course, the backup for whatever that thing is that was signed in 1977, as much as possible to understand what that is. Yeah?
I truly expect a substantial submission, and this is a valuable interest, and it's a big request with very limited information at this point.
Right. Okay, so should we give them like 4 months to do the work, something like that? That's what we did the last time.
Yeah, but that time also included replies and SIR replies. Would you like to follow a similar schedule as the one is that?
I think that
Okay.
would be fine.
All right, so I think you want to give them 4 months?
Yeah, 4 months to do the research.
To do the research. So that puts us in June for their submission? So I guess we could work backwards. June, is it? And then we give like 3 weeks and then 2 weeks. Okay, 3 weeks and then 2 weeks.
Do you already go up to those?
July 3rd, June 4th. 3rd. 1, 2, June 29, 1, 2, 3. Okay. So working backwards from August 6th, actually. Yeah, that's where we are. So that would be a SIR reply from Mr. Kilduff on July 17th. That would mean that DOB's first submission, or DOB submission would be July 3rd, meaning that Mr. Kilduff's first submission would be 1, 2, 3, June 12th. I can repeat that.
What would the hearing date be?
August 6th. Commissioner Cheetah won't be here, but
I will be here.
you will be here. June 12th. Do you want me to repeat those?
August 6th for hearing date. My initial submission, June 12.
That's right.
DOB submission, July 3, and my reply submission, July 17.
That's right. Mr. Zoltan, is that okay?
So
Okay.
that's a lot of time.
Yeah.
So please give us an amazing submission, something where we're so impressed by the level-
I'm making the note to make sure that it's amazing.
Yeah, you don't know, but, right, we're so impressed by the
You'll
depth
laugh,
of
you'll cry, you'll
research.
take it'll be an emotional tour de force.
It will, yeah, and in addition to depth of research, all the dots tied together, so we make zero leap of faith on our own. You take us right through the argument.
We'll take
There
you
are
on a
no
journey,
leaps.
southbound on the Deegan. There, yes.
And it would be helpful if there's any case, any precedent that supports using this indicia as substantial enough to grant the relief requested.
Okay.
All right.
Thank you very much.
Thank you.
Special order calendar, item number 4, 17699BZ, 4517 Marathon Parkway, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, to respond honestly to board member questions? Are we reopening? We're just voting on this.
Oh,
We're good?
yeah, we did have questions, so I guess we need to. So for a motion to reopen,
Chair Perlmutter,
aye.
Vice Chair Chanda. Aye. Commissioner Otley Brown.
Aye.
Commissioner Sheta.
Aye.
Commissioner Shabeta.
All right.
Good morning. Todd Dale for the applicant. So from your review session, I know there were a few questions. To start, I think there was some discussion about the submission. Did you get the submission? There was a submission that was made. I have another copy of it here.
We
I
got a
forwarded it
submission on, I think it's January 14th.
January 14th that had the revised plans, the
Yeah.
bubbled plans. Okay.
So but the bubble plans, that's what was, so the bubbles are very helpful, thank you. It made it very easy to go and see what was done, right?
Right.
But that was maybe the problem. So then you see what was done, but there's no beef, sort of, right? It says evergreens, minimum 6 feet high, doesn't tell you how many, doesn't show you any planting details, doesn't anything. The trash enclosure, same, we don't know what the trash enclosure looks like. We don't have photographs of that fence, of that wall behind.
I have here, these were taken yesterday afternoon. but I have
Great,
a few
okay.
copies. These are photographs. Just so you know, the property owner actually has an office in this building, so is very aware of what's going on. We believe it's maintained well. I'm sorry, there's only 3 copies, that's all I printed. But those photographs show that the evergreens that are in place currently are there. They sent me just a few, but there is a photograph of the trash enclosure that shows the fencing that goes around it. It's sort of this slatted, opaque fence around the trash enclosure. The photos there show the north side of the lot, which I don't know if were in the original photos, but there are some significantly tall evergreens between this lot and the commercial lot to the north. So there's
what-
2 photos there. And then we showed the existing evergreens that are currently in place, just to show that here in the middle of winter that these tall trees are still there. And those trees, in conjunction with the fact that we have this like 8-foot fence or 6-foot, depending on what side you're on, we have double level of screening, not only to the residential use, but also within the commercial portion of the lot. With respect to the details, when I asked the architect, he said he put in the species of trees because those are the primary type of screening there. They do have low landscaping that's there also, and he told me it's a real mix of everything, and that when it becomes spring planting season, they will often put in annual flowers just to make it look nicer, but they're really, between the fence the large trees, the low-level screening is really tertiary at best. And I don't think it really, they can't even see it from the residential lot, essentially.
Okay, so actually, I actually thought when it said evergreens that that was a future planting because everything else says existing.
Okay,
So that was
understood.
part of it that I thought, well, then that must be an empty lot, and it's hardly empty. It's really, it's actually one of the few times we see this working.
Yes, it is, I have seen few lots as screened as this one.
Yeah.
And then the trash enclosure, as I said, they noted it. And there was questions about the carting. They pick it up twice. It's a private company. They pick it up Monday evening as trash and recycling. Friday evening is trash. And the uses in there are office uses, and he says they never go past the capacity of the dumpster that they have. Because they're not high refuse generating uses there.
So here's my question for the board. I mean, this is an extraordinarily good property owner in the sense of really maintaining the planting in really top condition. Maybe we just, normally we ask for drawings that show all the plantings and so that the next board can see whether it complies. If we do that, we need to put it on for another hearing, right? In this case, we could just say conditioned on maintenance of the landscaping. We don't have a method for getting DOB to have, photographs. So this just goes into the into the records, which the next board could dig in if they want to, but it's not part of the set of drawings. So if people are okay with us just conditioning on maintaining the existing lush landscaping or something to that effect.
And the property owner agrees to maintain the landscaping 365 days a year.
Okay.
They agree to. And just one more note, just so you know that the latest plans, that December 18th is when he actually made the revision. Some of the plans that have the December 18th date, that does reflect the new revision. So some of the plans have the July 9th date because there were no changes, and only the plans that were changed have the December 18th revision date on them. So that's why he just changed the revision date on the certain sheets.
I don't know if Commissioner Shabeta was going to suggest this, but we can discuss the photos you've provided in the resolution and kind of indicate to future boards. Go look in the records and their photographs.
We can describe the amount of screen, thank you.
Yeah,
I didn't
the
know
photos
that.
provided in the record, we can refer to them, so.
Right.
in
We'll
Get them
absence of
clocked in
plans.
and let's
We
scan it
can
up.
describe and say an adequate level of screening and however in-depth that we'd like to go in the resolution to assure that
Well, it's dense screening.
we could find the proper word and description to save an extra appearance.
Sure.
Okay, all right. So are there any speakers on this since I reopened? There is a speaker? Okay. All right, then I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition that the owner maintain the existing lush landscaping, which is installed to create a dense screen along the property lines against the adjacent residential property.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Thank you.
Continued hearing items, item number 5, 53966BZ, 6119 Fresh Meadow Lanes, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Good. Sign.
Sure.
Thank you. Thanks. Thank you.
Thank you.
Elise Fullader from Eric Palatnik PC on behalf of the applicant. I'm here today with Andrew from Stonefield, who's going to, after I go through the changes on the plans, discuss the traffic impact study. So firstly, you told us to provide signs and striping on the drawings. So we added on page Z002 for clarification, proposed stop sign facing site and do not enter sign, and it's on the left-hand side by the curb cut on our property.
So I see corner Meadow Lane, Fresh Meadow Lane, there's a proposed stop sign facing site and do not enter there, that corner,
Yeah.
smaller curb cut. And then there should be another one, shouldn't there be another one on
There's-
64th Avenue?
It's right there.
Two, there's a,
Oh, I see, yeah, proposed stop sign facing site, okay.
yeah.
Yeah, it's above the tanks, that note.
Yeah, they just wanted to make it in a clear space. For trash, we were told last time, or at least we believe, that the intent was to keep the trash away from residences
Yes.
in the back. And your board has the power to, with a variance, waive all requirements, so we, because it's for the, I'm saying for where to place the trash, because you mentioned 3794. So we put the trash to your right. We thought that area maybe was more away from the street. Maybe a better location than right at the corner, but otherwise it would have to be in the rear.
Okay, so the property to the right of the convenience store is commercial, right?
Yes.
And then the property,
And then all the ones in the rear are residential.
right, so this is like 75 feet or 80 feet away from the residence this way, right? But it does open onto directly to the sidewalk.
Yes. But it is a variance.
So it's kind of, I think it's better than on the corner where it's almost like a feature of the site. Look, trash.
So if your board,
I
Wait,
think
so-
it's better, but.
Are you suggesting you amend your variance to also include a variance of the location of the trash?
No, actually, it's not necessarily a variance of 3790. It's not clear that 3790 actually even applies to the site. I don't, it's what the board has used as its guide.
okay.
So 3790 is quite a complicated section. I'm not really sure it applies to the site because it's not a development, arguably.
And we've done things like this in the past.
Yes. So I don't know that they need a specific waiver. If they feel like they need a specific waiver.
I mean,
I don't think it's up to either of us, though, whether they need a waiver.
So that's the thing. So we're showing them, but I think that the board has often moved these trash receptacles around kind of wherever, trying to keep them away from the residents, and at the same time, trying to keep them away from the street line 50 feet away, right? And sometimes rock and hard place, you pick one.
Yep, so that was
I
our
don't think we
difficulty.
ever specifically waive 3790 unless we have an objection.
I mean, I haven't seen.
Yeah, so I don't actually think it's necessary.
So if you like it there, we'll keep it there.
But so are the commissioners okay with this relocation? Okay.
And then it's like tucked behind.
Yeah, it's much better.
Okay, and then the 8 feet open area was also created to try to avoid a zero lot line, as it simplifies construction substantially and not having to deal with the impact to neighbors when they are building. It's just more ideal to keep it slightly away from the lot line.
So how do we make sure they don't store trash in it? Because
Well-
there it is, the trash receptacle area. How do we make sure that they don't use that entire 8-foot back?
Well, it's really hard to access now that there's a trash enclosure in it.
Well, they
And
can go
there's-
around the back.
Yeah, and there will be planting along the back.
They will?
Yeah, that's part of
Planting
the,
along that side. Where's the,
It says proposed gravel area
Yeah, that.
over
Yeah.
weed barrier.
And then on
Yeah.
0/009 has the plantings on it.
Oh, yeah, it is hard to access because you have to push past the shrubs on 09.
And I also was told by the architect that DOB code requires an 8-foot wide open area where 0 is not provided.
Yeah, no more than DOB,
Yeah,
bulk zoning,
yeah.
right?
But it was more ideal to not provide impact to neighbors by having it a slope.
Well, also to be able to access your own wall, I think is very important.
Yeah.
So that you can paint it, you can point it, whatever it is this is made of.
So hopefully with the trash and the landscaping, nobody will go back
Is
there.
everybody okay with it just being a gravel area like that? Okay.
I do have a question. If we back the trash enclosures a few feet back instead of exactly on the street line, I think that might serve a benefit as well.
Slide it back.
Slide it back. I think, the difference between 80 feet and 75 feet or 70 feet is not going to be that much, but I'm sure 10 feet is a big difference on the sidewalk
So the
line.
difference though is then you've got like a little strange 8-foot alley on the sidewalk. So, because normally we want a fence there anyway.
Yeah, we'd want a fence there anyway.
Right, so what you're doing, maybe what you're just talking about is making the trash enclosure longer, but arguably that encourages putting more garbage bags in there. So my concern is there wouldn't be a fence, right? And you need to have a fence because you created this blind alley.
There is a fence.
There is a fence, I believe, though.
Yeah, there is a fence, I'm looking at
Okay.
no, I see there's a gate, right?
There's a gate
So
that
you
you
need to have a
open up.
gate, you open the gate, you go in, and then you're.
Who's to
at-
say you're not having 15 feet of,
Yeah, exactly. I mean, it's effectively, once you've got the gate, you've got trash. That's just the reality of how it'll be used, I think. No,
Right.
I see what you mean, but
no,
I'm
I
concerned about the
didn't
blind
think about
alley.
that realistic, pragmatic
Yeah.
point.
Okay.
So you're okay with this?
Yeah.
Okay. What else? So we changed all the fencing areas to say opaque PVC fence. It's on Z002.
Okay.
It goes throughout the pages. And then because it's opaque on the lumens diagram, it's all 0 because you won't be able to see through it onto the lighting.
Because the light poles are lower than the 6-foot fence.
Was told it wouldn't shine in because of the opaque fence,
that work?
6 foot high. Can get further clarification unless, do you know? Sorry, I actually have the architect here,
Okay.
so I can swear him, and I don't know how to answer that question.
Come first, yeah? Now you raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Please sign and proceed.
Luckily, he's here for a different case.
Oh, it's because the lights have shields on them, that's why.
Yeah, they also, yeah.
So that's
okay.
different, yeah.
Oh, lights also have shields on them, yeah, but I was told that with the shields.
Please state your name for the record.
My name is Andrew Stewart, High Point Engineering. So as the chairman pointed out, the area lights adjacent to the resident property will be shielded, have light shields on them. In addition, besides the opaque fence, the landscaping also provides a deal of shielding from the light sources. Between all those, that's the reasoning and the outcome of the 0 lumens on the adjacent property.
But these pole lights are pole, right? The ones on the property line.
There is one on the property line at the corner, I guess it's the northeast corner by 64th Avenue.
Yeah.
And then there's I think there's a building light on the side of the building. But between, like I said, between the landscaping and the light shields and the opaque fencing, the lumens drop to 0. These are all inputted into a photometric program, taking into account the height of the light fixtures, the shielding, the sources of landscape and everything else, and it spits out the numbers. They're not just numbers that we make up. So.
Right. So my main question is, you've got So we're less concerned with the 64th Avenue spread. It's
Okay.
okay to spread onto a public sidewalk.
Right.
But for instance, adjacent to the convenience store, you've got lumen levels of 12 and 13.8. That's high, right there at your property line.
The lumen level is actually, the program is, I think the lumens, it spits out the numbers a few feet above the ground. So it's not that the lumens are 13 feet in the air or anything like that. The trees will block out the light shining to the adjacent property.
Okay. All right, so normally what we want is so your program is set to be at, I don't know, 8 feet away from the property line, 8 feet away from the subject property line onto the neighbor, it's showing 0, right?
Correct.
So normally we would want just over that property line, it to be 0. That's part of the problem, because according to your,
I see what you're saying.
your
This is-
diagram's indicating it's stepping down by 8 feet away, it'll be at 0.
I understand what you're saying.
Yeah.
Yeah, it's a set grid, obviously, you can see that the program spits it out at. I mean, we can confirm that, but from what I've seen, this type of a setup would be a low 0 lumens across the property line.
Okay, so because I don't know that we had any other, coordinate the DOT review on curb cuts. I think we still had open DOT issues on this, right? Yeah, we do. Okay, so then, since we have open DOT issues, maybe you could correct the lighting plan to take into account your analysis.
Yeah, we can look at that, yes.
Show that the second it's over on the other side of the property line, it's at 0, right?
Okay.
And maybe your program can take into account the shielding and the intervening bushes and all that.
Yeah, it definitely takes that into account. We'll check the grid layout and see where it is right over the property. Sure.
Great. All right. Thank you very much.
We passed out Andrew passed out a revised traffic impact study, and he's going to explain to you why updating it to perfectly match these plans doesn't affect the impact study. Here he is.
Thank you. Good morning, Madam Chair and Commissioners. My name is Andrew Valeri, Project Manager, Stonefield Engineering and Design. I'm a licensed professional engineer in the state of New York and the traffic engineer on this project. So listening to the conversation yesterday, we did find out that there was a discrepancy between the revised site plans and then our traffic study. And really just to clarify that, the driveway configuration that we're proposing, it's 4 driveways in total. Along Fresh Meadow Lane, there's 1 full movement driveway, 1 ingress-only driveway, and then a similar configuration on 64th Avenue. 1 driveway, the furthest west would be ingress only, and then the driveway further to the east is full movement. So updating the traffic impact study to reflect that, we did that and submitted it to the board. We'd be more than happy to continue to work with DOT on this project. We did receive some preliminary comments from DOT that we had addressed, and now we're looking for their response to those responses, and then anything further that they have from us, but we'd be happy to further coordinate with them regarding the new study and new plans.
Are there other comments?
I do
Yeah.
have one question, and I'm looking at the map, Exhibit 1. Can you, because Exhibit 1 still shows the 3 curb cuts on 64th Avenue.
Which one exhibit
And
one is?
same thing, Exhibit 2.
Oh, okay. Exhibit 1 in the traffic study, right?
Right.
Oh, okay. You were correct. It's still showing 3 driveways there. The findings of this study look at secret methodology for where certain intersections have more than 50 trips generated at those locations. And we found by doing this analysis is that anything along Horace Harding or 64th Avenue, that those driveways would be more desirable to people that are passing the site, pass by traffic. You're driving a car, you see a gas station, you're going eastbound in this case, You pull in and you keep going east just because it's convenience-based. The other percentage of traffic is new traffic, someone that goes to a convenience store then goes right back home. What we found in doing this analysis is that those people are to the south of the site. You have a bit of a unique configuration here with some one-way roads. So the only intersections that we had to perform a traffic analysis at were to the south. So although the exhibits 1 and 2 that you're referring to show 3 driveways, it doesn't affect the bottom line of the analysis, which is that the amount of traffic that's generated by the site does not have an adverse impact on the study intersections.
Okay. Okay.
Just think there was one thing that, this isn't relative, relates to Stonefield. I think we're just waiting, we're also waiting for DOT to review potential impacts on the drive lanes and stuff.
Right, yeah, there's, I don't have the name.
Can you speak into the mic?
There's a promise date coming up soon.
Can you speak into the mic?
You must be,
There's a promise date coming up soon.
a promise for review date.
Yeah.
Okay. Okay, and then I think the only other question I had was about the landscaping plan that needs to show curb details.
Oh, so there was a curve detail put on these revised plans. Sorry, I'll tell you what page.
Oh, yeah. On-site curb detail.
It's on Z009.
Right.
On-site curve detail
How do
on the
we-
bottom.
Okay. So I guess since we have a little more time, I know this was done in a super rush. If it could be made clear where those curbs, it says proposed concrete curb typical. Okay. Very good for picking this up so quickly. Thank you, I appreciate it. Okay.
We really tried, gave it our best
I can see that. Okay, so I think in terms of everything on this side, other than the lumen study, we've got the drawings, so it's really just a DOT outstanding. So what do we do with DOT?
So March 4th, is my understanding, was requested as a promise date. I don't know if they-
Sorry, say it louder.
March 4th was requested as a promise date by BSA, but I don't know if they committed to the 4th.
So March 4th, give them a little bit more time than March 4th? More weeks?
Because we can obviously do all of our things
Yes.
in an instant.
No, it's obviously
Yeah.
that, so, and obviously if the turnaround from DOT were faster and they asked Stonefield to make additional revisions, that will be back and forth with them, right? But so how about it, like,
Do you want to do early April in the case that it does come and then you can comment and kind of resolve
Yeah.
issues prior to hearing?
That's
Is that-
a good idea, okay.
Okay. Sorry. So that's a submission of March 20th for a hearing on April 9th.
March 20th.
Okay. And just a question, are there any changes, additional changes to these plans, or have these plans been submitted to the board?
They haven't been submitted because we were going to see if they agreed to the trash, but now that the lighting is being changed, we'll change that. And then we'll also submit the traffic impact study to your board.
So that'll be part of them, like prior to the next submission? Okay, great. Just wanted to.
Both of these are being changed, both of these documents being changed?
Yes.
Yeah.
Yes. Okay, great. So we've got.
March 20th, April 9th.
Oh, and I didn't ask, are there any speakers on this? Okay, good. Thank you very much for your response, quick turnaround.
Item number 6, 49072BZ, 4200 Baychester Avenue, the Bronx. Do you affirm that, sorry. That's this one.
That's the public.
Just sign it first.
Okay, raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond as to the board member question?
I do.
Please proceed.
Good morning, Sandy Ananostou representing the applicant. I attended the review session yesterday, and I noted the board's comments regarding the parking. The previous grant permitted 5 parking spaces. We originally proposed 8 and now reduced it to 7. Employee parking only, because no parking is actually required, but we're providing it. There is a no parking sign that was posted on the site. We submitted photographs, but we understand that the board would also like us to install a employee parking only sign, which the owner will do. And he also installed a combination lock where the code will only be available to employees on both gates. And you have the photographs that show that. The parking is located along, excuse me, the property line with the adjacent residence, and there is a screened opaque 6-foot-high fence there. The other area is a driveway. Also, there was a comment regarding the lighting plan, the light spread. It actually shows on the other side of the property line 0 lumen spread. And Mr. Gohari is in the process of installing new light fixtures. A permit was issued on January 11th, and he's installing new light fixtures, LED light fixtures, which are shown on the plan that we submitted by High Point Engineering. He should have that done, completed soon.
Okay. You know what I think it is, and this is relevant to the conversation we just had with the other architect, these programs that get set at like 8-foot or 7-foot intervals, so they don't put the analysis right at the property line of the adjoining property. So it makes it look like it's a step down from being, it's not very high, but nonetheless, in this case, it's like 2 or 3 lumens inside the subject property, but by the time it goes about 7 feet, it goes several feet into the neighboring property before you see it hit 0. And I guess for future use, all the lumen spread diagrams need to be, make an adjustment that you've always got a lumen spread just over the property line, so we know it's 0 by the time it's over that property line. I mean, that, you see, so I don't know how these things are done, but there might be a way of making an adjustment that reduces the grid size.
Right, it's a program from what to my knowledge, but.
No, it is a program, but I think maybe the grid sizes can be adjusted, and in that way, in future, we'll always see the lumen hit the residential property line, and that way we know it's 0 at the property line as opposed to within the property line. I actually have seen there is a code requirement that says you have to have 0 lumen by something like 4 or 5 feet on the adjacent property. That has to do with lighting pollution codes, but we're not applying it that way, and that's probably why it's set, why the program is set like that.
Okay.
We're looking at 0, but I'm not suggesting that you go back and redo it, because I think everything, you responded very well, your client responded very well to the request, so we appreciate that.
Also, the fence is screened, so by the time it hits the end, the lighting is all pointed downward and away. So by the time it does reach the other side, it'll be, but I definitely understand your point, Madam Chair.
For future use,
Yes.
just pay attention when you get these. Okay, does anybody have any comments or any objection to us just conditioning? So conditioning installing the sign on the outside that says employee parking only and lighting not to spread over the property line. Good enough?
I think that's fine.
Okay. Are there any speakers on this? Okay. So I do want to tell you I appreciate that this was fast turnaround and very responsive, so thank you. All right, so I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Spiletta?
All right.
Just note that's the extension of term. I just wanted to.
Yeah, right, okay.
How long that term is.
Okay, so what is the term?
It's 10 years.
10 years from And when did it expire? It expired March 8, 2008.
So it would be from the date of the resolution?
Yeah, right. Understood? Right. So this expired 2008, so if
Right.
you were extended 10 years, you're done. Right? That's not
Welcome
going to work
back.
out. Welcome back.
Right, so,
It's extending from the date of the resolution.
right, I understand that.
So there's that, and also this is a motion on condition. Some of the conditions we discussed before, no drive-through convenience store because there was still this drive-through bank window, so that's not allowed to be used. That the gates that access that rear and side are controlled at all times by employees. It's for employee parking only. That a sign shall be installed on the outside of the gate saying employee parking only, and that the lighting shall not spread over the property line. Should be 0 lumens on the other side of the property line.
Okay. Also, I just want to make one comment. On our plan, on the south elevation, we show a new door going to the meter room. There's actually one existing door there that will be we're going to relocate the refuse in that area, but we're eliminating that new door. So I do want to submit a plan that shows that minor change.
Then we can close and you can submit.
Yeah, that's fine.
Just eliminating that new door that was proposed, we don't need it. And then the planting area will work because there's an existing
So
door
here's
there.
My
right?
question, I don't know, it's 11:45. Do you think you could make that correction today? We're going to be here for a while. Your client is nodding yes.
Yeah,
Okay.
I guess, yeah, I'll have to call my office to do that.
Yeah,
Just
yeah.
eliminate that door, yeah.
Should you submit an entirely new plan set, or is that one sheet replacement sufficient?
That depends on. Normally, we want to have the whole plan set, it's just easier, right?
But there's also the issue of last week where we get new plans and maybe
Oh,
other
good
things
point.
change, and maybe we
Fine.
just want the plan sheet so we
Yes.
can look at it and
One
vote
plan
based on
sheet.
that.
Thank you very much for pointing.
Is that okay? Just submit that one plan sheet with the change of the-
Sure, that's better.
Yes, yeah, I think so too.
Okay,
So we can second call and then do the vote and conditions then?
okay,
Okay.
Yes, okay, good. Thank you.
thank you.
Were you done reading your conditions?
Yes.
I interrupted you, but-
No, that's
Okay.
Okay, item number 7, 8174BZ, 9727 57th Avenue, Queens. This is administratively adjourned.
So we have to pick a time. Actually, you had commented that your client needs time to put together all the materials, right?
Right, they have an engineering department within their company and they're aware of the issues, they just need more time. We should have made that clear, but I did forward yesterday's video link to them and the prior one from the hearing again. So they are aware and they're working on the vehicular circulation plan, the renderings from what the proposed recycling shed will look like from the street sidewalk, and all the other comments.
And I think you need to state your name.
Sandy Anagnostou representing the applicant.
Okay, so.
They need about 3 weeks. I spoke with them yesterday to get all this.
Okay, I want to make sure, I don't want to rush them too, because we already had 3 months. So
Oh, okay.
3 months and they submitted, they didn't respond,
Do you
right?
want to give 3 more months?
Yeah.
So submission in early June. How about hearing on June 25th, submission date of June 5th?
Fine.
Is that June? June? No, wait, no, sorry, the 5, that's May, sorry.
Getting palpitations.
Sorry.
It's already summer.
Sorry. 3 months is, how about a submission date, sorry, of May 1st for a hearing on May 21st?
Okay,
Okay,
thank you.
thank you.
Okay, item number 8, 28001BZ,
You wanna-
663, 673 Second
take a
Avenue,
break
Manhattan.
before
We
these
call them
two?
together?
After this
Oh,
one.
no, second is.
Sorry, should we call them together?
You want to call them together, or you want to separate them out?
They're not withdrawing.
No, I thought there were
Are
different.
withdrawing?
One was a withdrawal request and the other one
They
is
rescinded
continuing.
it?
They rescinded the
They
request.
rescinded their
Rescinded.
withdrawal request, so it's back in play. Yes, they
So
rescinded
we
the
have to vote on
withdrawal, and
that.
then we have to
Let's
talk
do it
about
together.
whether we're voting on this, because I think we want to.
I think we should call them separately.
Okay, fine. 280-01BZ, 663-673 Second Avenue, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and respond honestly to board member questions? Go.
Since there's potential for vote.
That's true, Ben.
Good morning, Chair Perlmutter, members of the board, Calvin Wong, Ackerman, on behalf of the applicant. We attended the board's executive review session yesterday. The request to rescind the withdrawal request was made in response to certain comments by the board at the last hearing that such withdrawal would adversely affect the prosecution of the related good faith reliance application. But if that's not the case, as indicated by the board's comments yesterday, we will happily withdraw this application. And we will do so this afternoon.
Okay,
So officially on the record, you are now withdrawing.
Correct.
request to withdraw, okay.
Do we do the second call and take a vote?
I'm actually okay with you representing that you're requesting to withdraw right now. I don't know that we need an additional written submission to that effect.
Nope.
Right.
So if that's your request.
Yes.
The board would like to vote on that request now. I see.
So much like to.
Conditioning his request on the fact that the board mentioned that this is not going to affect the other case.
No, he's,
So,
No,
yes, that's what he
That's what he just said,
yeah,
yes.
that's true, okay. So, yeah, to clarify, should we clarify?
Yeah, sure.
Or we talk about it at the next case? No, we clarify, right. The board was relying on the information that was provided to us at this last submission in terms of this following case, that it didn't really have anything at all to do with the variance for the new building. It had to do with an existing building that existed on Lot 28 that had a sign on the side wall that got torn down, and before it was torn down, they went to DOB, and the commissioner said, yes, you could put that sign on the site itself, so unrelated to the variance, right? That's an agreement? Yes.
Yeah,
Yes,
yeah.
Okay.
Okay, so we're voting on the withdrawal.
Okay, all right, so then I'd like to make a motion, did we reopen this? No.
It wasn't closed.
It wasn't closed, okay, a motion to close, or, no, do we need to? No, a motion to withdraw.
Motion to withdraw. Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
All right.
Application's withdrawn.
Great.
Item number 9, 2016-4273BZ, 669 Second Avenue, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions?
Yes.
Go.
Good morning, Chair Perlmutter, members of the board. Calvin Wong on behalf of the applicant. We attended the board's executive review session yesterday, and the two most notable comments, I believe, were related to the illumination, the degree of illumination, and the location of the sign. Since yesterday, we've attempted to speak to the applicant of record who attended the original 2008 meeting, Mr. Loria, and we were unsuccessful. So we'd like to request a short period of time for us to respond in writing to those two issues. And it can be very short.
Okay. So, okay, so what is it that you're trying to actually get at?
Well, the
Relocation of the sign to this other place?
correct.
right?
The plans that we submitted in the most recent submission were related to the structure application, which was number 110301343. We're going to do some digging into the actual sign permit application, which was a separate application, and we'd like to speak to the architect and see if he can advise us one way or the other with regards to the location of the sign. As the chair noted, it's not directly on Second Avenue on the plans that were submitted.
Right, okay, so in other words, you're looking to see whether the architect of record had a follow-up meeting or something like that?
Or
with
the plans that were
commissioner?
subsequently submitted reflect the current location.
But in terms of, if you're talking about detrimental reliance, of course, it needs to have gone to a higher
Correct.
command, right?
Yes,
So that means another,
we understand.
interpretation by the commissioner as opposed to simply a permit,
Yes.
right?
It would have had to have been vetted fully and not just like you just slipped one in there.
Understood.
Right, right. And,
But this is something that you, on the last hearing
sorry, you have
date,
to speak into the mic.
on the last hearing date, I recall correctly, you stated that this was something you were looking for since then.
We did, and so subsequent to that hearing, we were able to speak to the architect. These were the plans that were provided. This is new information related to the actual location, I guess 50 feet away, that we'd like some additional time to just discuss with him.
Because the other thing that I'm sure we said in earlier hearings was that there is no permit for a sign in the DOB file located on lots 26, 27. The permit is for a sign on 28.
And I believe that was in part due to the inability to, because the original permit was on 28, the DOB couldn't enter this permit into another lot.
Because the lots were merged?
The lots were merged, but when the second sign permit was applied for, they were unable to enter that permit into this new lot number because it was supposed to be a grandfathered sign.
Well, right.
Yeah.
Exactly why you can't.
But it was
move
a single zoning lot. But we'll respond in writing.
Because I don't think it was a single zoning lot at the time. That's part of the point, is that when it was shown to Commissioner Santulli, when the drawings were shown, there were these individual buildings on individual lots that were shown as an existing condition, and then the sort of tear down where you still had the individual tax lots, because the tax map.
They were individual tax lots, but I believe that they were merged by law. I believe our last submission discussed the merger.
Yeah, there was a last submission with
zoning lot.
indicated.
I'm not,
Go ahead.
I'm not really very confident that the submission is going to, the second submission is going to change my mind on what's happening in this case. And but if he's requesting a short adjournment, I say we grant it.
Okay. All right, what do others, I feel the same way, because we've already talked about this, and there was lots of time to come up with these documents, because we expressed this skepticism on the very first hearing, where we said, we understand you have a permit for lot 28, it's sitting on lot 27, and we had asked for backup drawings to support the reconsideration. That we had the reconsideration, we didn't have the backup drawings. So what we had asked you to do is show us what the commissioner saw. So we now see what the commissioner saw, or at least the representation by the architect that this is what was shown to the commissioner. And it's consistent with our thinking that it was supposed to just drop down from the roof of the existing building onto the ground, and didn't. And that the commissioner approved the dropping down onto the ground. So I'm not really, and it seems to me if there was another zoning interpretation by the commissioner, that would have been made evident already.
That would have been at the forefront of their argument,
Yes.
not where we are. But if it's a short adjournment, I don't see a harm in it.
Okay.
Well,
All right. Are there any speakers on this? Okay, so it's going to be a very short adjournment.
That's okay.
You had plenty of time to come up with these.
Understood.
Right.
We're also hindered by your calendar. So how
We
soon
are,
would
well,
you?
Let's see what we have available.
No, not that one. So I guess we could.
13, yeah.
Oh,
No, sorry, that one, March 5th, yeah.
but that would be, yeah, that's 21, it's 19, it's 14.
No, but it doesn't require us to look at much.
Okay.
So it could be soon. So what's today, the
5th?
So do
it's
we
next
give them a week?
Wednesday.
No, that's too little. Okay. So that one.
Okay. So submit by February 27th. Gives you 3 weeks,
Yep.
approximately, for a hearing on March 19th.
just one question. Are you representing that you have reasonable to believe that there's
No, we'd like to
evidence?
speak to the architect before making any such representations.
Okay.
So one question that I have for you is, you obviously received this material long before we did, right? And we received the material and then we don't look at it until, sort of a week or 2 weeks before the hearings, right? So I'm surprised that you didn't follow up on this when you saw the material had opened questions, right? Where you realized, uh-oh, this is showing it dropping down right onto lot 28, not onto lot 27.
Don't believe it's dropping it down to lot 28, but we'll respond.
That's exactly what it's showing.
We'll
If you
The
don't think
language
that's,
of the recon even specifically says that. That's probably what undoes your whole argument right there. The language says, let me read it.
I can.
It says, request reconsideration of objections 14 and 16 based on grandfather application and BSA letter allowing sign relocation at this site. Note, the sign is substantially in the same location as originally, but much lower in height and therefore making a lesser impact on the community.
and then, assuming that the diagrams that were submitted are the diagrams that the commissioner looked at, then you see 50 feet away from the corner is the sign on the diagonal, and that 50 feet away coincides with lot number 28. And it's the architect who represented in an affidavit that that was the drawing that was submitted to the commissioner. So to say that it's not lot 28 is confusing at best.
We'll clarify.
Thank you.
All right, thank you.
It is now 11, it's 12.
Yes.
You want to take a break?
Yes.
5-minute break. 5-minute break. 5 minutes.
Okay, take a 5-minute break, please.
12:05. Everyone has to stand. Everyone.
Mr. Black, whoever, sit.
Or whoever.
Sorry, don't mean to be rude. Yes, I That's my Brooklyn way. Okay, we're back on the record. Special order calendar, continued hearings, item number 10, 13204BZ, 310 East Caston Street, Manhattan. Here, raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board, and to respond honestly to board member questions?
Yes,
I do. Okay. You can come back and sign, whatever.
Good afternoon, Eugene Pillman for the applicant. We apologize for the confusion regarding the plant sets. We actually have provided an exhibit that we believe will be helpful in reviewing the instant matter, so if you could please pass these up. Pass this down. This as well. What you have there is a chart summarizing all 4 sets of plans that are being reviewed pursuant to this application. You have the original 2004 grant, the 2006 DOB approved plans, which led to the certificate of occupancy, the 2014 letter of substantial compliance, as well as the proposed plans. We have Andrew Stewart of High Point Engineering, who will discuss how the floor area calculations came out the way they did, and we hope to clarify any confusion regarding the lot areas and floor areas of the building. And the second exhibit that you have are photos of the bridge area, which we will discuss as well, and why we believe it's not counted as floor area. Prior to digging into the architectural questions about floor area, which Mr. Stewart will address, I'd like to clarify some of the other comments on the record. In particular, there was a comment about the scope of the application and what we are seeking to do. So we are seeking to permit a future transfer and to permit a future merger of the premises, lots 7503 and 40, with contiguous lots located on block 384. There was a deal for a specific transfer in place for lot 21 in 2018, but as this application was not resolved in 2018, that deal fell through, so as such, we are seeking to permit future mergers as we do not have a current deal in place for the transfer.
Maybe it's a question for you. I don't know whether any of our Bella Vista cases are prospective lot mergers.
Right, and we anticipated this question, and we did found a case. It's calendar number 17404BZ, which permitted essentially, which the resolution was reopened and amended to essentially the language that we are seeking now to permit transfers to contiguous lots on the subject tax block.
Can you tell me, did you cite that again?
Certainly, it's 174-04BZ. It was an application from 2014, which permitted basically an open-ended future transfer of development rights.
Say that again?
Yeah, that's what he said.
It's
not what?
Never mind.
He said it was an amendment.
174-04BZ, and I have the resolution right here as well. But we'll be happy to elaborate on that in our writings for the board.
Thank you.
There was another comment about using the lot area,
Wait, is that 124 West 24th Street?
124 West 24th Street, yes. There was another question about utilizing the entire lot area of 7,901 square feet throughout, and we do indicate the proposed lot area is smaller than the existing lot area, but as the chair mentioned, since it's going to be one zoning lot, we will revise that to reflect 7,901 square feet throughout. This doesn't affect the calculations, especially with the amount of excess floor area available, and the total excess floor area is 11,487 square feet. So the total lot area is 11,487.4 square feet.
Well, available transferable floor area, I think.
No.
Excess floor area.
The lot area is 7,000.
901 square feet, as per the 2004 Monroe survey.
And area available.
There was one more question besides the floor area. It was, when was the second floor penthouse added? And it's actually shown on Exhibit 28, DOB approved plans on sheet A-5.0, page 9 of 34. So the second story duplex was approved by Department of Buildings during the 2006.
Maybe we don't have that page.
It was submitted with the original, with the first notice of comments, and it's sheet 9 of 34 of that PDF.
Because I looked at the original DOB plans, I'm not 100% sure that we have a page that shows the second floor of the penthouse.
132.
Previously, no.
I have a hard copy as well, if the chair would like to examine it.
Yeah, please. Plan. So these are the plans from 2000, that were approved 2006?
With the job number associated with the BSA variance and certificate of occupancy, yes.
Job number, I don't find the job number. Yeah, it's stamped, but I don't actually find the DOB job number on here.
It should be on the cover page probably. Maybe it's, the print copy on the smaller pages might not be sufficient.
Oh, wait, and then maybe it's 103-673-473, is that the job number?
103-673-473 is the job number on the original BSA grant as well.
All right, so we're looking at the 7th floor plan. Yeah, it does show the penthouse. So that's a DOB. So this is the part that's confusing. In your papers everywhere, you say a lot of things that were not approved by the BSA were not built. You say nothing was built.
The 8th floor duplex was built, but, the community facility was never converted to residential, and there were certain interior changes that were never made pursuant to the 2014 letter of substantial compliance, but Mr. Stewart will elaborate more on the building's existing condition.
So, because that's what's very confusing about your statement of facts. There's a statement that says, though we received in 2006 or whatever an approval for these changes and admit that we didn't come back to BSA to show the changes, none of that work was done. And that's one of the reasons this is such a confusing application needlessly. It's only a Bella Vista case, right? And we've been back and forth because your submission tells us nothing was built, and then we learn kind of by accident that the penthouse was built. And there's an inconsistency. I mean, the total floor area between this last submission and the prior submission have changed.
I believe a lot of it relates to the prior applicant, and the prior plans. We believe that the floor area calculations on them.
What do you mean the prior applicant?
The prior architect, the prior architect that provided the plans, we believe that some of their calculations were incorrect, as Mr. Stewart will elaborate on later. But as for construction, we believe that all work on the building was done during the original construction process. So it was,
Do you have anything to substantiate, you know?
yeah.
So what we need is something we can rely on, and,
Plans are in the folder, it's a December 2017 submission.
Yeah,
2017, and you
Yeah.
found the penthouse?
yeah,
Yeah, DOB approved plans.
December 14th.
Yeah.
So-
Yeah, it's 2017.
Yeah. It's in my hearing folder.
Okay. Continue, sorry, Commissioner Shabeta, finish your sentence.
I would like to have something concrete that perhaps the architect going there and reviewing it and confirming and swearing that, certifying that this is the current state of the building.
Well, I have a little more difficulty with it because the last set of drawings that we received indicated there was an increase in the amount of commercial floor area. That was the subject of the variance. You don't have the right to commercial floor area under current or prior zoning. So how was that increased without coming back to the board for an amendment? That's quite confusing. And for the architect to say, oh, it's a miscalculation and it should have been this, zoning floor area is zoning floor area, you measure to the outside of the building.
So, right, so the commercial floor area, original BSA grant was a use variance. The conditions did not specify a build, but the floor area of 3,882 square feet, I believe, was noted on the BSA approved plans. Currently, the commercial floor area is 4,200 square feet, approximately a 10% increase.
But
So we would be happy to address whether the financials would be altered in any way by the additional 400 square feet, if that affected the original BSA grant. We could go back and reevaluate that if the BSA would like us to.
Well, would like you to, you're amending the variance. I'm very confused about this approach, right?
I'm sorry, I didn't mean to interrupt you, Chair. So the letter of substantial compliance speaks to some increases of floor area from 2014. Is that what you're?
No, so they said none of that floor area was built.
Right.
So they essentially abandoned the the letter of substantial compliance, right? So, and by the way, letters of substantial compliance arguably shouldn't allow increases in floor area unless it's not the subject of the arguably. It could be something that's allowed as of right. Commercial floor area was not allowed as of right. That was the subject of the variance. So,
Well, the building was overbuilt. We admit that, we acknowledge that, the building was overbuilt during original construction, and here we are. We believe that the latest plan set, noting the total floor areas, is a correct representation of what it is, and I'll have Mr. Stewart speak on it shortly. But the building was overbuilt, so as such, we would have to essentially seek an amendment as well to permit the increase in commercial floor area to 4,200.
this was an application to be permitted to transfer floor area. That's all, right? So now you're amending it.
But the building was overbuilt, yes.
You're amending it to request an increase. Yeah, you're amending the application, completely different application now. You're amending the application to request an increase in the floor area of, never mind what's allowed as of right for residential because you got upzoned. It's an increase in the grant,
Right.
right?
I don't believe it creates a windfall, and we don't have the financial consultant with us, but
You didn't submit an application requesting an enlargement of the variance.
we were not aware that the commercial floor area is overbuilt until the latest submission, when based on the previous hearing of the board, we went back and recalculated the entire floor area. So we were not aware of the increase in commercial floor area until about a month ago, based on the recalculation, and this is a good segue to Mr. Stewart to explain the floor areas.
Hello again. So speaking to the plans that were prepared by our company, High Point.
Just your name for the record.
Oh, I apologize. Andrew Stewart, High Point Engineering. We looked at the old plans. And we went back for our set of plans, the latest that you see before you, checked all the dimensions and calculated everything in a computer-aided drafting program to be as accurate as possible, and came out with the square footage and floor areas that you see before you now. From what we could tell of review of past documents, there seems to have been errors either in internal dimensions of areas, and therefore that's where the lesser floor area from previous submissions came about. But the current set is accurate as per a computer-aided drafting calculated area program.
As per computer-aided drafting. What about?
Well, no, we went back and checked all the layout of the building. The footprint of the lot area stayed the same. It seemed to be internal calculations, errors in distance or dimensions in past plans. So we went back and confirmed everything, input those into AutoCAD, and AutoCAD gives you an accurate floor area. It's a computer. It gives you, it's...
When you say went back, you're just saying to the plans or to the site as well?
We checked at the site to confirm all dimensions, layout.
So here's my question. This is a full lot coverage building. The lot is only as big as the lot is, right?
Understood.
How could the dimensions have changed as to the full lot coverage? It was full lot coverage.
There were errors in internal dimensioning of spaces. There are some areas that aren't calculated, I think, into a floor area overall, unused space, not non-residential community spaces. And because of those internal dimensioning errors, came up with a smaller floor area in past submissions than what is actually there now, as represented by the current plans.
So here's the thing. It's one, if the commercial floor area changed, you would be able to tell whether it changed because, say, the staircase became smaller, or the lobby became smaller, or something like that. It's a full lot coverage building. So did on these 2006 approved drawings, and I don't know whether their floor area calculations match, I think. No, they match with respect to the commercial floor area, the BSA approval.
Correct.
Right? So unless you're saying that's a misrepresentation on the plans.
The prior plans, I wouldn't say it's a misrepresentation, more so of error in dimensioning and calculations. Plans from the original 2004 BSA grant going forward with the same architect, Marin Architects, just promulgated those errors in their calculations going forward. It was never corrected in the original plans, and therefore the errors continued across time.
So we're going to need an application to amend.
To further amend.
To further amend, but...
But it's a material amendment, right? So this is an amendment to increase the amount of floor area devoted to commercial use in a district where commercial use is not permitted.
And just like previously, we will go back to 2004, analyze all the figures, analyze the rent rolls for the commercial space, and make an argument that the change would not affect that an increase in 400 square feet in commercial floor area would not affect the BSA's original grant as required by Bella Vista. So we will go back.
No, that's not a Bella Vista.
That's a different one.
This is an amendment?
There's still a minimum variance necessary, right?
Okay.
Right. I want to just check with Commissioner Otley Brown that we're using 2004 numbers when you're looking at an enlargement of the commercial use today.
Yeah, you'll go back to the original grant, but strangely enough, if you look at those original approved plans, it says there's 4,024 square feet of retail, not 3,882, which means the jump to today is much smaller. Of the 4,200, it then goes down to like 175 square feet.
So what you're saying is,
if you're going back to the original plans, as I'm reading them, the original BSA approved plans, the retail area is 4,024 square feet. And if that's the case, then the jump to today to 4,210 is smaller. It's not 400, it's like less than half.
Is it still smaller if that space wasn't constructed?
It would be a couple of 100 feet instead of 400 feet, right?
Right,
The increase.
if you're going back to 2004. Then what happened was they went and they made their changes and went to DOB, and then got the letter of substantial compliance, and that lowered the amount of retail
Right.
floor area, which then makes the jump larger. So the question is, at what do we go back to? I think if we're talking about 7221, we have to go back to 2004.
Yes.
I agree with that. I believe that if the calculations.
Even though the increase is smaller then.
Right.
So we will go back and amend the application, and there was one last comment about the bridge area. Whether it's counted as floor area, so section 1210 of the zoning resolution specifically exempts bridges that are not enclosed, and they consider a parapet wall of a height less than 3 feet 8 inches not to constitute an enclosure. As such, based on the 2006 plans, the height of the parapet wall is 3 feet 6 inches, as you could see in photograph number 2. As you can see in the second photograph that I passed up recently. So if this parapet wall is less than 3 feet 8 inches, then this would not count as floor area.
Well, what about the wall behind you? It's enclosed on 3 sides. It's a full height wall behind you on 3 sides.
So the way that the section is written, if you just give me one moment. It states floor space in open or roofed bridges, breezeways or porches, does not count, provided that the parapet, so enclosing it, is not higher than 3 feet 8 inches.
Parapets, 4 sides of a structure, parapets, none of which are more than 3 feet high, 3 feet, whatever you said, 6 inches. Right?
We'll discuss that in greater detail in writing then, as a response to the floor area.
But I've been talking about this since the first hearing, right? And the responses have not been satisfactory, and I don't know how you get out of the fact that it's enclosed on 3 sides with a roof. At the very least, underneath the roof is floor area. The only thing you're missing is the 4th wall. And if this was a balcony, this would definitely count as floor area on a balcony. So,
We'll discuss that in writing then, because we have to re-examine that and potentially consult DOB, potentially seek a ZRD1 on that issue.
anything else?
That,
All right. So again, you need to clarify. So today you said the building was definitely overbuilt, right? Well, that wasn't clear in any of the submissions, in fact, until your statement today.
yeah,
right?
and we do apologize for the confusion.
Yeah.
Our last cover letter indicated that it was overbuilt, but it should have perhaps been brought to the forefront of the cover letter. Not
Right,
very.
so I think I asked at 2 hearings ago for a drawing that shows the difference between the BSA grant and the existing conditions. Still don't have that. That way, we could easily understand whether there's more of an amendment that's necessary, because you're just telling us now that the commercial floor area is greater.
Well, as
We
Mr.
don't know
Stewart
how.
noted, the dimensions of the building are the same as the original grant.
Hence
However,
the confusion, if it's a full lot coverage building, why is this building bigger than what was granted?
due to its irregular shape, there was an error in calculations. That's our position.
Okay, so again, show us what's changed between the BSA grant in 2004, all of it, and what the existing conditions are. So the architect did a survey of the site, and there must be existing conditions drawings. Show us the difference so that we capture all the amendments.
Understood.
Okay. Some of them, in the end, don't matter so much because it's now an upzone residential district, but nonetheless, the approval should reflect what's accurate.
Understood. We will address that thoroughly.
Okay. All right, are there any speakers on this? What? Do you want to clarify? Any other comments?
Yeah, Commissioner, Vice Chair just pointed out a difference between the zoning analysis form on the BSA-approved plans and the plans that show a difference of another, 30 square feet, which is yet another difference, where the zoning analysis form has 3,990.
That's why I asked. Sorry, I need to hear her finish her sentence so we know what she's saying.
Where the zoning analysis form says 3,992 square feet, but the plans say 4,024 square feet.
This is on the BSA-approved plans?
The original ones from 2004. So it just seems like there are inconsistencies all the way around.
Do you have the resolution available?
Right, the resolution says 3,992 square foot of commercial space on the ground floor.
3,992
square foot of commercial use on the ground floor, community facility space of 5,558 square feet at the second floor, and residential space of 22,490 square feet.
Okay, thank you.
That's in the BSA resolution. 22,490 square feet.
90.
Yes, 490. Okay. And as per the BSA approved plan, which also has the zoning sheet attached to it, the proposed floor area for residential is 22,490, matches. Community facility, 5,558 square feet, matches. Commercial floor area is 3,992 square feet, which matches the resolution.
Yeah.
However, in the floor plan drawings,
So this, what you just read was the calculation sheet?
the zoning sheet.
Yeah, it's it.
Sorry. Okay. Yeah. Whereas I guess the floor plan is not.
Right.
Okay.
Oh, but the floor plans is just looking at the floor area inside of the space.
Right.
So it
why
may
would
not
you
be
want-
taken, because sometimes that's, the
Right, but it's
mysteries of
actually
calculating.
higher. It's
Yeah, it
actually
should-
higher
it's
than
usually
what's on
higher.
Some,
It's higher than what's on the zoning analysis
Yeah.
form. So it looks to me like it just was never checked properly. Because like you said, in a full lot coverage building, where's the extra square footage coming from? And when you look at the other spaces on that first floor, those measurements of the other spaces don't change. The 275 square foot corridor is the same across the board. The 1,169 square foot lobby area stays the same. The 118 square foot lobby area stays the same. So what are they grabbing that wasn't floor area that's now all of a sudden floor area that's...
so in other words, it was built to the plan and not to the resolution, the commercial space.
Right, or
Maybe.
there's some maybe gross measurements of the envelope of the building that changed.
And so, and part of this is, there was a survey that we're relying on. This is the other part that's quite confusing. We're relying on a 2004 survey by Montrose to tell us that the lot is 7,901 square feet, right?
Yes.
So the idea that the measurements of the triangle or the trapezoid were modified and incorrectly calculated is extremely confusing, because it also needs to tie back into the Montrose survey, because we're relying on that 2004 survey as an accurate representation of the size of the lot. So the extent to which Mr. Stewart's team measured the site and came up, because remember, we were talking about before the ever-shifting dimensions on this
Yes.
site, and I wanted to rely on one survey at the time of the grant, which was the Montrose 2004.
And it's the more conservative survey. The 2014 surveys showed a greater lot area, so
Correct.
we went with the more conservative
Yes,
estimate.
but so if your building, when you look at your floor plate analysis, is bigger than your lot, this is confusing, because the Montrose survey on which we rely says you've got to pack all of this floor area into 7,901 square feet of zoning lot, and subtract from it where you cut off for your new lot 40, right?
So, Mr. Stewart, you need to coordinate your field measurements to that survey. And I appreciate CAD does these amazing square footage calculations,
Yes.
but it also makes stuff up as it goes along. It doesn't know, right? It's not a survey.
It's not a survey, no, but it is modeled after the survey. And let me just clarify that the lot area that you're speaking of, the 7901 from the Montrose survey, that stays the same between the survey and our plans. The variation in floor area calculations comes across the 7 floors of the building, and errors in dimensions or calculations on the previous plans on those floors. So the lot area stays the same. It's the floor area across the multiple floors of the building that create the inconsistency.
Okay, but when you add up, and this is, CAD never does addition. When you add up all of your areas,
Yes.
they can't exceed, well, obviously it can't exceed 7901, but it's got to be 7901 minus 400, however many feet, lot 40 is.
Well, understood, but the floor areas for each floor of the building don't necessarily equal 7901 as you go up on each floor. It's just
Understood, but we're starting off with talking about the ground floor, which is a full lot coverage.
Right.
Except for lot 40, right? We know how big lot 40 is, the surveyor told you.
Right.
Right? So your floor area, and when we measure zoning, it's to the outside of the building, right?
Yes.
Your floor area has to not exceed the 7901 minus the area of lot 40.
Right.
So please check that when you add up all of your uses, you're still correct.
Yeah, I mean, from what I said, from what we calculated in the current plan set, it is accurate. We will go back and check it once again, but I'm sure it will come out to correct numbers.
Okay. Because we have had examples where the building exceeded the size of the site, and that
Which of course
wasn't a
doesn't make
possibility.
sense, right?
Okay,
Right.
right.
You asked for speakers.
Yes,
Great.
I asked for speakers, all right, so
How much
what do we
time?
need?
How much time do you need?
We need some time. We will likely pursue a ZRD1, so maybe 6 to 8 weeks to submit.
Months to submit, February, March, April. Okay, could you submit April 3rd? Is that reasonable amount? of
Yes.
Time? Okay, so next hearing will be April 23rd, submission date of April 3rd.
Thank you.
Thank you.
Item number 11, 141, Eugene, you still have to sign in. Item number 11, 14106BZ, 2084 60th Street, Brooklyn.
Sandy submitted.
Do you affirm that you're the only one speaking?
I think I'm the only one speaking right now.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to the board member questions?
I do.
She took out the door.
Okay.
There was also a mirror.
All right.
You can store trash in a meter. Storing trash in a meter.
Oh, she submitted.
Oh, it was a separate. Took it out. Submit April 7th.
And then,
Party favor for you.
and then, is that sign there?
Thank you.
Thank you. Oh, wow. 4,200 page.
Hello, Eric Palatnik. Give your mind a rest on the complicated zoning matters and come to one I think that's mentally a little bit easier to understand. We've handed up to you, we attended your review session yesterday, and we've handed up to you an affidavit that's written, signed by Goldie Schick, who is the wife of the rabbi. And she speaks to the location of their, you had the questions yesterday about the location of their services, and are they really there? So we put together this package for you, the affidavit, that tells you that they are in fact currently praying at 1917 East 61st Street. We give you a copy of the lease that they've entered into for 1917 East 61st Street. We give you some pictures of some people praying at 1917 East 61st Street. and we give you copies of the rent checks for 1917 East 61st Street. So,
Palatnik, you're saying
Yes.
East 61st?
oh, sorry, I keep saying East, 1917 61st, I apologize. I don't know why, but
This says
1917 61st Street,
1971.
1917 61st Street. Did I say something different?
wait a minute, I'm
kept saying
sorry.
East 61st.
I didn't mean to.
The premises logo, I see.
1917, 64.
Yeah, I'm sorry, I said East, 1917 61st Street.
It says 71, so that's where the.
What's
No, it says
17?
57th Street and 54th Street. What are those things?
Yeah, well, I think those are the addresses of the participants in this lease. But man, I think maybe this is what your question is, because it certainly is mine. The owner, what address is that on 57th Street? 1724 57th Street?
I'm not familiar with, I assume that's where they were registered to, or where their place of business is. I could ask them while you're speaking, while we're testifying, what 1724 57th Street is. It's, Ms. Schick is telling me that is their place of residence.
And so what about 1737 54th Street?
I believe that is probably the place of business of the landlord. I'm not familiar with the landlord, but I'd imagine that's referencing their address. So you've got the owner or the landlord above, and then you've got the lessee below, or the tenant.
Okay.
Sorry for confusing everybody with East
No, no.
61st Street there. Okay, and then I think you had the fire department made comments, and we've given you plans that showed you the scuttle at the rooftop.
Well, wait, before you do that, so let's just finish with, what we're trying to do is establish the existence of the congregation. So what you're saying is, it exists at the 61st Street location currently.
Yes, correct.
And you're representing, but you don't know because you didn't take this photograph. Is the person who took the photograph?
Is the person who took the photograph in the room? I don't know if anybody here who actually took the photograph? No, but there are people here, I'm sure, who could attest to that photograph as being the location of where they pray if you wanted to.
If you're a fact witness, you can attest to the veracity.
Who's familiar with the photograph? Come on up if you're familiar. You're the next
You
contestant.
need to be sworn in.
Are we talking about the photographs of this lease or the?
You need to be sworn in to attest to the fact that the prayer that's going on is actually, so it's a double swear.
Swearing at 61st Street. Can you come to?
Come on up, you have to walk up by Miss Matias there.
Please raise your right hand. Do you affirm, no, raise your right hand, please, sir. Do you affirm to tell the truth,
Raise
the
your
whole
right
truth?
hand, please. Actually, show it raised.
It's raised.
Thank you.
Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, to respond honestly to board member questions? Thank you. Please sign your name. Thank you, sir.
By the way, it's Eric Palatnik. Before he speaks, you could actually see in the first photograph that the rabbi that's in the back is photographed. But the question is this the space at 61st Street that we were just speaking about? If you could say your name.
Shmili Sheikh, I'm a son of the rabbi, and I'm actually also the Gabba of the Shield. So every Shabbos I call out the people for the Torah.
So about how many people come to the ceremonies that are held in this location?
It varies because there's, obviously in Saturday we have they daven 3 times. So every time there's different people, the same people.
Approximately.
Approximately around 50, 60
50, 60,
individuals, not each time, but
Each time.
approximately.
50, 60 each time.
Could be 30 as well. It depends. The
30 to
weather.
60. 30 to 60 each
Depends on the weather. It depends if people go to other congregations or they come to this congregation. There's
Okay, so let's try it this way. How many would be the maximum at one time? Would you say that's your 50 to 60 number?
in the high holidays it could be more.
Okay,
That's
but
it.
regularly 50 to 60, and when you say high holidays, how much would you expect then?
As of the moment,
At
at this moment, it can be, I never counted each seat, but there's certain times of davening that there is no seats
How
available.
many people could fit in the space?
I never counted exactly. In this space, I would say, I never counted, so I'm not gonna say something, just a
Would you
number.
say around 70 people?
at the max.
At the max, okay. Now, you said earlier, you stated that you don't want to double count. Sometimes people will go to 2 services as opposed to 1.
Correct.
Counting everyone that goes in, not double counting, so all 3 services included, but not double counting any one person. How many people would you say entered and exited?
I never count people.
I know, I'm just
But I
asking.
can say we have 50, 60 people is a decent number to say, individuals.
Individuals
Should be-
throughout the whole day?
Yeah.
Okay, thank you.
I know. I know. Oh, okay. I know.
They own it. Okay.
Eric Palatnik.
Okay. Wait, I wasn't done actually asking.
Oh, wait, there were some more questions about the photographs.
One more photograph.
Mr.
Yeah.
Schick, could you please come back up? Thank you.
Can you tell us where that photograph was taken?
Also in the Shield, 1917, 61st.
Can you tell us why he's dressed like a cowboy, too?
So this is Purim, and everybody gets dressed as,
Okay. So this is a day when a lot of children came. Can you say how many were there that day?
again, I don't count people.
Yeah,
But
okay.
there's certain times that it's on the max, that there's no seats available. And that's why we need to expand and have a bigger facility to make sure that everybody should have a chair and where to sit.
Okay. And then one other question. I can't see who the signator is, but there's a bunch of checks here that are from the congregation. And the checks are, I don't know, who is Ohel Shmuel?
That's the
landlord?
The landlord for the,
Okay, so the checks are for less money than the lease. Can you explain that?
I'm not financial, so.
You're not in
Goldie Schick could come up and speak if you would like for her to speak. From what I understand, they've made an arrangement because they don't have enough money to pay them, that the rabbi is signing over his Social Security checks directly to the congregation. And maybe Ms. Schick, if you would like, she could speak to that because I'm speaking to the information that she has given me. But that's where the difference is in the payments. Goldie, you have to be sworn in.
The only question I
Raise your right hand. Are you speaking?
Okay.
Speaking also?
have a question to the format.
Okay, all right, thank you.
Okay.
Did you want to
Raise
ask?
your-
All right.
I'll answer your question while you're waiting.
It's just.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your
I'm sorry,
testimony
Ms.
before this board and respond honestly to board member questions?
Just want to make sure your comments were heard over.
I'm sorry.
Go ahead. Say it
So
again.
it's just a concern, it's clear that the format of page 1 and 2 of the lease are the same, but page 3 is different from font to the format in itself. Can you explain?
No, I didn't create the lease. I can imagine it's just probably sloppy draftsmanship, and the boilerplate lease is probably the best I could chalk up to on it.
Okay.
They are paying rent. They're there all the time. You have people here telling you, them showing you rent checks. So it's just a matter of, in the world of synagogues, I think if there's a free synagogue available to rent, I think there's a limited number of people who could rent it. So they make a deal, they shake hands, and they swap money.
Thank you.
Thank you.
Would you like to hear Ms. Schick? Nope,
No,
they don't need to hear you
Thank
speak.
you very much.
Just
Okay,
Goldie.
then please come up and speak and state your name.
Yeah, I'm Goldie Schick. I just want to clarify, the check, the Social Security check does not go directly to them. The Rebbe signs it and gives it to them. So that's a difference. He doesn't.
Right.
You know what I'm saying?
Yeah,
It's not like-
the
yeah.
check goes to
Yes,
him,
right.
and then he signs it over to them.
Right, yeah.
Right, okay.
Goldie.
Thank you.
Well,
Gentlemen.
Please, sir.
I will have you removed, both of you.
Okay, all right. Anything else? Did we have other?
The fire department
Fire
scuttle,
department, yeah.
which we showed on the plans. I think the fire department is satisfied. They're not here. I don't, yeah.
Yeah, fire department's here.
Up, he's in the back. I'm sorry. He's shaking his head and gave me thumbs up, which I think is, I'll let him speak because I don't want to misrepresent his thumbs up.
John Daly, Fire Department. I apologize for not submitting an updated letter. I did review the plans that were submitted January 15th. They do show the scuttle, the ladder to the roof, and the notes that the building will be fully sprinklered and have a fire department connection. The fire department has no objection.
Okay, thank you very much. Okay. All right then, I don't think we had any other comments on this side, right? So then I'd like to hear from community members, if there are people who would like to speak.
You could just
Please
line
come
up.
up.
Come up, 3 minutes.
If anyone would like to speak, you can come up and start signing in so we can keep the hearing
so
moving.
keep this
please.
going.
Thank you.
Relax, relax. Deep breath. Deep breath, deep breath, deep breath. Deep breath. Take a deep breath. Take a deep breath. Go ahead, sign.
Natalie DiNicola, on behalf of Neighbors for the Preservation and Development of Brooklyn Southwest Incorporated. First, I'd like to thank the board. We came in, we saw the file folder, and we would like to thank all the members of the board for the 6-foot privacy fence surrounding the balcony. Our neighbors group held a meeting, and we reviewed the submission by Mr. Platnick. It included a letter from an accountant on behalf of the congregation to Philo LaDavid with documentation that proves that they are a tax-exempt organization. The documents do not prove that they are a religious corporation. Furthermore, the accountant states in his letter, and I quote, "The articles of incorporation will be presented upon request."
Thank you.
If indeed they have them, why not just present them to the board as requested? It would have answered your questions and ours as to whether they are a formed religious corporation. At the last hearing, Mr. Platnick said that the congregation was renting space out of a one-family home located at 1917 61st Street. Several community members observed over the past several Friday and Saturday evenings from 4 to 7 p.m. They observed that from 6:30 to 7 p.m., only 24 members, including 3 young children, came out of the building, and then Mr. Schick came out last. Our community stands firm in our belief that they do not have the membership that Mr. Schick told the board, 100 men and 100 women. Finally, we are requesting that the board postpone any decision on a variance until the applicant and Mr. Platnick can submit legal and satisfactory documentation to your board that the congregation to Philo LaDavid is a religious corporation and that David Schick is the rabbi of that congregation. If they can prove this to your board, and then the board grants them this variance, we request that the board make certain that all the revised conditions on the board resolution be included on the certificate of occupancy, just as they did on the original resolution from 2007. We will request that the DOB commissioner have a compliance inspection done before any certificate of occupancy is issued. Thank you.
I just do have one question. What is it that you want to include in the board resolution? I didn't quite understand what that was.
I have the original resolution with me, but all the conditions that are listed, that are usually listed,
Yeah.
I want to make sure that all of the new conditions, the new revisions that have been taken place through these hearings appear on the DOB website as a condition for the certificate of occupancy?
Okay, it won't, that's the thing, it won't show up on the DOB website, it shows up on our resolution, which is available on our website, but DOB doesn't have a method for mounting those conditions. Instead, it should show up on their C of O when they eventually.
Really? Because they did, the original resolution did appear on the DOB website
Really?
as a condition.
The plan
Yes,
that's in there sometimes adds them as required items.
Okay, so this is the, okay. So, you know, when you go on the Department, you probably know because I know you've been at this a long
Right.
time. On the Department of Buildings website, there's a required items list when you're looking to see how much more before permitting and C of O and so on.
Right.
And sometimes, as council mentioned, the DOB will add those kinds of things to the required items, but we're not in control of them doing
Okay.
that. So that's the problem. It's very erratic.
Okay,
Okay.
thank you.
Next speaker?
I'm sorry, I
I'm
just
sorry.
have one. Can you tell me the dates that this was observed, that the numbers were observed?
Every weekend since the last
So every
hearing.
weekend since the last hearing?
Every
only
weekend.
24 people?
Yes, during those certain times. It was just done on Friday evenings and Saturday evenings.
Okay. Thank you.
Thank you.
Next speaker?
My name is Joseph Oliva. I lived in this neighborhood for the last 88 years. And what happened over here should have never happened. The other day I was looking through my papers and I found this here, 2008, a letter written to Commissioner Ferriello of the building department. It said, "I've been contacted by the members of the constituents regarding the waiver of the required parking determination of the above premises." That's 8024 60th Street. The constituents who represent the community association are concerned about the increase in the occupancy of the people from 100 to 200. And this is completely different from what they originally said. I understand that the waiver of 8 cars, parking permits or places, should be upon the occupancy of 100 people. Now there are over 200 people on the premises that they claim. So the member that wrote this letter was an assemblyman to the commissioner, and the commissioner told him exactly what happened. First they said I have 100 members, then there's 200 members. So the parking is completely different. The funny part of the whole thing over here is the conception of what they say and do is completely what originally was. They had submitted 7 different plans, drawings of this building. The last one was submitted that the rabbi is going to live in the residence. He's going to take over the 3rd floor. So it becomes a residential area, a house. This wasn't originally said. At the BSA's first meeting, a member of the community board states that the rabbis don't live in the synagogue. So if that's true, and they're changing this now to a residential area, I think the community would be very happy for that to happen. That to make it into a community house again, the way it was, and let David Chick and Goldie Chick live happily ever after in their house, which will become a residential area. They say it's one thing and do say it's another thing, change the plans 9 times or 7 times they changed the drawings. It doesn't make sense. It doesn't make sense. None of it makes sense, and it shouldn't be. I seen a man come up here, wouldn't even raise his hand, to tell the truth. It's not the first time. Another person did it the last meeting, won't raise his right hand. Why? Doesn't make sense, and it's a shame.
Thank you.
Thank you.
Next speaker, please?
Any other speakers
Anyone?
on this?
Anyone else?
Great. Okay.
Hi, Eric Palatnik.
Okay, I just want to try to explain to the community, this is quite difficult for us because we try to verify that these religious institutions are, when it's called into question, are indeed operating institutions. It's extremely hard for us to establish proof, right, unless they have an existing active site and they're enlarging the building, for example, or relocating from an actual active site to another one. And then the other problem we have, of course, is, and if you put this into context, the idea of having a rabbi's apartment in a synagogue is the same as having a rectory in a church. And we're more used to, let's say, the general public is more used to the idea that the priest lives next door or in the church, right? And so for us to say that the rabbi shouldn't be allowed to live in the synagogue is, then we have to ask why the rectory exists in the church. So we're not in a position to dissect how each religious group pursues their religion, and how the participants in, let's say, the various leaders of the congregation participate in the religious building. And hence, we're put in a position to evaluate that, and we really can't, right? So we rely on testimony from the applicant, who shows us, in this case, photographs of religious services going on in another building, who gives us representation that they have congregants in walking distance, which they did submit to the record. And so based on that, we have to rely on that because there's no way for us to otherwise dig in, right? And in terms of an official document that says it's a religious institution, the IRS issued a letter, which is in our record, that says it's an institution that complies with the foundation requirements of the Internal Revenue Code of 509A and some other codes, which I'm trying to find out what that is, but my computer is too slow. But in order to qualify for these kinds of foundations, you do have to demonstrate something to the IRS in order for them to grant you that not-for-profit status. So presumably they were able to do that with the IRS, which, as everyone knows who's experienced working on things that the IRS is concerned with, it's not always an easy task. So 509A, private foundations. So, and foundations also has the issue of being able to accept money that's tax deductible, right? So obviously this synagogue will be receiving money in order to be able to build this building, or has received in order to build the building, and probably arguably is making filings that money is a tax deductible filing to a private foundation that qualifies for that under the Internal Revenue Code. Okay.
Okay. Any outstanding issues?
I don't. So, are there outstanding issues? I'm just looking at. No. So the fire department signed off, and we have the drawings revised to show sound attenuation on all of the windows. The sound attenuation is not for the benefit of the synagogue not to hear outside, but for the neighbors not to hear sound from inside. And we asked for an amendment of the drawings to show the decorative elements that were shown on the renderings, so to make sure that those appear on the building as opposed to what we're seeing right now, which is a pretty severe structure. So that's a direction to the synagogue that it must build this project according to look like the renderings and to provide the decorative detail that makes the building look more compatible in this residential district. And by the way, looks like a house of worship that should be, for which people should be proud. So, or about which people should be proud. Okay. So I would like then, are there any other issues?
I just had a question. I was just looking at the photo. Is this a double height place, the current?
No, that's a house.
They're asking me, is the height of the existing facility double height? Is there a double height ceiling? Yes, they're telling me there's a double height ceiling.
typically houses of worship, the main worship space is a double height space. That's true of every house of worship, no matter which religion you're in. There's always the grandness of the worship hall, right? That's just.
So I guess at some point, the building was converted from a two-family to a synagogue.
Yes.
Yeah.
Yeah.
Why are we going down this line?
Right.
No.
Right.
I just want to
I mean,
put
this
it
is
in.
an extension of time to complete for a space that's not that space.
Right. It has to do, what, the real issue here was the rabbi's part, which was in addition to the prior approval.
How much time are we going to be granting? Because,
Well, no, so this is a two-part thing. One is it was an amendment to the original approval.
Right.
Right, that's a permanent amendment. And the extension of time to complete is, normally is 4 years, but we don't need that much time
I
because
just
the
wanna
building
limit-
is closed in, right?
I just want to limit that as much as possible, only because one of the major things I heard from the community was that this has been an ongoing ordeal
Yeah.
for so many years, and what I got from them the most was they want an end to this, and with all, they should certainly get that.
Okay, and having removed the elevator bulkhead, then we don't have to worry about them not doing that work because they did it, okay? All right, so I'd like to suggest a 2-year extension. That gives them time to get a C of O and to finish the work more than, I think that's enough time.
I think that should be more than sufficient.
Is everyone all right with that? Okay. So I would like to make a motion to close the hearing.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta? Commissioner Shabeta?
Aye.
And I'd like to make, so that everyone is here and can hear this, I'd like to make a motion to grant on a lot of conditions. So it's to include all of the conditions that were in the prior approval, but also to add, in case there's any, because this was these were new subjects that were brought in, that there shall be no commercial catering or banquet activities at all in the building, no commercial spa or commercial use of the mikvah. It's to be used by congregants and the congregants' guests, very limited. That's the whole idea, right? And, did I leave anything out? Oh, and that there's no use of the roof at all. The only access to the roof is through, we discussed, it's through a scuttle, that's for maintenance. Okay, so any other conditions that I left out? Okay, so based on those conditions, motion to grant.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
This application's been granted.
Thank you.
Thank you. Thank you all for coming. Appreciate the neighbors also coming.
No.
Yeah, I did. Second call. Second call, yeah. Is she? Sorry. If you see her, yeah, that'd be. No, she said that's the way it is now. Oh, okay.
Here.
There she is. Go ahead.
Okay. Second call, item number 6, 49072BZ, 4200 Baychester Avenue. You're still under oath?
Yes, Sandy Anagnostou, representing the applicant.
Okay, so you removed the second door, so,
Yes,
the site plan, the landscaping plan is therefore accurate.
yes.
I just want to caution you, you're showing trash inside of the same room as a meter room. I don't know if that's legal. I'm just warning you that you might get a violation if you do that. Just letting you know.
We may have to put the partition back, separating them, and
Right.
we can do that.
Right, in which event maybe you'll want to put the door from the inside. Again, I don't know if that's allowed either because the meter readers often want to be able to have a direct access from the sidewalk, from the outside. I don't know. Yeah, okay, just alerting you to that, okay?
Okay, we may have to add them when we get to the building department and
and send us
To make
back,
that work.
and then the buildings department might have you come back for a letter from us.
Okay,
Okay,
thank you.
thank you.
Did we
Yes,
take a
so
vote?
we take, wait a minute. So we already closed, right?
Yes.
So I'd like to make a motion to grant on those conditions that I read. Should I read?
Read them again, please.
Okay, so the conditions are, no drive-through convenience store is permitted, so no use of that window that should be blocked up anyway. That the gates are locked and controlled at all times by employees, that there be a sign added to the gate saying employee parking only, and that the lighting is shielded and not spill over onto the adjacent property. Okay, so I think that's everything. So then a motion to grant on those conditions.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
All right.
Thank you.
Thank you.
New cases, item number 12, 244, 97BZ, 15862 West 83rd Street, Manhattan. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and respond honestly to board member questions?
Good afternoon, Todd Dale for the applicant. So from review session, I understand that there were some questions.
Oh, please.
We'll see, hopefully that's a little better. Just to confirm for the board, the PCE use is all located within this building. They vacated the adjacent space, which is a separate tenant. There's no connection. There's a question about what is above the PCE. There is residential use above the PCE. This is sort of an interesting history to this building in that it was originally in the two adjacent buildings, then reduced to the single building. Subsequent to the board's grant, our most recent grant, the property owner built the residential enlargement on top of what was a two-story building. So the residential use was installed after the PCE was in place. I know there was questions about notification to neighbors. This particular site is actually, fortunately, perhaps, located in one of the community boards that requests for us to post notices.
Oh,
I have a copy I can
okay.
pass up to show. But prior to the community board meeting for this, they asked us to post, and we posted not only in the residential lobby, but on poles, street poles and fixtures around the side. The community board, voiced support for the application, and there was no testimony to the contrary at that site. I would also say, as far as any concerns about noise, I actually spoke to the project architect, and he says because of the unusual construction here, there's actually an extra buffer because there was actually a roof to the building before they put the residential there, so we're actually dealing with thicker construction, is the way he described it to me.
Much better than putting a little rubber mat on the floor.
Yes, it's like a building on a building, essentially, in some ways. To confirm the hours are the same, I just checked the website and I confirmed with Crunch that the hours are the same as the prior resolution. There was one other question, and I was a little confused about this, but maybe a question about signage information and the analysis forms. When I checked, they matched, so I'm not sure if there was a discrepancy.
That was me, hold on.
Maybe I misread or wasn't quite sure.
Pull it up. Oh, the plans say there's less square footage than the signage analysis form. Let me see.
Do? Okay, let me... It's incorrect. I thought it was 125.64 for both. 125.64.
But then on the analysis form, it adds up to 156.64.
Maybe there's a different sign analysis form? The one I have has 125.64 feet, 112 and 13, so I don't know if there's a
That's the
different.
one we're looking at. Is that what you see in the individual?
No, I see 125.64 on the analysis form is the total, and then 112.58 and 1306. Maybe there's a later one?
That's the same one. Isn't that what you
Same one. So 125.64 is the total, 112 of which is non-illuminated and 13.06 which is illuminated.
Yeah, now I'm looking to see where did I get the 156.64 from. All right, it could be my error. So,
We'll double check, I mean, but I believe it is.
On that, let's see if there's 100.
yeah, I'm just trying to find out where I got the 150.
Is it possible the previous approved plans had a different figure? I don't think that they're,
Because I have here, plans say 125.64 total, of which none is illuminated. And then I have a different total on the analysis form, but I don't see it. So it could be just me mis-adding things up.
well, I do believe it's accurate. It might just be, as I
Yeah,
said, a
it's
confusion without a
it's probably
Okay.
my mistake because I can't seem to find it, so.
All right, then. Any other issues?
Well, the only other question is, just so the board knows, I believe a review session, it said, didn't receive comments from the fire department, but they did submit a letter afterwards. Just to clarify, we reached out, the order that was included with the fire department's letter referenced those. It was described to me, I reached out to Crunch to find out what's going on, they said that they were having a signal problem, so that's why they turned off the fire alarm. While it was trying to be corrected, the inspector came in and issued the order. I don't believe any summons to court have been issued on that as of yet.
No,
If
they
no,
were,
they
would
come back to us.
Fire department did issue violations, that's what it says in its letter to us. It says, in addition, fire department summons were issued for failure to provide records and certificate of fitness for the fire alarm and sprinkler. A copy of the violations is attached to the letter that they sent to us.
Right.
The letter of approval submitted for the fire alarm system covers only the residential portion of the building. A review of our records shows the fire alarm system for the PCE space was inspected and approved. In addition to the fire suppression systems, the fire suppression systems were inspected and tested satisfactory. The department has no objection for the board to render a decision, as the Bureau of Fire Prevention will continue to inspect these premises and enforce outstanding violations. So it's on their radar. Obviously,
And
your
we
client can
understand.
expect regular.
No,
basis.
and they understand. And just to clarify, some of the violations that were issued for the place of assembly. The place of assembly has been obtained since those. Our office is actually representing Crunch for those. So that issue's been addressed. As far as the current matters, they're in the process of addressing them.
Okay, and I have a nod of agreement from Chief Daly that we're
Good.
good to go. All
Okay.
right? So then, are there any speakers on this application? No? Okay, so I'd like to make a motion to close.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
And a motion to grant on condition that fire department conditional letter of no objection is observed, is complied with.
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Thank you.
Item number 13, 15603BZ, 13535 Northern Boulevard, Queens, and item number 14, 12715BZ, 13535 Northern Boulevard, Queens. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and respond honestly to a board member question?
Yes.
Okay. You can sign when you come back.
Afternoon, Commissioners. Howard Goldman for the applicant. A couple of things follow up from the review session. First is the status of the community board. This was sent to the community board as a courtesy, as an extension. It's not a mandatory referral. And we have agreed to go visit them on February 13th, next week. They have been very supportive of this project since its inception, and we look forward to continuing to work with them on the project. So that's the status there. With respect to the fire department issue, we had a brief meeting with Chief Daly, and I think ownership understands what the fire department is looking for, and we're going to agree to it. We need to have a technical meeting with the contractor and the fire department people to make sure we provide exactly what they want, but we are willing to accept a condition of the extension that prior to demolition, fire department signs off on on this condition.
Okay, well, we'll hear from fire department.
Okay.
How they would feel about it. Okay.
And just FYI, demo is scheduled to start next month.
Oh, really?
Yeah.
So all the interior elements are being removed?
Will be completed in February, and then the demo is scheduled to start next month.
Okay. All right.
All right.
Great project, yeah. Any other questions from the board? Okay, so Chief Daly, please.
Good afternoon, John Daly, Fire Department. Regarding this application, I had an inspector visit the site, and in 2015, the Fire Department granted a variance to the previous owner to remove a non-automatic sprinkler system in Siamese connection, which was done. But in addition, they also removed the standpipe system, which was not granted. So, and currently, the condition of the water tank is the wood staves are all rotted. It could never hold water. So we requested either a wet or a dry. Now, finding out that there is no water supply to the premises, a dry pressurized, air pressurized system with an alarm system attached to it is what we are requiring before the start of demolition. Failure to provide that system, they will not get a permit from the fire department to do any torch work or any demolition operation at the site. So I did meet with the attorney and the owner's rep, and they agreed to do coordination to put in an air pressurized standpipe system.
Oh, interesting. So this is for my education. So on construction sites that are existing buildings being gut renovated that normally required a sprinkler system before they were being gutted, you require that the sprinkler system continues to operate while the gut renovation is going on?
Yes, but they can, the fire department also grants variances to remove the sprinkler system when a building is being demolished. It's the standpipe risers that we really want to keep. For example, if this was a 10-story building and they had a standpipe riser that runs through the stairs, when they start demolition on the 10th floor, we want them to cut the pipe down to the 9th floor. Always have the riser one floor below the demo floor. And they keep working downward. In this case, I know it's a one story, but it's over 70 feet in height. We'll have that riser going all the way to the top floor. And then when they start demolition work, I know we have the steel trusses, which is going to be a lot of torch operation and a lot of sparks and flames going around. The riser would go to the top floor, and then as they come down, the riser would shrink down. When they get to the lobby area, the riser would be all the way into the lobby, but they're going to stop there and not remove it anymore. These inspections will be conducted every 30 days to confirm that the risers are being maintained, that they're being taken down gradually as they're doing demolition. And of course, once they start construction, once they get above 75 feet, the risers will be replaced, put back in service and continue upward as they build upward.
Mm-hmm. Okay.
So.
Wow, didn't know this. Thank you.
Yes.
Okay. So it's okay for us to allow the extension of time to complete construction, which is what they're asking us to do, or even commence, but to complete, which is what they're asking us to do, as long as you work out something with them on the standpipe.
Right, the fire department does support their application for an extension of variance. I just wanted to make the board aware about their standpipe system. We will work with the owners and their attorney. Of course, non-compliance will result in summonses being issued, and I will request a compliance hearing before the board.
Okay, great.
Okay.
Thank you very much.
Thank you.
Right, are there any speakers on this? Other speakers? No. Please. Okay, I don't think there were any other issues, so I'd like to make a motion to close this.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
And a motion to grant on condition that the owner work with the fire department to resolve the standpipe issue.
Chair Promoter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
All right.
Thank you very much.
Both applications have been granted. Item number 15, 6108BZ, 439 86th Street, Brooklyn.
Yeah. For the height of the FAA height. Yeah.
Thank you. Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Okay.
Good afternoon, Madam Chair, Commissioners, Frederick A. Becker. We attended the review session. So a few things. One is with regard to the community board issue that was raised. So what happened at the hearing was this gentleman came to the community board and he says, I've had issues with this building since 2004 and you were there at that meeting. And I said, no, I wasn't. And he said, I remember you. And I said, we came before this board in 2008. And he said, well, I don't care. So the community board said, if there's an issue, will you take care of it? And we said, yes, we would.
So is there an issue?
No, there's a setback, which has, this building is a multi-use building. There's a setback on the second floor, which is the closest to him, and there are units there which do not belong to us, and which obviously were problematic back in 2004. We were on the roof, so there is no issue. They just said, as a courtesy, would you? And I said, yes, I would.
Okay, so the reality is that the HVAC units, whether they're noisy or not, are not the PCE's HVAC units?
No.
Okay, so there isn't anything you can do?
No.
The neighbor, if there's still problems, has to go to the building owner?
Right, and the community board is working with him, and as I said, as a courtesy, I said, if there's a problem, we'll certainly deal with it when the time comes in the spring or in the summer.
Well, you don't represent the building owner?
No,
you
I said I would work with the New York Sports Club units if there was an issue with those.
Okay, but they're not their units, so you can't, there isn't anything for you to do, is the
No.
point? Okay, all right. Okay, there was also a conditional letter of no objection from fire department here, which just says there's a problem with the public assembly unit and, public assembly permit, and that fire department will visit the site and issue violation orders, so you should alert your client that.
Right, well, we've filed for it. We can't get the PA without the C of O, and we can't get the C of O without an extension, et cetera, so we're following up on that.
But meanwhile, the fire alarm and sprinkler were tested properly.
Yes.
They're okay with that, and that's that, okay. And then I noted yesterday that the hours of operation have changed, right?
There's also an error on the signage analysis form.
Yes, so.
I thought we had corrected that. I wasn't quite sure what, it was a calculation of, we're well within, do you want to clarify for me what we did wrong?
It was just the calculation. Your total is less than your non-illuminated and illuminated total.
Okay, we can fix that and resubmit.
Can you do it now?
Well, they also need to
Oh,
apply
right.
for an extension of time to obtain a CO.
Well, that's an interesting question. I would like to,
I actually don't really want, to- if you,
the question is how, if
because we've talked for a great deal at staff.
Right,
staff
but the question is,
level.
if I apply for it, you can't grant it.
If we apply for it.
If I apply for it, you can't grant it.
It was a condition of our prior approval that you failed to comply with. I don't see how we can.
But what I'm requesting, it's not a penalty for failing to meet the condition. You're asking me to apply for a extension, and you can't grant the extension. So I'm filing for something which you're going to not grant.
I'm failing to understand how we can't grant an extension of time to obtain a C of O when we
Because
just did in two calendars ago for Mr. Dale at Rothkrug Inspector. Two calendar items.
I understand
right?
that, yes.
Extension of time to complete.
Fine, okay, we can do that, yes.
Thank you.
Okay.
Good, so we need to do that. So it takes a little bit of time to get your DOB objection?
No, it doesn't, no.
Oh, you
It's
need
just a
to have to
condition
amend.
before it's grant.
Oh,
You just
you-
need to amend the application.
No, you need to amend the application.
And pay the
so-
fee.
Right, and pay the fee, okay.
I can do that this afternoon, or it would be easier if you just put it over. I have hearings the next several weeks, and you just lay it over for next week or the week after,
Well, that
perhaps?
was my question. Can you do it today?
It's-
I mean, we asked last week, so I'm
Why
not quite
can't
sure
you-
why.
Well, I have to amend the signage chart as well,
Why can't you do that today?
because by the time I get back to the office, submit it
Fine.
back and forth. It's me running back and forth. Can we just put it over till next week?
I don't know that next week is next week's not available, but
I'll be here on the 19th, I'll be here the 12th, I'll be here the 26th, I'll be here the 5th.
No, sorry. That one.
that's 32.
No, that's
Oh,
that one.
so if you can submit by next Wednesday, we can put you on for March 5th, which you're also here for,
Yes.
okay? That would be great.
So you need an amended application requesting the waiver, you need an amended signage sheet, and you need a check, correct?
Yes, that's right.
Okay, are there any speakers on this?
Okay.
Thank you.
All right, thank you.
Thank you.
Item number 16, 8910BZ, 53 Mercer Street, Manhattan. Just you? Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and respond honestly to board member questions? Yes. Okay. Fine. Yep.
Good afternoon. My name is Eric Daniel from Kramer Levin. I'm here on behalf of the applicant, who's the owner of 53 Mercer Street in Soho. With me today is Gary Tarnoff, also from Kramer Levin, and Oren Evanhar, who's a representative of the applicant.
Okay, before you go on, I just want to correct the record. There is no requirement, as was pointed out, for service of the initial application on these extensions of time to complete construction. The reason that I asked for it is very many of our applicants just do it anyway. They're so used to submitting an application, they always just send it to everyone. And so we kind of got used to seeing that, and so it was a surprise when I didn't see it here.
Sure. And we did communicate with the community board. They said there was no need to appear and that they had no comments. The other issue raised at yesterday's review session was with respect to the addition. I just want to clarify that that's not before the board today. And if the applicant does decide to go forward, that they'll be back here before you all to seek an amendment to the variance. And the client is well
Yeah, so we
aware.
just want to alert you to the idea that you should under no circumstances allow your client to obtain a permit from DOB, which might do it by mistake, or proceed with construction until you've come to the board, because it's not at all clear that the board would view that favorably.
Understood. Also, in response to the board's comments yesterday at the review session, I do want to just point out the two primary justifications for the extension of time to complete construction. The first is that the applicant acquired the property nearly 2.5 years after the variance was initially approved.
Which was when?
The first approval was November 2010.
Right.
And the applicant acquired the property in January of 2013.
Okay. So, 5 years later.
Yeah, so the second primary justification is that the applicant entered into a lease with a tenant, Steve Madden, who's a major fashion designer. The applicant, the tenant took possession of the property, was paying rent, and under the terms of this lease, the tenant was responsible for the interior build-out of the property, while the applicant was responsible for, primarily for the exterior of the building. And the tenant's plans didn't proceed as they'd anticipated. This resulted in litigation and ultimately a 2-year delay. And so during that time, the applicant was unable to do the improvements under the approved variance. And it wasn't until December 2017 that the litigation was resolved and the applicant took possession back of the property.
So you're saying that litigation, hi, you're saying that litigation was between 2015 and 2017? Is that?
No, so they began negotiations with Steve Madden in January 2016. They entered into a 5-year lease in May 2016. And then the litigation began in February 2017 and didn't end until December of 2017. So it's for these reasons that we're asking for.
So this is the problem I'm having. So we grant a waiver for retail occupancy in the kind of M15A or B, whichever this is. And what I'm hearing is, and what I'm hearing is until the owner finds a tenant, they're not going to be able to occupy with a use that conforms to the grant.
No,
But that's hinging our approval on vacancy rates, which is not at all what we're here for. We grant a variance for the tiniest revision, right? The revision is just allow us to use it for retail space.
Yeah, I mean,
Rent it to retail space.
the applicant has been moving forward with the work, and we have interior photographs that can demonstrate that, which I'm happy to submit. There was approval from Landmarks with respect to restoration of the facade. There was quite a bit of work involved with restoration of the facade, windows, all of which is in the process of being completed. So this is not contingent on them finding a tenant.
Well, the facade is unrelated to the occupancy of the first floor.
Yeah, well, there's also been, in addition to the Landmarks work, there's been interior demolition. They've replaced interior joists. They've removed a fire escape from the front, and are moving forward with completing the rest of the work now.
So what's really going on is a gut renovation of a building, and the renovation of the upper floors is holding up the occupancy of the ground floor for the use for which the variance was granted, right?
The addition is really completely independent.
No, I'm not talking about.
Or not the addition.
Your explanation for why you still haven't, after all of these years, occupied the ground floor with retail is that work is going on elsewhere in the building, facade and joists and so on.
Well, it's joists on the ground floor, and they're proceeding with the work now. So it's independent of a tenant.
Do we have a construction schedule in the record for the site?
There's not one in the record. I'd be happy to submit one.
Maybe that would be helpful.
I think that's.
Yeah, we need that. I think we asked about that.
Can you also explain why you're asking for 4 years?
Yeah, so we'll submit a construction schedule, but the applicant does anticipate potentially being able to be done with the work by the end of this year. We're asking for a cushion to allow any unforeseen circumstances to be addressed without us having to come back before the board. We've requested 4 years at this point, but it's possible that we'd be amenable to a
Well, so if
shorter time.
there was litigation with the prior, I guess it's a prior lessee, or was that resolved so that the lessee is the same one? Is it still Steve Madden? Or now they're looking for a new tenant?
Yeah, so as soon as the litigation was over, the applicant immediately began marketing the space. There is a lease out now. It's not executed, not finalized. But that relationship between the landlord and tenant that resulted in the delay with Steve Madden is not the case in this lease. The landlord would be responsible for the interior work and completing all of that work. So that issue will not come up again.
So then, now, in terms of occupancy, are you suggesting that we have to wait till your tenant does the build-out?
No. I'm saying that was the terms of the initial lease. That was the case. The lease that's currently out does not have that structure, and the landlord would be
So the landlord is doing the build-out?
Yes.
And working right now on the
Yes.
build-out?
Yes.
Okay, so we need a construction schedule, and I think 4 years is really too much for this little tiny variance.
And explanations for why, whatever, even if you're asking for 2 years, we need explanation. The construction schedule does not provide usually explanations. It does provide activities plus duration, but we need explanation on how much work is remaining, why you're asking for whatever, 2 years, 3 years, 4 years.
Okay. All right. Any other questions here? Comments? All right. Are there any speakers on this? All right. So, construction schedule, speed, and,
Explanation, I could submit interior photographs.
interior photographs, yeah. Okay. What do we have? How soon could you give us that? We could do this. Sure, that's 21.
What's the date?
So it would be March 5th hearing with a February 13th submission, gives you a week. Is that enough time?
I think
10 days.
I think that's reasonable.
All right. Everyone got that?
Say it again?
Great, got it.
Any
Thank you, thank
speakers?
you. No, I asked already.
No, repeat it again.
February 15th?
Yeah, February 15th, okay.
13th, sorry.
February
March 5th.
13th, March.
5, okay. Item number, continued hearing item, keep going, I'm sorry. Continued hearing items, item number 17, 238-15A through 243-15A, Dunton Court, Queens.
I did. It's not there. Nothing's there.
Jeff Geary?
Want to sign? Want to sign it? Oh, okay.
To address Mr. Commissioner Shatter from our last meeting.
State your name, please.
Oh, Jeff Geary?
Good to see you.
You had asked us to provide some information regarding the flood venting and the flood venting requirements. So we've added the detail to the plans regarding stormwater discharge code sections and the typical flood vent that we are specifying for flood-prone areas in this day and age.
We saw. Right. Did you hear our comments?
I was not able to hear the comments from last night's review session.
All right, so we then have to go through them. Is Mr. Daly working with you on this case? 'Cause that's the-
Mr. Todd.
Dale, all right, working with you on this
Yes.
case?
On some
Yeah.
of the things, yes.
Yeah, okay, so let's have him address those things.
Hi, Todd Dale, for.
So at the last hearing, I
Right.
thought that you were going to be submitting some materials to try to make your case about why you thought that the road should be treated differently, but we were asking you to sort of tie it up. But in the interim, as you probably heard from yesterday's review session, we submitted to the Borough President's office what we had already from your submission, and they disagreed that the city has ownership or that it's the equivalent of a CCO or anything like that. So that takes us back to the conversation we had, which is, and even on a CCO street, we've learned that the city may or may not take responsibility for the different types of maintenance. Hence the need for the restricted deck, and hence the need for the homeowners association agreement to cover the kind of maintenance. So what we had talked about at the last hearing was you'd said, well, nobody owns the roadbed.
True.
So how can we go in? Oh,
If I could just interrupt. I'm not sure if someone has title. The property owner does not have title, so I just want to make that clear.
So then you had said, how can we put a sign up and enforce on the no parking and so on? But then I added that deeds to property always say, all right, title and interest to the center of the roadbed, just to cover it. It always says that it's as old as, as 19th century from some English court.
Sure, certain deeds, yes.
So based on that, we said, therefore, you need to have a restrictive declaration so that you do put the parking signs, which actually Mr. Fury indicates on the drawing, and that you do have the HOA enforce against the no parking, because we can't know whether DOT or the police department or anyone will enforce the no parking signs.
Right, so to backtrack a little bit, with our most recent submission, the two submissions that our office had made, we just presented that information to show that the street was, as a record street, being maintained by the city with respect to sanitation, the snow plow, and also we provided the information with the fact, there's questions, there is a water main and the sewer that are there that are actually on the DEP official record, and DEP would take responsibility for maintaining those utilities. They wouldn't be on the DEP maps otherwise. So this relates actually not for this specific application, but our office is another GCL application where this issue came up with respect to the CCO street and the maintenance. And I know in that application, there was a request to draft a type of declaration, like a notice of declaration saying that essentially that even if the city is maintaining it now, there's no guarantee in the future, and you should know that. So a comparable type declaration could be drafted for this one, but we still have the issue of, we understand the board's concern, we understand the borough president's concerns. We think that they're valid concerns. We want to make sure that somebody is maintaining this. And yet, filing a traditional restrictive declaration, there could be difficulties in the sense that if we don't have title to that, it's not a question of interest, it's a question of right.
You have
well,
all right, title, and interest to the
Well, we
road.
take a look, I haven't personally reviewed the deed for this particular property. I know the language on the deeds will change depending on there. Sometimes that language just references the fact of right of access as opposed to the right of maintenance. So I don't know the specifics for this particular one because we weren't involved to that extent yet. So we could take a look at that. If we did have that, there could be something that's drafted there. But any type of declaration we're going to need to work with, because the other thing too is, again, as I recall, we have those homes that are across the way. We would need to draft something that would be to the center line of Dunton Street just for the particular property. At this point, I'm not prepared to answer that now because we weren't really involved with that declaration point. We could be. I'll talk with Mr. Geary about it, whether our office can work with that declaration and presenting it. But we would need to come up with something that could hopefully address the board's concern, but also reflect the fact of what this property owner actually has the right or interest or ability to maintain, and any issues that come across the way because you have the property owner across the way who then would be responsible for to their center line that wouldn't be part of this restrictive declaration. So it's a little bit more involved than some of the other documents that come up. Now, the one thing I would say about the homeowners association, I know our office is involved with them. I don't personally work on them every day, but I don't think a homeowners association could work in this particular instance for what you're talking about, because there's questions about whether the state would agree to approving a homeowners association for property that you don't have title to. So that's a question that came up when we were speaking to the attorney in our office who works with the homeowners association. So I understand what you're saying, like the homeowners association, when it's clear it's a private road, it's a non-issue, you can file it. In this instance where the title ends at the tax lot line, even if there is language in there saying you have right to access or whatever the particular language is for this deed, there's questions about whether you could even get a homeowners association approved because the attorney general might say, that's not your property.
I have a question.
We can't grant that. So
There was actually a homeowners agreement, I'm not sure if it was a draft or if it's actually been executed, for Dunton called the Dunton Court Vista Homeowners Association. Does that association not exist?
The document was prepared to be filed and recorded upon direction or finalization of where the board falls in on with this application.
So the association was going to be formed based on the
Correct.
on this application it has.
The language from the beginning was evolving with our discussions back and forth in the meetings we had had. It wasn't going to be filed until it was, I don't want to say signed off, but approved that this was the language we were going to use.
So as I understand it, that was draft language.
Yeah, it was
It's not
draft.
actually, okay. So
Right. And
weren't
just to-
involved with that, so.
Right, understood. So, but I'm asking you to please be involved in it because
Okay.
this case has gone on interminably.
I understand.
Because you can't seem to get sort of basic things that you do regularly so well. So please be involved.
That's fine. And just so you know that with respect to Dunton, the other application that we're working on, this language, we're working on that. We could translate it to Dunton possibly, but as I said, it's a little bit not a little bit, it's more involved than a simple restrictive declaration. It'd be very easy if this was a private street. Since it's not a private street, there are other considerations that we have to take in effect
But if
as
we-
to what we, as I said, it's not a, if it was a question of interest, fine. But if it's a question of interest and right, then we want to make sure what we have the right to file and how we're going to handle it. And there's questions as far as, the maintenance and you stop. And I mean, not to just throw out just one hypothetical, what if there's a pothole that's half on our side and half across the street? And how do you deal with something like that? So it's not just recorded declaration.
Right, understood, but just imagine I buy one of these homes.
Sure.
Unwittingly, really, right? And then it turns out let's say, DOT wants nothing to do with the street. They stop plowing the snow. The potholes are everywhere. And I call up DOT and say, hey, what's going on? And they say, we're not responsible for the street, so who is, right? And I still have potholes. And so then I call the borough president, please fix my potholes. And the borough president says, you know what? Your own fault, go fix your potholes.
I would say, from a practical standpoint, I don't think it's realistic that DOT would stop because of all of the proof that we put in there between the sanitation, the snowplow, the fact that DEP has city utility lines under this property. So practically, no. Theoretically, sure, I understand what you're saying. But as I said, it's more than just,
They have a budget, they need to cut back. They're instructed by the future mayor not to spend so much
they
money
would
on
never
these private,
cut out
whatever
maintenance
they
of a
are.
street in Staten Island.
Yeah.
Please.
Anyway, it's a task.
I understand.
to figure
No,
out.
and so just, so we understand, and we just wanted to impress upon the board that it's not a simple cut and paste or change from other comparable applications where it's just private property.
Okay, and in the worst case scenario, whether or not the Attorney General approves whatever it is that you're consigned
Sure.
HOA specialist either, a restrictive declaration, I don't believe needs Attorney General approval.
It does not. You're correct. I just wanted we can definitely differentiate between those two. A restrictive declaration in this instance, or a notice of possible maintenance or whatever we're going to call it and how it works out. We'll work on it.
Okay, good,
The owner would have no issue with that.
good. Do you know that? You better not, because I can't keep going on with this application, not getting anywhere, right? So, and please always listen to our review sessions. That's this is directed at Mr. Geary. We have the review sessions on Monday. They're put up, the video is put online by 3 or 4 o'clock, even earlier sometimes. Listen to them, okay, please. All right, let's see. All right, that's the outstanding thing.
I just wanted to be
And I wanted
clear.
fire department also to comment on the issue of the enforceability of the no parking, but maybe we're dealing with that with a restrictive declaration. This was a question that was posed yesterday because there was a comment at the last hearing that there's nobody to enforce the no parking signs, but we're trying to get the HOA to take responsibility for enforcing the no parking signs, okay?
Okay, so the only thing we're dealing with is restrictive deck. His plans are fine.
Restrictive deck and the HOA. which
HOA,
we've been
plans and
trying
everything
to
else
get
is good.
cleared. Yeah, right. So, and I know that there were comments from council, our council, on this HOA in August.
Yep.
And they were never responded to. So there is what is that? It's not that's an HOA
No, so what was
bylaw.
included in the October submission were the bylaws of the HOA, and what I had been discussing with Mr. Geary in August was something called the Declaration of Protective Covenants, Restrictions, Easements, and Liens for Dutton Court Vista Homeowners Association. That was submitted in August 2018. Yeah, so that should be what it is, but, yeah.
Again, we're prepared to provide that. It was just whether or not how it gets provided. We were understanding.
Okay, I'm giving you a direction. I don't know who the "we" is, but it needs to be Mr. Dale, okay? When you say "we," I don't know who was doing it before, they have to stop, and you have to give that job over to Mr. Dale, because we can't do this anymore. And he has a lot of experience with working on these kinds of applications, so please tell your client he has to do the work, okay?
We are more than happy to look at this particular issue and work out
Using this?
what we need to work out.
Okay.
Okay, So,
Yeah, no, we can't close.
Nah.
It's an open issue.
Just
No.
very quick, one more thing. I'm looking at the drawings, and we've got some structural details. This is just a disclaimer issue. I don't want to, be responsible for this, but you need to talk to your engineer/architect to take a look at the details provided, especially the one on A-010. I see inconsistency between the pull-out and the drawing. In addition to that, the 10-inch poured concrete foundation will need to be looked at, engineering-wise.
Okay, and again, an engineer sees there's a problem, just points it out. It's not in our purview to review the engineering, but when you see something that's wrong, you point it out, like we do with other kinds of code violations and things like that that are not within our.
Did you say 810?
Yes, A-010.00, yes.
So we're not going to discuss it, it was just pointed out, okay?
That's fine.
Good. All right, so let's set up a time. How much time, Mr. Dale, do you need for this?
We'll definitely need some time to review our part.
Yeah.
I would throw out two options. One, is just as far as coming up with a draft declaration. If it turns out an HOA is not possible, we could do that faster. If it was feasible to do an HOA and we had to go through the state, let me ask this, two parts. If the board would be agreeable to draft HOA language, or if an HOA were feasible and we actually wanted the HOA, that's a much longer process. So I don't know, you know what I'm saying?
Yeah. So here's my question. The experts in your office who do HOA agreements.
Sure.
Some of this is based on their experience, what they could expect, as opposed to actually submitting it to the AG for a review, right? Most of the time, we don't ask that it gets submitted to the AG because we know that could be months, right?
Okay.
So these are proposals, and the extent to which the AG might require an amendment, that's one of the reasons we have the restrictive declaration, is like a belt and suspenders. Okay?
So then I would say we could be on the shorter, because then if in HOA, we could file a restrictive declaration referencing the future HOA, and then the board wouldn't have to worry about that, but it would reference the future HOA. I would say we would want, I don't know the schedule, I think we still need, because we're working on this and other cases, at least 4 weeks to submit.
Okay.
So I don't know how that
And
works.
just to
And we
clarify.
can vary a little bit.
We do want to see a draft
Sure.
of
Oh,
the
no.
HOA. It's just that we don't expect the AG to review it and approve it.
Our next submission, with which we'll be involved, will submit to the board draft language, whatever format we believe would be appropriate in this case, whether it's restrictive declaration or declaration in HOA. Okay?
Great, thank you. All right, so.
we could do March 26th or April 9th?
April 9th?
Okay, April 9th would be the next hearing, with the submission on March 20th, so that gives you more than a month.
Is there, it's March 20th submission, is there a submission date that's a week after that? I'm just thinking for my calendar.
2 weeks after, there's one April 3rd, or April 23rd.
Submit April 3rd, April 23rd? That's fine for us, okay.
Okay, so the next hearing is April 23rd, with a submission date of April 3rd.
Thank you.
Thank you.
New cases, item number 18, 2018, 47A, 45 Case Avenue, Staten Island. This application has been postponed for failure to properly notify.
Right, you know that we need to notify, this is a vesting, you need to notify the elected.
We were aware, the letter came to us, it was overlooked in our office.
So they need at least 20 days.
So we're prepared to submit tomorrow, pending the date.
20 days.
We have that wrong.
1, 2, 3, 4, 5, 7, date after February 26th.
That's a vesting application. So that might be, 3.
It's a small addition off the rear of a single-family residence.
Right, but it's vesting, so it means we're looking at the zoning that was allowed then, the amount of work that was in the ground at the time, or work that was done on the project at the time, to see whether it vested, right? Right.
We have aerial photos, the project was 100% done,
21 on March
never signed off.
19 on March 19th. 14 on March 6th.
Okay, March.
Okay. All right, so the next, the postponed hearing will be on March 26th. And you have to effectuate notice 20 days prior to that. And the submission's already,
Yeah,
there's no
submission's
submission,
in.
it's just notice, right? Okay.
Okay.
So next hearing is March 26th, or the first hearing, March 26th.
So a new notice will go out.
Yes, new notice should go out.
Keep going?
Yeah, we'll just
Thank
do
you for your
this
time.
one, and we'll take a 30-minute break.
Okay, so we're going to do just 19 and 20. Okay, zoning calendar, continued hearing items, item 19, 5602BZ, 317 Day Hill Road, Brooklyn, and item number 21-96BZ, 600 McDonald Avenue, Brooklyn. Raise your right hand, Mr. Klein. Did you forget me? Yeah, that's all right. How quickly they forget. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Good afternoon, Madam Chair, Commissioners. Stuart Klein on behalf of Klein Slowick for the respondent on both cases. I listened to both the City Planning Commission hearing last week. I believe it was on the 31st. The hearing was closed. There were a couple of questions that were asked by both Commissioner Levine and the chairwoman. I believe Adam Rothkrug responded in a letter to them in full response to those questions. I'll submit a copy of that. Sure, of course. The fire department appeared at the site during the course of one of the affairs. I believe as a result of that, they dismissed 6 of the NOVs. The one remaining is obviously the NOV for the use.
Right, so we received the fire department letter yesterday?
I didn't see, there was a letter just submitted, oh, I'm sorry.
From the fire department.
But fire department's right here, why do we have Mr. Chief Daly?
I'm just saying for the
Yeah, yeah.
record. Okay.
John Daly for the Fire Department. Mr. Klein had provided us with dates during the week of January 22nd. Our inspectors from the LPPA unit visited on January 24th. 6 of the 7 outstanding violation orders were dismissed. We have one current violation order pending, and that is to discontinue the use of a banquet hall, which was enforced. So that's where we stand right now. But the other major violations were dismissed.
Okay, that's good, okay. All right.
You also received, I believe, I apologize, I think I was a day late, submitting the architect statement as to the daily checks.
Okay. Can you give us an updated calendar of events?
Surely.
And the other?
How long a period of time going forward?
It's
As far as you currently have.
as
Okay.
far as you've been booked.
Okay.
Right? Because the next, so I'm aware, I don't know if everybody is aware, next week, city planning is going to vote on this. So according to that, then it goes to the city council. So they have, 50 days before it becomes the state of the zoning, right? At which point then, because these are compliance hearings, right? The application, the materials have to be amended to reflect the actual conditions. And then, because the zoning will now permit evening use of those spaces for Use Group 9 banquet facility, then the drawings have to be amended to show how they are, that banquet facility and how it's being used in the evening, and that it complies with zoning requirements of the new zoning. And
Well, we would be seeking a new certificate of occupancy under an Alt 1, and those would all be filed with the building department. Do you want us to file a copy with you?
Yeah, but you need to come to us first, right? This is a compliance hearing, and clearly the use is not in compliance with the terms of the prior grant. So you have to come to us first.
Fine.
Right? Okay. The DOB should kick you back here if you came to them first. Okay. All right. I don't know if there's anything else. Are there any speakers on this? The owner's representative from next door? No? Okay. I just wanted to point out to the owner's rep that city planning has been held a hearing on the rezoning of this area, to permit this use in the building, which affects actually the neighbor's property, right? Which I believe the neighbor's property is included in the.
Yes, a thin sliver of buildings, yes.
Right?
Mhm.
So,
They're currently overbuilt under the
they're
proposed code,
overbuilt, but
yes.
it now allows, not that it's necessarily relevant to that property, but this would then allow a commercial use on the ground floor.
That's correct.
So, okay. All right, so then,
Next
put it on to
hearing?
continued.
Is that, then the three, we've been doing it every 6 months.
6 months, we did 8,
No.
11, we did. But we can do.
Oh, we did 3 months.
the city
Every-
council.
Yeah, after, well, after city council, so that would be
50 plus a week.
plus
50
next week.
And maybe a little bit more to revise the drawings, and the city council wants a modification or something, which I doubt.
I doubt no, the city council member was in support of this proposal, so the
That's
drawings
about
could be
8
done
weeks.
now, right?
It's about 8 weeks.
8 weeks, okay.
So they would fall under they would just submit under these calendar numbers here? Is it-
Yeah, because
They don't have to file
compliance
an
hearing
amendments
here.
or anything? Okay.
No, they're compliance hearings to show how the building is in compliance, and we need to open this up as an amendment after. Yeah, that's what, right.
That,
Yeah, I agree. So it would need to be filed as an amendment to the existing proposal, the existing approval, and with no other amendments except for the use.
That would require submission to the community board, though, on the amendment, I would imagine.
The way it goes.
and you pay a fee.
I'm sorry, what?
Yes.
And there'd be a fee involved.
I'm sorry, would it be an A case or be a,
It'd be an SOC, because it'd be an
SOC.
amendment to a variance.
okay.
Okay.
All right, so let's,
So then the next continued hearing will be April 9th, with submission date of March 20th. And that allows for the 50-day city council.
Okay, fine, thank you very much.
Thank you.
thank you. Okay, we can actually, there's one postponement after this, and then we take a break, right?
No.
Adjournment, sorry.
Adjournment.
There's an adjournment.
Which one?
The very next case,
21 is
That's
adjourned?
Northern Boulevard, request adjournment to allow more time on a traffic study.
Oh, okay, sorry.
268.
Oh, that's right, yes, it did, I'm
Yes.
sorry. Apologize. Item number 21, 268, 14BZ, 2310610 Northern Boulevard, Queens.
Okay, is
They
there
in-
anyone here for this one?
Please,
No?
it's just-
Okay, so we could just, what'd you say?
She should be here, actually.
maybe they thought we were taking.
Called it.
I can go outside and look. Okay,
Why don't we just call this after lunch? Let's
Yeah,
let's
that's
not
okay.
put a schedule
all
together.
right, so then, taking a 30-minute break, so that's 2:40.
2:40.
240, okay.
2:40, everyone know that? Everybody bring their watch.
We're going off the
2:40.
record, Emily.
Never
don't
late. I know you're not. You were looking over there, I was looking at the end of the table.
Take it easy.
2:38.
Giving you 2 extra minutes.
Thank you.
Good afternoon, ladies and gentlemen. Back on the record, this is the Board of Standards and Appeals public hearing for February 5th, 2019. We'll continue with the continued hearing items on the zoning calendar. Item number 21, 268-14BZ, 2310610 Northern Boulevard, Queens. There's a request for adjournment.
Good afternoon, Lisa Orantia from Ackerman LLP for the applicant. We're asking for 6 weeks, so next hearing date of April 9th, if that's available, with submission on March 20.
That's fine.
Do you have DOT on this?
April 9th, submission March 20th.
Thank you.
Thank you.
April 9th? March 20th. Oh, okay. Item number 22, 11115BZ, 98 3rd Avenue, Brooklyn. So you're the only one speaking?
That's a good point.
So the team may want to get up and do it now, so we don't waste time. Gentlemen? Thank you. Raise your right hands where I can see them. As they say in the Westerns, raise them up. Raise them up. Jack. Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions? We do. Go.
Hello, good afternoon. Eric Palatnik. We attended your review session yesterday. We heard a lot about what Commissioner Sheta had to say and your comments.
And our direction.
And your direction. Okay, but, you know, the song that came into my head this morning when I was getting prepared, and since yesterday I've actually been preparing since 11:30 when you made your comments. I've been working almost nonstop. The song, There Must Be Some Misunderstanding by Phil Collins. I don't know if you know that. There must be some kind of mistake. And that's the theme of what I want to talk about right now for a second. So I want to make sure I'm understanding what you were saying yesterday. I sort of got the sense that what you were saying yesterday was that we're already, when you saw the soil, what I took was when you saw the soil reports, the geotech that we did for this site, and by the way, we're trying to, as you see, I know that you mentioned yesterday a lot of hearings, but we've been trying to address things at different hearings. We went back to OER, we've done geotech. I mean, we're not just stalling, kicking the can down the road, so to speak. So when I heard you yesterday, and I listened to you again last night, what I heard you saying to me was, Palatnik, you got bad soil here. And you got to take that soil out because that's non-good soil. And you can't necessarily count that. Is that what you were trying to tell me?
Fill
The
is
fill?
the same as bad soil.
That's because you came from the 1 to the 4.
No, this is not what I said. What I said, this is part of what I said. What I said in totality was, right now, you're claiming hardship based on the need for digging to ATM fee because of the environmental issue,
Right.
because of the contamination.
Right.
And all the hardship you're counting in your submission so far are based just on this. What I'm saying is, you submitted to us 4 borings, which we didn't ask for last hearing. We said we can go with the borings.
Across the street.
Yes, across the street. And you submitted 4 borings, and when we looked at them, we realized that based on these borings, you have fill material that's not suitable by the New York City Building Code to put foundation on them down to deeper than 18 feet.
Right.
In some of the borings.
Okay.
So if you're gonna dig, let's say we don't have the environmental, you don't have the contamination. You would need either way to dig deep, remove bad material, put structural fill in, compact it, and then put your building on top of that. Or the other option is pile foundation or ground improvement. Since you're gonna dig because of the environmental contamination to ATM fee, and you're gonna put the structural fill, and you counted this in the.
That's what I thought you were saying.
That's probably gonna enable you to put the building on shallow foundation, so it's gonna give you some relief. Right now, some relief. Right now, you're not counting this kind of relief in the equation. But this is what I just mentioned. I said this at the very end of my statement
You
yesterday.
did. Okay.
At the very end.
So, yes,
Before you
go on.
Okay, so, as I said at the very end of the very end, we're not entertaining more back and forth. We've had lots and lots of hearings on this. The submissions were intended, we asked for these submissions so that we could analyze scientifically what the issues are on the site.
I'm with you.
And now we have an instruction.
I'm with you, but there was a misunderstanding, and that's, I want you to just give me the, hopefully, you can we've spent a lot of time and a lot of money trying to do everything exactly the way you want, not like other applicants I've heard today who haven't done anything over time. We're constantly pursuing the end game here with you, and we're in it with you, so I'm asking you, just give me the ability to
That's
give
why
me
I
my
want to say
view.
this before you proceed.
Go on, yes, no, I'd like to hear what you have to say, because what you said is important.
I got what I didn't ask for, and I didn't get what I asked for.
Okay, so,
It's not true that you gave us what we asked for. It's not true that your submission was thorough and complete.
Elise, can you pass this up to me, please? Okay, so I hear what you just said, we didn't give you what you asked for, and I'm going to explain, what I'm asking her to pass up is an excerpt from the Langland report that did give you what you asked for, maybe you didn't see it, and that's the comment about just pass that up. That's the comment about going out to 18 feet over 63% of the property, in writing, signed and sealed.
No, sorry, we
But-
don't need to go through that again.
I'm not. I'm gonna cut to the chase, the guts of.
He's given us the sign and seal.
We have already seen that, yeah.
Okay, let me go to the guts of, I think, what Commissioner Shetta was saying yesterday.
I don't see sign and seal.
The letter was signed and sealed.
No, Eric, I'm sure, I'm positive that you're smarter than this. This is not what I asked for. What I asked for is a signed and sealed letter, please let me finish, that indicates clearly that digging 2 ATM feet is needed. This is number one. Is the most cost-effective way to achieve the target cleanup. This is number two. Sign and seal.
I will get you that. Let me go to, I think, is your deeper problem, because that I can give you easily, and I thought the geotech sort of replaced that, but I apologize for that oversight. Where I think the commissioner was taking us yesterday,
Hold it a little further away.
where I think he was taking us yesterday was a story, like when I go shopping with my wife. What my wife tells me when she sees polo shirts that are on sale for half off, that if I, 3 for $30 each, but if I buy 6, it's half off. She says to me, buy 6. You're saving $90. I think the principle, what you're saying to me, is I'm saving money. This side represents the side that's, I could go to grade, the right side. You're telling me that I can save the money that the money that I'm spending to take out the soil that I'm counting as my hardship, the $4 million that I'm counting as my hardship that we gave you yesterday, you said is now $1 million. And when you said it was $1 million, because I think what you're telling me is I'm counting costs to take out soil that I have to take out of the ground anyway,
No, but
because it's poor soil. Am I correct in that, though?
No, that reduction from whatever you claim to 1 million does not include the relief that's coming from environmental cleanup. It's
Right.
giving you some.
Right, but I think.
Sorry, I need
yes.
to interrupt, because I don't want this to go on. We said that this isn't going to be a back and forth, okay? I want to make clear. Commissioner Sheta talked about this idea of the crushed stone replacement for the bad fill. The very last comment was, and you didn't even take into account how it's helping you. Instead, what happened was Commissioner Sheta went through many, many, many other
Yes.
costs that were a mat slab that's 10 feet
I've
thick,
got-
lots of
Yes.
engineering costs and all of that stuff that were done.
And I have answers for, I have explanations for each of those, but the core issue of his question, he wasn't telling me that we were that we went from 4 to 1, a difference of $3 million, because we were over-exaggerating whatever somebody said. That's $3 million. I think what he was telling me was I'm counting,
No, that's what he said.
That's what he said.
You're
That's-
overcounting to the tune of 3 million.
Yes.
As an afterthought, basically, to close it out. In conclusion, also, if you're going to count all the 18 feet of excavation, at least don't put piles in afterwards. Put a cheaper foundation system in because you had to get rid of the dirt anyway. That was an also.
And I recall my exact words. I said, if you want to dig deep, so it means that we dug deep enough on this case. And by the way, here we go. We have the hearing. This is just being circulated. This is part of Langen report. When Langen does this, based on my practice for the past whatever, when an engineer like signed this, it's like he's coding. He's not putting this in his report as a recommendation. This is not the recommendations section of the report from Langen. This is just like a factual part. We got this from somebody else. And that's what you did in your submission, in your response letter. I mentioned this again yesterday. You blamed the 18 feet story on Langen, soil mix, the decision document from OER, and I did dig deep in all these 3 documents, and I couldn't find that.
okay, it is in the.
That's why I said,
It is-
please go back to the.
It is in the OER, we spoke about that at the last hearing, it's in the OER paperwork, the board did the
So then I'm
research.
going to interrupt again, because I do not want this to be an hour's worth or even 30 minutes worth of debate, okay? What the issue is this, the board was accepting, because it needs to base its assumptions on something, that 18 feet is going to be the excavation amount.
Yes.
What we had asked for was something that said it's the least amount necessary. We're not going to get that. We understand we're not going to get that because none of the professionals nor OER will say 18 feet is the
That's not true. We'll give that to you. That's not true.
It doesn't even matter, right? We asked for it before, we didn't get it. We're working on the assumption that 18 feet is in fact what's required so that we can do our analysis, right?
Right.
And based on our analysis, based on the 18-foot assumption and all of that, and looking at the numbers that were supplied to us with whichever submission number this is of cost analysis and everything, we find that the project is overvalued, and that's why the variance is not the minimum necessary to afford relief.
But it's not overvalued.
That's what but we are.
You're seeing it that way.
No, but we've concluded that it's overvalued, and we've had many hearings on which to review these numbers.
No, the last hearing we had, if I could correct, because I watched the hearing, the last record, the discussion was, now we've got the general concept, this was your words, now we have the general concept that we're digging down to 18 feet over 63% of the property. The next hearings are where we drill down now on the expenses, and we see what expenses are valid, and you cited to a case on 29th Street that you had been working on, that came in here at the beginning with a large number of variances, and by the end of it, you had dwindled them down after you had pushed back on all the numbers. That's the discussion I thought we were going to have today, where we ended up on the discussion today, and I think, if it just give me a second on the thought, I think what the disconnect that's happening between all of us is that we've been establishing the baseline as a baseline with the seller being dug out for the as of right being dug out, but that's not the baseline in this neighborhood. The baseline in this neighborhood is marshy conditions that are on fill soil. All of the properties around us are just like that, including the property.
I'm sorry for interrupting you. So it's not a unique condition? Right.
No, I'm not claiming it as unique. Hear me out. Good, you're with me. Hear me out. Do you hear me out? Just let me, please, I know this is so complicated and deep. Okay, so when you pull, that was the baseline we were all talking about. If you look at everything we've been talking about, we've been trying to isolate the hardship and saying build an as-of-right building and isolate the hardship. I mean, showing you a warehouse building with a cellar level. Okay, that is not the true baseline because the conditions in the neighborhood are that soil condition is crummy. So no realistic developer, such as the developer at 101 3rd Avenue, which is right across the street, it's an 8-story building in the R7 district, directly across the street, which he's going to testify to, is on grade. And the reason it's on grade is because it's partially with a partial basement. The reason it's on grade, which he's going to testify to you, is it's very expensive for a developer to dig down and take out that crummy soil. So it's easier for them to just put it on stilts on piles and put it right up at grade.
You keep focusing on point number 10.
There's a reason.
Focusing on that because we were looking at all the costs.
There's a reason for it, though.
Over.
If I could just continue, hear me out, because it makes good logical sense. The issue, by analyzing it the way we've been analyzing it, by saying that the soil has to come out, that's been the given in this whole discussion, that the soil, I don't care if it's dirty or not, the soil has to come out. If the site was clean, which is the true baseline, if it was just like the property across the street was, a clean property with silty conditions, the as-of-right, the one-story as-of-right warehouse that could be built on the property would not have to take out any soil. So they wouldn't have this hardship. We have, whether you call it
Hold the mic from your mouth.
Whether you call it $4 million or $3 million, the discussion you were all having yesterday about the numbers being slightly off, they're here to tell you, okay, what you said last time at the hearing, drill down on the numbers this time, just like 29th. That's what they're here to tell you and have a good, honest discussion with about. But I think what you're presuming is that we would have to take out the dirt if the site was clean.
No, that's not what he said.
For the fourth time, no. This is that relief that you're getting from the subsurface conditions, the geotech, the soil strength, subsurface conditions. This is not current. This is not part of your issue. If you want to dig deeper on this,
and we don't claim that to be our issue. We're not claiming that that's our issue. What I'm saying to you is, if the site was just like across the street, and I came to you for a variance, you could kick me out because you could say, Palatnik, you don't have to dig out that dirt. You could build it just like this, at grade, on piles, and you don't have a hardship. I'm telling you that I don't have that condition as across the street.
We know
Right,
this.
but can I just simply
Yeah.
say something? The difference between this site and the site on, I think it was 19th Street, is this has been going on for well over a year. And in well over a year, you haven't been able to convince this board of the degree of hardship that you're claiming. Although you have been trying earnestly, all of you, and that's great, but we still remain unconvinced. Part of why we remain unconvinced is because we also have a staff engineer here as one of the commissioners.
Right.
Who has been looking at it and has been debunking all of your theories all along and all of your costs. So, we're not sitting here saying you have no hardship. We're not saying that at all. We're just saying that the hardship you have does not merit both an FAR waiver as well as a use waiver. And so you have to consider a lesser variance.
And we're willing to, I want to have that conversation, I understand.
Well, no, there really is no conversation right now because we've already set out the guidelines. We want to see a use variance only, a 2.0 max FAR building, and make it work.
But we're entitled to, during this conversation with you, to understand how I have Saul, well, let's speak here, came to you with a number 4 million, and Commissioner Sheta, you came up with your number yesterday of 1 million. That's governing the bulk, the size we're asking. It's a $3 million difference. Maybe we could let the two of them speak so that they could, maybe he has a rational explanation explaining.
I don't think that he could prove his case verbally today. I
Right.
just don't see it happening. It was a very intricate analysis that Commissioner Sheta put forth, and he did list all of the areas where he felt that you were either double counting or overvaluing your costs. So to sit here and say that you could just come back at it in the next 5 minutes and you're going to convince the board that, oh, okay, yeah, we misunderstood, and you're absolutely right, it's $4 million, that's just not going to happen. And not only that, if we're here a year and a half in and we're still hashing out these costs, that's problematic.
We spent a portion of that time going to OER at the board's request, and the board also went back to OER. And I know, but that's what we've been doing. We haven't been spending the time on this issue. Why don't you just say a couple of words?
No.
You know what, this is, so I don't think, I think you're reading the room pretty well. I don't think words are going to solve this. I think that you heard the statements yesterday, your engineer can respond to them in writing, and perhaps that might take us there, but I assure you, I'm quite confident that just going back and forth isn't going to resolve this, especially when it's throwing real numbers in the air with real calculations.
Right. Since your review session yesterday, he's been at work, he's done all the numbers.
And I think that submitting that is the best way to.
Agreed.
Ms. Blanik, counsel.
He's here
No,
now.
sorry, Mr. Palatnik, we cannot have another hour
We're not
hearing
trying to
on
have
this.
another.
Just let me finish the statement and let's just get on with this case, okay? So if you want to make a case for why those stated numbers are not inflated without then correspondingly inflating other numbers that we didn't even talk about because we expect all of the other numbers to remain the same, if you want to make a case for why those numbers were not inflated, then you need to do that in writing. I don't want to do that again at the hearing. We've had too many hearings on this. Let me finish my sentence. And simultaneously, you need to look at the project with the lesser variance that we directed you to. Otherwise, I'm going to direct, close, and vote on this hearing the next time, and we won't have the project
Don't do that,
before. Okay.
That's what I don't want you to do.
Project before us that we were willing to consider because of the refusal to entertain that project. We have been actually, to correct, this has been almost, let's see, we've been at this since October 2017, right?
Yes.
So it's a year and 3 months, right? It's enough of hearings, right?
Well, we've been making a lot of progress. If you go through what's been going
You shouldn't have
on.
this many hearings on a case. It's because we were giving you the opportunity to make your case,
and certain things were submitted
I
that needed to
understand.
have been, that were not submitted, which would have arguably helped your case, but many things were submitted that hurt your case, right? And when we get new material, that's the whole point. The new material is
Understand.
for
Adam,
us to investigate.
I'll shut up now. I'm thankfully not closing the hearings. We'd like to submit it in writing, and maybe we could talk about it.
Okay, so no, you're not talking about it, you're submitting in writing.
Yes.
It needs to be a very detailed submission so that it can be carefully reviewed. No other numbers that were not discussed in yesterday's
Fair
review
enough.
session can be changed. You can explain why they are there, which is what the commissioner should
What about the
ask
contingency,
for
what about the
in-
contingency fees?
You have triple contingency fees in this project, right? You need to explain everything that was commented on and in writing, and then we can look at it, but I really recommend to you that you include in your materials a lesser variance, which you're willing to accept, because that's most likely where the board is going.
And this applies, please, this applies to whatever was mentioned yesterday and 2 hearings before.
And previous hearings.
Because we did ask for stuff last hearing and we didn't get them.
Right.
So whatever we asked for before, if you want to submit this in writing, whatever explanations you want to submit, be my guest, do it. And I'll go through it, and I pointed this because I did read Langen report very carefully. And it didn't fall down it's not true that I didn't realize that Langen mentioned something about the excavation. I did. But like I said, this is not a recommendation. So if you want to submit what we asked it for before, in addition to what was mentioned yesterday, I'll be more than happy to go through.
We thank you.
This is going to be at the risk of the following. If next hearing, I say, no, I'm not convinced, and there is no lesser variance submitted, it's done deal.
Well, if I can ask you a question, how can we get to the point of giving you a lesser variance if we haven't had a heart-to-heart discussion on the numbers and vetted them? We know they need to be some smaller, but he's going to defend them, though.
No, but we've been having that heart-to-heart, and we haven't been convinced. So read the tea leaves. Start working on a smaller project, because that size project is not going to fly with this board. It's that simple. We're not convinced, especially after seeing the debate on the numbers and listening to our own engineers' take on those numbers. We're just not convinced that a project of that size is warranted here. So you can spend your time, and this is where you're taking the risk. Your risk is you're going to do one more back and forth and be on the losing end of that with nothing to show for it, or you go back, you regroup, you talk to your developer/property owner, and you say, listen, we've been at it a year and a half. I've been in this business for 20 years, and I'm telling you, we need to rethink what you want, because you're not going to get everything you want here. That's your call.
I'm hearing you on that. I just didn't, yesterday when it was 2 stories and the 1 million, that's a big gap between what Langen is sitting here itching to talk about.
Right, but we're not going to talk about it, so, yeah, we're not talking about it, I'm sorry.
If I could just say one thing, I think what I would acknowledge is that the $4 million that was submitted was in error. There is, we found something to where we weren't carrying contingency and CM costs and things like that on the baseline scope. So when that subtracts out, it does close the gap. So, I mean, we're still not at 1 million. I believe we're at 3 million now. But
So
I'm acknowledging that it's not 4 million.
Thank you for coming forth and being honest about it, but I must simply say that if it takes us to point out the inconsistencies for you to then come to the podium and say, you know what, you're right, we overcounted this really shoots your credibility out of this room completely. And I know you understand that, you've been at this enough, but when we have to bring it to your attention and then you respond with, oh yeah, you're right, we overcounted this and we're closing the gap, and then what are you waiting for? Are you waiting for us to push harder, or are you hoping that we stop pushing?
Look,
that's the question. So
look,
there's
I
no
think-
credibility here.
Look, I think it was a simple mistake. It wasn't any sleight of hand or anything like that intended. That's why I'm here today. That's why I'm trying to, the reality is that,
I'm sorry, sir. It's good that you're here. You're Langen, right? Are you the environmental engineer of record for this project?
I'm I'm supporting them on the geotechnical side,
Not the environmental side.
not environmental.
So this statement here doesn't mean that you're recommending digging down to 18 feet?
No, my
Yes or no,
understanding,
please?
I cannot answer that because I'm not the environmental engineer.
Is this your recommendation? This is the letter of planning. Is this part of your recommendation? You can take a look at it.
It's a statement.
But
I
it's
don't,
not a recommendation.
I wouldn't take it as a recommendation. From what you're asking is a signed and sealed thing that, like, I understand what you're asking, like
So
hearing.
that is not recommending digging down to 18 feet?
I'm not saying that we're not recommending that, because like I said,
So
I'm not the
far,
geotechnical
till date,
engineer.
You did
I'm
not
not the
recommend
environmental.
digging down to 18 feet. Am I correct?
I'm sorry.
No, okay, so we don't want to do this anymore,
Just a
okay?
word of advice. At this point, I really think you should take the offer and submit where you have time to craft a response and really have a thoughtful, crafted out response, addressing the issues presented by the board, addressing an alternate, because like, as Commissioner Ali Brown stated, this is a big risk, and there's a cost and benefit analysis that needs to be done. And I think you need to, I don't see it going much better the longer this goes on.
Right. And by admitting that you're a million over, then you start looking at the other numbers, then maybe it's 2 million, and then maybe we're close to what Commissioner Sheta estimated, and then you've proven to us what we've already proven in-house, that the hardship was evaluated at, or valued greater than it really is, and therefore the minimum variance is not the minimum variance as requested.
I would just say that the differences in cost that we were reporting were not a result of hard construction costs. They were the contingencies, CM, things like that on the
Whatever.
back
So
end.
I don't want to get into the details. You heard, there's information in the review session, in the prior sessions, please listen to those and respond to those comments.
I do want to
Let's
say
move
though
on.
that the construction costs that were reported were
Yeah,
based on actual, were based on actual values that we had gotten from.
We're not going to get into that.
I understand that. I'm just trying to let you understand.
And I think it's better if we do it in writing.
Thank you.
Understood.
Thank
And
you.
please, if you submit something based on codes from contractors, I want to see these codes.
I'm hearing you loud and clear. Thanks for giving us the time.
How much time would you need?
How much time? That's
And
the,
are there any speakers, by the way?
I
Any
think,
speakers?
No
No speakers.
Langen, how long, you probably need 2 months or so, a month or so to get your paperwork together, a month? And Jack, you need,
But you also need to do the lesser variance, right?
Yes, it's not 2
It's
weeks.
not just
You have
one
to
again.
pursue the lesser variance because yeah.
How about we just pick one?
all right.
Yeah, we'll just pick it.
Jack is hearing you loud and clear, because when I said to Jack, how much time do you need? He said, I'm starting from scratch. So if we could have 3 months to make a submission, that will give Jack ample time. to-
Not
to
just
get it
Jack,
to you.
it's the
The whole team.
architect.
The whole team, and I'm hearing you, and the 3 million, when it comes down to, of course, if it affects it, we'll come back with a lesser project.
Okay.
Not if. No. Also.
We will
Also, you're being instructed to come to us with the lesser variance requested.
But like with any other application, if he doesn't come forward with what you've asked for, you're completely within your
They
rights
just
to
live- They just
deny.
lost 25% of completed hardship.
Yes, okay.
I think our
Okay.
record's clear.
Yeah, it's clear.
It's a mess of speaking, actually. How about submission of May 1st for a hearing on May 21st?
Yes, no?
That's great.
Thank you.
Thank you.
Thank you. Item number 23, microphone on. Item number 23, 2017, 33BZ, 398 Lenavar. Lenavar?
Yes.
Avenue, very good, I got it finally. Sad. I don't know if anyone's here for Mr. Rampula, but they requested a withdrawal without prejudice.
Okay.
So for a motion to withdraw without prejudice. Chair Permutta? Aye. Vice Chair Chanda? Aye. Commissioner Otley Brown? Aye. Commissioner Sheta? Aye. Commissioner Shabeta?
Aye.
This is drawn without prejudice. A note. Okay, item number 24, 2017-217BZ, 4855 Holland Boulevard, Staten Island. You know what's speaking? Come.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions?
Yes.
Good. Want to sign? Yeah, while Lisa's speaking. Yeah, this one. Get us.
Good afternoon, Lisa Orantia from Ackerman LLP for the applicant.
Damn town.
Yesterday, the board raised some questions about the grade elevation and the classification of the lowest story in the existing building. And today, I'm with John Chimenti, who's the project architect, who can address those questions.
Good afternoon.
State your name, please.
John Chimenti.
Mm-hmm.
I should stand back a
Already
little.
did that.
All right, so
Yeah, for some reason I can't.
I believe I have two comments. I think the initial one that there was an elevation on one of the drawings that showed an elevation. You want me to stand further back?
Trying to figure out how to fix the mic.
All right. So the site pitches from the street elevation up. So when I went to the site and evaluated the grade elevations that I show on the floor plan, just spot one. The building is now, as it presently exists, it enters on grade. You go downstairs to a cellar, and you go upstairs to the first floor. So what I did, based upon the comments of the board last time, is I've created a basement elevation, which then creates the handicap accessibility. And the board properly pointed out that I should pick that up as floor area. So what I did is I increased the floor area for the basement area, which counts under the zoning code.
Right.
The second issue was that the board then said, well, I'm raising the first floor up. And I'm raising the first floor up because the side elevation of the street, which is on Barclay Avenue, pitches up parallel to the Allen place. Maybe I'll stand over here. I'll talk a little louder. So that pitches up. And as I created the handicap accessibility and parking, I had to drop the area down. Now, as an architect, you are, and I can only pitch it in a certain degree. So what I tried to do is I created a basement area that would be accessible for the handicapped people, and I put an elevator in. That then, it makes the cellar area accessible and the first floor accessible. Now, on the drawing that I created by definition, what a cellar is. And by definition in the zoning code section 1210, it clearly states that a cellar elevation is from the floor to the ceiling. So what I did is that I created the first floor higher, and I created this ceiling to floor above at 3'1". Now I've done that for two different reasons. One, I provided enough height that I could put in a split system in, and those split systems could run above the hung ceiling, and I'm not picking up the area. The second issue is, in this type of framing, which I've done maybe 2,000 houses, sometimes I keep the framing of the floor and I go on top of it, so I don't have to redo that floor. So I created the space based upon the definition, and I think someone pointed out, isn't it a basement now? It's not a basement if I don't change the ceiling.
You mean it's not a cellar?
It's not a cellar. It is a cellar.
It is a cellar.
That if I don't change the ceiling height. That's in the code, so I've taken advantage of that, and I think those were
No, but so my concern is that it's very obvious that you're dropping this 3-foot plenum so that you qualify it for a cellar. I don't know, I just simply don't know whether DOB buys that kind of an argument, because your cellar, your base plane, the ceiling of your first floor, or rather it's the underside of your first floor, is almost 8 feet above your average grade.
Right.
So that's very high for the other half of the cellar.
I understand that, but under the existing building, it has a C of O that says cellar, and the cellar height
Your existing building doesn't have a raised ceiling, and you didn't drop
It has a ceiling.
No. The
Doctor's office has a ceiling.
You're raising the height of the ceiling of your cellar floor.
No, I'm not. I'm going to leave the ceiling, I'm going to rebuild the ceiling height to the exact height that it now exists.
Underneath the hung plenum.
Right. I'm going to keep the ceiling
But you're
height the same.
using the plenum to say that that's not a part of the ceiling, right? Right?
I've done this before. I'll just take an example here.
So I understand what you're trying to do. My point is, I don't know whether a DOB agrees with this approach, and they have to agree that it's not a basement, because if it is a basement, it's floor area, and we have no authority to grant a special
I understand.
permit.
I will, if the board approves the project today, I'll get a ruling.
No. So we don't, this is, as was explained yesterday, it's a jurisdictional problem. We can't grant an application if we don't have the jurisdiction to grant. So at the moment, you're asking for more floor area than we're allowed. If the cellar is a basement, what you're saying is a cellar is in fact a basement, then it's more floor area than we're allowed to grant, and we can't grant the special permit at all. So what we really need is a determination from DOB. You should be doing this simultaneously. So we are going to try to reach out to the DOB commissioner to see if he can answer this question with us through emails and a phone conversation. But in the event that he's unwilling to do that and requires that you go in for a zoning determination, we're going to have you go in for a determination.
I understood, though, that there were two options presented yesterday. One was to get a zoning determination from DOB or to grant
Yeah, I think we
the
worked that
special
out
permit.
yesterday. We worked it out yesterday, and I think we agreed that since it's a threshold, a jurisdictional question, that we would have to know if we have the authority to move forward, or jurisdiction to move forward.
Right.
And the only way, it's either through a ZRD1 determination, and then we'll know, or if they're going to have
If we could speak to if the DOB Borough Commissioner is willing to have a conversation directly with us and give us a determination, which therefore would be faster than you doing it, we're willing to consider that or try to obtain that. But we can't guarantee that that's the way that
Right,
the Commissioner will work.
I don't think it's a jurisdictional question if it's based on the plans as proposed, and a condition is cited that says that this grant is conditioned on
we can't
maximum
make it-
floor area.
we cannot make a determination that is outside of our jurisdiction. And this can possibly be a determination of that kind. Therefore,
Right.
Okay.
Also, just to clarify, that option was presented to the members of the board. It actually wasn't a
Yeah, we
option
discussed
for
it
you
amongst ourselves,
to-
right?
What you preferred.
Right, and another way of doing this faster is simply not change the floor-to-floor heights. Keep this a clear cellar where the
No, we can't do
cellar
that.
level to underside a first floor structure is the same as it was when it really was a cellar on the C of O. And then it's not an open question because it's clear. It's this manipulation with the plenum and the modification of the average grade and so on that brought this up.
I understand that. No, we can't do that, because I'll explain why very quickly. You can't get the cars into the parking lot. You'll hit, by law, obviously, handicap accessibility, and the height going in wouldn't work.
Okay, so be it. So therefore, and the only other option is to reduce the floor plate of the new construction by, I think we're over by 1,200 square feet, something like that, by whatever the overage would be if this lowest floor were in fact a basement. Those are speedier ways to go, arguably, in case the Borough Commissioner isn't willing to go the in-house kind of intra-agency route. Okay, are there any speakers on this? All right, so I know that there's a lot of concern on the part of the property owner to try to really move this along. We could put this on for like 3 weeks from now, and that way gives both our route and perhaps your route a chance. So I would do it simultaneously. Don't wait for us. file the ZRD1 request, but be very, as I said, it needs to be very specific in the request. It needs to state the current average grade is X. We're proposing the new average grade to be Y. The current level of the cellar floor is X. We're proposing it to be Y. The current height of the underside of the first floor is X. We're proposing Y. And we're proposing a 3-foot, whatever, plenum, and the measurement, therefore, to the underside of the plenum is, okay? It needs to be that clear, otherwise we'll feel like it wasn't fully represented to the commissioner. Okay?
Thank you.
Right.
Okay.
So,
right.
We could do a hearing in a month, so March 5th.
March 5th hearing, okay.
The official submission date is next week, February 13th, but I don't know that there's anything.
There's no official submit, I mean, if you came in with a ZRD1 on March 4th, that would, or even March 5th in the
That was
morning,
approved, yeah.
that would be enough, because it's the
Yeah.
only outstanding issue, I believe.
So as soon
right?
as you get any reply, would be the submission date.
Right, it is in fact the only outstanding issue. There was the parking. Oh, we also wanted backup materials and so on the parking study. That should be submitted quickly.
Okay.
Okay. Yeah. Okay. Thank you.
Thank you.
What's the date again? I'm sorry.
It's March 5th.
Okay,
next
thank you.
hearing.
I'm sorry.
But the parking materials need to be submitted
By February 13th.
February 13th, okay?
Wait for ZRD1. Just want to make sure that's on the record there. Okay, item number 25, 2017-247BZ, 1367 East 24th Street, Brooklyn. Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? Okay, proceed. This one. This is for the neighbors.
Good afternoon. Lyra Altman from the Office of Lyra Altman. We did have somebody attend your executive session yesterday and heard your comments. And here with me today is Heidi. I'm going to slaughter your last name. What is your last name properly?
Kunstler.
I should say properly. And she is working for the designer on this project. And to go through just a few of the little issues first regarding why the first floor is being raised. The joists are actually being left at the exact location. That was one of the comments from yesterday. The joists are in the same location, but because the building is changing, we're having to sister up new joists. We're going to need some thicker joists for some of the new ones. That's why it looks like the top of that floor is being raised, but the bottom of the floor is remaining in the same location.
The bottom of the...
Basically, the floor is getting thicker, but the bottom of the floor, the bottom of the existing joists are remaining in the exact location. The newer joists that are going in are going to be higher. So if you look closely at the section drawing, what you will see is the bottom is lined up and the top has a dashed line. There is one dashed line. Instead of normally you see two dashed lines showing where the entire floor is being moved.
Can we have the architect speak or?
Actually, the existing joist on the building is 3x8. So the engineer might come out with a new design which with a higher joist. Could be 2x12, could be metal joist. So therefore, the new elevation for the first floor is going to be raised based on the new size of the joist. That's going to be sister to the existing 3x8 that are on the building.
So what I don't understand is this then, why you keep, the goal is to keep the existing joists.
Correct.
Why are you, if you're replacing, effectively replacing all the joists in the house?
No, we are not replacing them. See, we are extending the building towards, facing the building towards the right-hand side, we are going to extend the building on the first floor and certain areas on the second floor. So obviously, those new joists must be to be longer to reach to the other side. So we are not going to have a bunch of columns holding the existing floor. So we are going to have new joists attach to the existing and reach to the other side, therefore it's going to be higher.
No, but what you're saying, so I know what sistering is. So normally, a sister would just be that you're extending the joist so that it reaches the new wall, right?
Correct.
But the way that it's described on the drawings is it's not a simple sistering, it's a doubling up of the joists for the entire length so that you get a thicker floor all the way across. So if you've got existing 3x8s and you're doubling the joists for 3x10s, then what's the point of the existing joists? You can't even put them in I know there's no beam pockets here, but you're not being able to hang them from the same hangers or anything. You're having to attach it to the adjacent joists. I don't get it.
Well, it will be attached to the existing framing that is there. It's something that the engineer has to come out with a solution to do that. The bottom line is that we are going to keep what is there. We cannot touch because that is part of the approval from BSA, correct? We cannot touch them. We are just we have to hold, we have to be able to design and hold the new area that is going to be extended.
Yeah.
So how do we do that? If we have to bring new joists, attached to the existing one and be able to extend it.
But you have bearing wall. I don't understand. You have walls all over the place in the center of the house. What do you need to have new joists running from exterior wall to exterior wall? You have all of these potential bearing walls here. Everywhere. Watch the. I mean, there's a lot of partitions in this house.
You see, our first floor is basically, we do not have any partition on the first floor, on the cellar, I'm sorry, on the cellar, proposed cellar. So we are keeping them, if you see, obviously, we don't have anything across to hold the existing.
Well, you
framing.
do actually. You have an opportunity for columns in the open cellar in a lot of places, and you could always add another little column because the cellar, of course, is not for sleeping, right?
That is correct. It's going to be for family, accessory to the dwelling above, like a TV area. And usually the client likes to have an open area without columns. So,
Well, you have a boiler room right in the middle,
And in
so
the
it's
middle.
not really an open area. I don't really know what you mean. It's
Okay.
not an open area.
well, this is something that has to come from the engineer. Maybe he wants to run an I-beam from the existing wall all the way to the other side. I'm sure he will.
So this is the part I'm very confused about. You have plenty of places to support your first floor and your second floor joists. It's like all over the place on the drawings. Go ahead.
And one more thing, engineers do not work this way. If you ask your engineer that I want to keep the same depth of the existing joint and the system should be the same depth,
That is true.
he should be able to
do.
It's just a little house.
If you just don't think that he may need to, and you eliminate may and say, Mr. Engineer, we need to use the same
Size.
drawing
Okay.
size, he would say yes, sir.
That is correct, sir. However, just keep on mind that we are going to have radiant heat. So it's going to...
You're going to have what? Radiant floor area?
heat floor areas, a floor. So more likely it's going to increase the depth of the...
So you do that with your subflooring materials, right? You don't do that with your joists.
No, we will not, but as you start putting more and more things, it start going... if it's too much to have the wall that we have to be raised, I will remove it so that it will not create this conflict of what exactly we are doing.
Yes, please remove it.
No worries, I will do that.
So you can sister them, that's normal.
Okay.
But you can't replace these beams with other beams. It doesn't make sense.
We'll remove
By the
that.
way, nowadays, for like if you have an old house, existing house, and the joists are weak and you cannot take like too much load and you want to put additional load on them, you could get some GFR grease, glass, fiber, reinforced plastic. It's sheets. It's like fabric. You just tie this to the bottom, to the sides.
Oh.
You get way stronger joists than what you have originally.
Interesting.
And no change in dimensions.
Good to know.
Right.
Okay, thank you.
Thank you.
Huh.
Okay, so that's the first thing.
Okay.
All right, the second thing, what was it about that sidewall? You need to retain that sidewall because you're showing the retention of 1 wide of brick on a chimney. No one ever can hold up 1 wide of brick on a chimney, right?
No worries, we will address that.
Okay, so you're going to retain that entire sidewall and take out the calculations for the attic where there's no floor area. You're including an attic where people can't stand. And the whole concept here of retention is that we retained 50% of the floor area of the house. So you can't include the portion of the attic that doesn't make floor area. You understand?
That's something that is very unclear. What is a floor area?
So
The
floor
definition.
area is a defined term.
Yes.
Because I don't have the definition right in front of me, is essentially, though, area that is defined by the walls and the floors and the ceiling of a space, right? But it has to be something that's defined as floor area. So in an attic, floor area, it's not floor area if, depending on the zoning district, it's under 8 feet.
8 feet,
And in this
R2.
case, you even have under 5 feet. So you can't include the enclosure of the places that are only 5 feet. And you actually show that clearly on your existing attic plan, where the areas are that it's impossible to stand on the existing plan. And you're including those enclosing walls towards your 50% total.
Because on my proposed attic floor area, I am even have the information of the ceiling height along that wall, which is 6 feet.
Not your proposed, your existing. What do we do with this?
Okay,
So your existing, I'm trying to find your existing attic floor, if we go to your existing attic floor. Where is it? Here we go. No?
So what you are saying is that I should only count the areas that are 8 feet high?
Over
Yes.
5, right? I'm sorry.
8 feet?
Yes, correct, 8 feet high. So you do have I just can't find it in my little pile here, but you have existing floor plans that make clear where your attic is.
Yes, but the only areas that are 8 feet high.
No. Where did you find the existing plan?
Under the original application.
Is E5, I guess.
Yeah. Okay, so the existing attic, you have something called a storage area that says under 5 feet. That cannot be, you don't even show walls on your existing plan there, so you can't count those walls. The only walls that you can count is that 15'7" wide bedroom wall.
May I come close to you, please?
Yeah, sure.
That way we're on the same page. You are talking about this area, correct?
Yeah, but not on your existing.
That's on the existing one. But 15
Yeah,
foot
okay,
area.
well, I have a different drawing, but so this area is under 5 feet, and this area is under 5 feet. So the only part that you can count towards retention is this 15'7" wall.
And on the other side?
And on the other side, I don't think you're including any, I don't think you're keeping any of this. But
Yes, I did.
wait, okay, but under 5 feet,
Yeah,
only
it's
this
out.
15'9" area.
It's only 15'9" and 15'7".
15'7", which is why you need to include more on your first and second floors, because you're under your 50% requirement by a lot. Okay? And it doesn't really affect your project very much. It's just because of, you're only pulling the wall out by a couple of feet. It's not really worth it.
I agree, pulling here and there, it will make actually the first.
I understand, no, I don't want to get into it. Your job is to be the architect and design it and to comply with the request, correct.
Okay. Are there any speakers on this? Oh, and also you need to, there's some conflicting notes. Oh, this is about the.
Yes, I will address in
yeah,
those,
okay.
yes.
And show dimensions of the exterior walls
We
to
did that.
remain on the floor plans, right, on the proposed floor plans, okay?
Okay.
Okay, good.
Thank you, everybody.
Thank you. Yeah. I asked for speakers. Is that it? You done? No, no.
We need plus the 3 weeks, and that's when we get the hearing date.
At least 4 weeks to make the changes.
We need 4 weeks to make the
Yes.
changes.
I want to be sure that everything has to be perfect.
How about March 6th submission date? It's about a month. March 6th for a hearing.
For my birthday.
Oh, good.
Oh, happy birthday.
Maybe that will bring me good luck.
And for a hearing, continued hearing on March 26th.
March 26th is the one date.
Oh, you're not available,
That's
that's
the one
right.
date that I'm not available.
That's right, that's right. March 20th? Okay, so submission date March 20th, after your birthday. But next hearing, April 9th.
Can we do it, would it be possible to move it the one before on the 19th?
Let's see. Kind of 6, half dozen of the other. March 5th, wait, sorry, no. 17, 15. That's fine. So submission February 27th.
I'll be ready for February 27th.
Hearing March 19th.
Thank you.
Thank you.
Okay, item number 26, 2017-288BZ, 17-10 Whitestone Expressway, Queens. They're requesting adjournment?
Adjournment is, yeah, Ms.
Who's this
Arantia,
here?
you, yeah.
Good afternoon, Lisa Orantia, Ackerman LLP for the applicant. We're requesting a hearing date of March 26th, submission on March 6th.
Okay. So this is, they're working out more issues with the neighbors. I think it's terrific that they're working so hard to meet the neighbors' concerns or address them. So, yeah.
All right, so submission March 6th, next hearing is March 26th.
Thank you.
Item number 27, 2017-295BZ, 128 West 26th Street, Manhattan. I know. Raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions? Start go. Could you sign, please?
Good afternoon, Jay Goldstein for the applicant. I attended yesterday's review session. I don't know where to stand.
Me?
Sorry, I can't.
It's fine.
Try.
Yeah.
We're good, I'm not going to move.
What about unplugging it and plugging it again or something like that?
Right now it's working, so I'm good.
No, not really.
Anything other than computers?
Should I hit it on the side?
I think we're.
Blow into it like a Nintendo game? So I attended yesterday's review session. The comments regarding amplifying the statement of facts and removing the comments regarding the buildings next door, understood and will be done. We'll include on the proposed plans the finishing facade, the finishing materials on the facade. The comment regarding the lesser variance scenario, we will come up with plans and explore that as well. With me today are Carl Schwartz and Barbara Cohn. Carl is the cost estimator, Barbara is the clerk prepares the financial report. I think we'll do a little bit out of order just to save some time, I believe. Commissioner Shetta, to your point, first of all, thank you very much for remembering when I do good work. Few and far between, but I appreciate it. The estimates that were given initially were based on assumptions, based on the years of experience, not based on facts on the ground, because we had a building there that we couldn't access, so we couldn't really get in to see the conditions. The SOE plans, again, were prepared, the building was still up in the process of being demolished. It was a baseline that was proposed, knowing that we would come in and create the template. I know last hearing, the board actually gave me the template that the board wants to see now, with the estimates and with the quantities. Now that the building is demolished and demolition was extremely long and finished about a month ago, not even, we can put together borings, or come up with, or have the borings done, and come up with actual foundation and SOE plans that match the site conditions, and based on that, we'll be able to update the cost estimates with the quantities and give you exactly what you're, I believe, exactly what you're looking for.
The SOE that you submitted, I didn't have like significant comments on it. The only
Right.
comment I have, I wanted to understand what kind of plug is used. The client, when I looked at it, it seems like it's a pipe, and then right behind it, there's like a B section.
Right.
And when the cost estimator counted it, he counted like 3 times.
Well, it was, the cost estimate was first and then the SOE. That was the problem.
The cost estimate was done before.
That's what that was the problem. And we couldn't fix it at the SOE. Mr. Schwartz had back surgery. By the time we got the SOE, there wasn't enough time. But we'll submit everything to you now with the estimates, we're going to actually look into the SOE to see if we can do the setback at the front or the slope excavation at the front. We'll explore that. It was just, the SOE was submitted as a kind of a baseline. Here's the, you requested SOEs. We wanted to try and be as responsive as we could. Now that we have that and we have the ability to go in and actually clarify and formulate the responses better, we'll come up with the more concrete estimates and present it to you.
There's something that I didn't mention yesterday.
Sure.
In the SOE drawings, it says that the conditions from the building next door, it says it's either assumed or conveyed to the designer by somebody else. So I would like to understand how did he get that? The adjacent building footing is whatever, 8 feet. Whatever he puts on the drawings, he need to
explain how he got it.
How did he get this? And if he does estimates, I would like to get logs for the estimates.
Okay.
In addition, of course, to that, like that formal duty.
You got it. No problem. Okay. So again, we'll submit everything to you and hopefully it'll be done in a way that will put everything to rest. Commissioner Ali Brown, with regards to your question, Ms. Cohn's here and she can address those better than I can.
Barbara Cohen, real estate and planning consultant. I can go through the items. So the site value, that all got modified and is okay. Then I did overlook taking out that asking sales in the residential sales comps, and I'll do that. I know you were also looking to maybe try to find some higher floor comps just to get a sense of what those higher floors are. I will do that. I've been very conscious about picking comps that are the narrow floor plates. So hopefully I can find that, and in the year that we've. The other thing then leads to the site plan, stacking plan. So on page 20, I had added the discussion of the outdoor space and how that was going to be valued using that Miller report of assigning value to that exterior space representing a percentage of the value of the interior space. And I had felt that the lower end, the 25% of that interior space, was more appropriate because the 87 square feet of what was balcony, that's access to through the bedroom, that lets you out on this balcony in a shaft, wasn't exactly the most attractive outdoor space, so I didn't think it, deserved the higher percentage of value. I can lay out a better chart to sort of walk you through how, take the numbers from the prior stacking plan, and then take that 25%, add it, multiply it by the 87 square feet of balcony space, add that amount to that prior total, and then it divides the price per square foot.
Right, but, so the issue I had
Yeah.
was that out of your comparables, I think only one of them has outdoor space. So you're using comparables without outdoor space at all, and you're getting an average price per square foot, and you just applied it in the first report to the apartments in the stacking plan. But then that's not really accounting for the value of the outdoor space, because the comps, only one of them has a small amount of outdoor space. The others have no outdoor space. So you're not accounting for it there, and then you didn't break it out in the math on the stacking plan. So that's why I said add in for the outdoor space, expecting the overall average price per square foot to go up, because it would reflect the addition of the outdoor space that you had left off, but I saw it didn't.
Well, it did go up, it didn't go up, it didn't go up, no, the math is there, it didn't go up as much as perhaps you would have expected because of the value of the percentage was a lower percentage. Very often we do 50% of the value of the interior space and then apply that to the exterior outdoor.
Yes. So this is what I need though, because I think that when you're not including comps with outdoor space, like all of your comps should have outdoor space, then I'll make sure that at least the sales price that you're showing me is accounting for the amenity of having outdoor
having it,
space.
period.
Then, when you pop it into your stacking plan, it should just reflect that. So that was the issue. But then the other issue I had with the comparables were that you talked about how this space was at a disadvantage because it didn't have the amenities that the other space has.
Right, and to say what the...
You never told me what any of them have, so I can't check your assumption.
I know. And for the most part, it's probably gyms and things like that, but I'm happy to go back and spell that out. You're right. And actually so yes, I'll cover all those things in the next go-around. And just in terms of the idea of the setbacks and adding more office square footage, right, as a lesser idea, I sort of did that quickly, and without, of course, the other side of the equation, which is the cost to build that extra space, and it still comes out as a loss. But if you think we need to spell all that out, we can have Carl do yet another cost estimate and just play it out.
Okay, it's just to prove that, yeah, it's just to prove that a lesser variance would or wouldn't work.
That's fine,
Yeah.
that's fine.
Cross that off.
I think that's it.
Okay, great.
And the final point was with regard to the question of DEP.
Yeah.
Again, the demo took a lot longer than we anticipated. We did the work, we sent it into the lab. We should have the results this week, and then we'll be able to submit the report for DEP review. So calculating that into our response time, I think we need about 2 months at least just for DEP. Okay.
Air
Yeah,
quality.
it'll all be part of the same response. It's usually
So
30
you're
days there, 30 days back.
Right. So you're saying you might be able to submit in 30 days?
No, I'm going to submit within the next week or so.
Next week, okay. But then you're assuming comments, so.
Comments
another
back and
return,
forth is
okay.
2 months, so 2 months.
Okay.
I don't want
Are there-
to, otherwise we're not going to have DEP
Right.
done.
Are there any speakers on this?
128 West 26th Street, any other speakers?
No? Okay. So at least 2 months.
This 2 months, that is, how about a submission date April 10th for April 30th?
1 second, let me do a holiday check. April 10th for hearing on what?
On April 30th.
We're good.
April 30th.
Okay, thank you very
Submission,
much.
April 10th.
Thank you very much.
Thank you.
Item number 28, 2018-42 BZ, 1360 36th Street, Brooklyn.
Okay, that's me. I'm recusing from this.
Yes, ma'am.
See the submission? Various submissions, sorry.
Raise your right hands. Okay. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions? Thank you. Go.
Good afternoon, Vice Chair Shonda and Commissioners, Judy Gallen, Brian Cave, Leighton Kaesner. We attended your review session yesterday, and my colleague C.B. Mobley and I will respond to each of the questions raised. You noted that the times during which the proposed school can be used non-simultaneously as a use group or synagogue will be a condition of the approval, and we would also want it to be specifically noted on the CBO, so that there's no question about what can go on, and there'll be no problems with that. With respect to secured access, you raised a question about the primary circulation for the students versus the visitors, and how that would work. The school is a school, so school is primarily available to the students. In fact, they can go anywhere except the obvious places where they cannot be safe, utility rooms, back of house, things like that. As you pointed out, there are 4 staircases, so that when visitors are in the building, the school can, as an operational issue, decide how they're going to have people go up and down the building. All visitors to the building, as we indicated in the security response, all visitors will go to the lobby, and they will be directed by a security guard to whichever of the available staircases should be used for that event. There will also be signage. There will be teachers posted when it's a large event to make sure that people are going where they want. And this is, the events that would happen in the school are really family events. It's not anticipated they would be open to the general public. So not that security isn't required, but there is that as just something to consider. But all events would be planned and coordinated and staffed so that the children will be safe. That's obviously an utmost consideration for the school. There was a question about whether certain spaces, particularly something you had mentioned, the mezzanine, might be off limits to the students. And on that level, there is a kitchen, a kosher kitchen, utility rooms, and back of house things. But there are also on that level coat rooms and restrooms. And those are used by children who would be in the auditorium. And so that would be accessible to the students as appropriate under supervision, always. Then an issue was raised about the size of the recreation spaces shown in the plans and whether the occupancies stated on those plans exceed the anticipated utilization. Bienenfeld Architects has prepared a memorandum explaining this in detail. We submitted that electronically this morning, and I do have copies, if I can give them, I think it will facilitate the conversation, as well as a copy of a schedule, which you already have, but I think it will just make it easier.
All right.
No. Do you need a copy?
No.
Oh, okay.
So as Sam Feigenbaum, who will speak to this, will explain, the occupancies that are shown on the plans are based on building code egress requirements. And those are conservatively set at 15 square feet per person as a worst-case scenario. The building department wants to make sure there's appropriate egress to get everyone out. But that is distinct from functional capacity. Schools are not designed to that capacity. And obviously, when people are participating in active recreation, 15 square foot per person is a recipe for a disaster. In fact, gyms are designed, as Sam will explain, with a minimum square footage of about 50 square foot per person, and it goes up from there. But before he does address this, and Will, I want to just go over one aspect of the schedule that I passed out that we submitted to you on January 19th, and that I believe Vice Chair Shonda, you were looking at when you raised the question. There's an aspect of the way it was formatted that I think caused some confusion. If you look, for example, at the gym, and I've highlighted Tuesday at 11:50. On a Tuesday at 11:50, the gym is actually occupied by 4 classes, not 2 classes. There's a line, a column line that separates 5A and B and 5C and D, which shouldn't have been there because it was confusing. So in fact, at 11:50, there are 4 classes, not 2, using that facility, and that, in this case, is 94 students. And in the Bienenfeld memo, there is a chart which shows each of the spaces at their maximum capacity, which is what they're designed to. So Sam Feigenbaum will take you through his memo and the rationale for the size of the recreation space.
My name is Sam Feigenbaum from Bienenfeld Architecture.
We worked, as you've seen before, on the programmatic needs packet and helping programming the building itself for the school. So we, based on the comments yesterday, we prepared this memo, which the point is to help clarify essentially what the square footage numbers on the drawing are in relation to how the spaces are actually used. So a gym actually in New York City is somewhat unique. New York City is the only code that we looked up about 30 state codes yesterday out of curiosity, because between New York State and the International Building Code, which they're all based upon, they don't actually differentiate a gym from an exercise room. They list an exercise room and they list 50 square feet per person, which is usually about the baseline starting number for a gym in large spaces where you're going to have kids running around, especially older ones and playing basketball and stuff like that. So New York City differentiates, and one of the indicators maybe why that is the SCA and their requirements actually request that these gym-type spaces be designed sort of so that they can potentially be used in educational spaces necessary. So the goal is to just make sure the egress requirements in a space in a dense environment like New York does actually accommodate all the children. If you were to, just a simple example, for example, like if you think about a standard classroom, per the egress requirements on the code is 20 square feet, and that would be the minimum. Typically, ideally, you actually have more square footage per student than that to start with. I can't imagine actually having the majority of physical activity with a child of any size that would even be less than that. You know, the locker room that goes with the gym is a 50 square foot per person square footage number. Similar examples like a reading room in a library, you know, and stuff like that. They are larger numbers because playing ball in sports just entails more movement. One of the standards we actually use in designing facilities like this is time saver standards, and they actually recommend for a gym 125 square feet per person. That probably is more in the line of when you're actually doing larger kids and larger sports. So you're going to have a range. Here we have small children and up to larger children, so the actual usage of the spaces, if you have a chance to review the chart at some point, they broke down the different uses in some of these rooms where the smaller children, based on the class sizes right now, which are more, they're not running around like that, they probably walk around together. Little kids, if you've ever watched, they sort of play in denser groups. So that, the estimated number right now based on the usage of that lower cellar indoor space is about 19 square feet per person. Well, if you went all the way up to the gymnasium on the roof where you're having the children playing basketball, and that's where I think they have like 10 basketball hoops in there, that comes out to about 65 square feet per person. So when you sort of look at it in the actual use case scenario, the rooms are not oversized. They're actually designed relatively well to accommodate the needs of the school. We included on here, just for your reference, you can even see some of the codes that we actually looked up yesterday to reference. And, you know, the New York City Building Code reference is 15 square feet net, the New York, and 50 square feet gross. Basically, the New York State, the 2018 International Building Code, and about 30 other building codes that we were able to check relatively yesterday, all use just the standard number of 50 square feet gross per person. So I think...
Well, I appreciate for this detailed information. The reason I had that confusion is because I chose not to look at the floor plan. I looked at the programmatic needs statement to see what specifically the capacity, the programmatic needs statement was stating for each one of those rooms. And it actually replicated the same occupancy code as what's in the plan. So I didn't want to look at I know the plans have to show the occupancy rating based on DOB code, so I was looking at the programmatic needs, and that's why I had those questions. Thank you for this clarification. I think we can use this as a standard in future to understand why some of the schools need a certain amount of square footage, but yes, this
We
is...
listed it, the programmatic needs, because it needs to match the plan, so otherwise...
I guess
so,
it,
but now
just as a
understand.
future reference, it would be helpful if you can kind of
Correct,
say,
we would
while
add-
that's the occupancy by DOB, this is the going rate, if you want to call it.
Yes, that makes a lot of sense.
Right?
We'll definitely do that the next
That's the whole intent of the programmatic needs
Thank you.
document.
If you have no other questions on this issue, my colleague C.B. Mobley will address the transportation issues that were posed yesterday.
I believe we have a DOT sign-off.
We do.
right?
And we were
Yes.
satisfied.
And applicant, and I believe the agreement is that you will agree to coordinate with DOT School Safety Unit and the Brooklyn Borough Engineers to implement the safety improvement plans prior to the opening of the school. And that would be one of the conditions. Now, I also had laid out another condition. I just want to make sure that's also acceptable. With regards to the use group, should there be any other use group other than use group 4 synagogue, or in addition to use group synagogue is going to use the lower 2 floors, then it has to meet all the underlying regulations of the zoning.
We understand that that would be a condition of approval.
I don't want to take your thunder, but if you think we have missed anything and you want us to...
I'm glad to sit right back down. You had questions about parking around the street frontages at the site, but I'm also glad not to talk about that, your decision.
No, I think DOT has signed up.
Very
This is a
good.
very complicated site, and we wanted DOT to fully review and understand it. And the only question I had was about the 36... Parking on
Yes,
that one.
Did you want to talk about that?
Just as an FYI. I just want to know.
So, I mean, we had submitted this figure, I can pull it back, that explains proposed and existing
Right.
street signage. And all 4 frontages at the site would be signaged with no standing, here we go. No standing anytime except Saturdays, 7 a.m. to 7 p.m. And that would apply to all 4 frontages. So that would prohibit parking during the day, 6 days a week, but would not prohibit parking at night or during the day Saturday.
So after school hours, there'll be more parking spaces on this site than currently exists?
That is correct.
Okay. Which probably helps if should someone wants to use the synagogue or space after hours, wants to drive, you have that additional parking space.
Or the neighbors, yes, it would be available for the community. Yeah.
Right, or the community.
Okay. Any other questions?
No, thank you very much.
No, thank you.
I want to say this has been one of the most thorough applications we have received, so appreciate it.
Thank you. Thank you.
Also, the next item, I just wanted to comment, we received your draft restrictive deck, and I reviewed that, and that's sufficient for my purposes. It's not been executed, but it can be incorporated as a condition. It's execution on the property, execution and recordation against the property will be a condition.
I'm comfortable closing this case. Is everybody, and you want to vote with the conditions that we had laid out?
Yes.
Okay, we'll make a motion to close.
Motion to close.
Chair Perlmutter? Oh, sorry. Sorry, Vice Chair.
That's quite okay.
Vice Chair Chanda?
Yes.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
And approve with conditions. Do you want me to read out the conditions?
Yes.
So the first condition is, I have to scroll back and forth, I don't do this very often, that the non-simultaneous uses that would be using the facility, portions of the facility, of the school, may also, with regards to that, may also be used as use group 4 house of worship Sundays through Thursday, 7 p.m. to 11 p.m., Fridays, 4 p.m. to Sunday, 7 a.m., and on Jewish holidays when school is closed. That is one condition. The other is with regards to the DOT sign off, that the applicant agrees to coordinate with DOT School Safety Unit and Brooklyn Borough Engineer to implement safety improvements prior to school opening. And the last one is the condition that board approves this application, that if any other as-of-right use groups operates on the site as an alternative to the proposed use group 4 or in addition to the use group 4, such uses would be required to comply with the underlying zoning regulations, including parking and loading.
And then the recording of the...
And the recording of the...
off-street bus parking.
Yes, and the recording of the off-street bus parking. Thank you.
Yeah.
With that.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Shetta?
Aye.
Commissioner Shabeta?
Aye.
This application's been granted.
Thank you.
Thank you. Keep going?
You gotta bring the chair out.
New?
Gotta get the chair.
No, I mean, yeah, obviously, but. What do I have? No, wait. 120.
You're a steel meter.
2018-120 BZ.
Yeah, okay, so this one's. I don't know how to speak, it's from the neighbors, that's why it's. Could sign it.
Really?
Waiting for the chair to come in.
Wow. Makes you wonder if in the summer it's gonna be 40
It's
some
going to
days.
It's going to be a.
It seemed like they turned the air off, right?
Well, I think, is El Nino time?
This is a summer El Nino?
No, I think it's El Nino now, and that's why it's a little bit warmer. No,
No, we're talking about weather-wise.
It's in general.
So it is time for break officially.
What? No, just, thank you, I really
Okay,
appreciate it.
it's 4 o'clock. I
don't
was
wanna-
just saying you can have a break if you'd like.
Right now, yeah.
She's coming. She's putting her things together. I think that went a lot faster than expected. But maybe stop the tape. Sorry, we just lost another.
Yeah, I'm like, Zoning calendar, new items, item number 1, 2018-120BZ, 550 West 41st Street, Manhattan. Raise your right hand, Mr. The most, forgot your name. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and to respond honestly to board member questions?
Yes, I do.
Go.
Good afternoon. Jordan Most from Bryan Cave. It's a PCE application for a property located at 550 West 41st Street. I could run through some of the application sort of highlights. This is
No, you don't need to, we've read the whole application,
We were, of
right?
course, at the review session yesterday, and we're, of course, aware of the Community Board 4's condition. In fact, I think they attached my letter to their recommendation. And when and if there is a change, of course, as we're legally obligated to, if there's a change in the operator at this PCE, we'll, of course, submit the DOI. And when the PCE is up and running, we'll invite CB4 to come observe, take a look at. I know that's their general sort of MO. They generally walk through these spaces while they're operating, which is often sometimes before they're actually at the Board of Standards and Appeals, or while that process is taking place. So we'll certainly do that. Then there were really three other things I think that the board touched on that was discussed yesterday. One was the question of amplified sound. The one was about sound attenuation measures in general, and one was about lighting in the outdoor space. So just to set the scene here, we're between 10th and 11th Avenues on 41st Street, or really Galvin and 11th Avenue. And we're sort of on top of the Lincoln Tunnel entrance there. This is the former Mercedes-Benz site. One of the, it's an E-designated site, which among the requirements for this property to be developed is that it has to have sort of ramped up window sound attenuation measures. That windows, I think, are 33 dBA requirement, and also non-opening windows, and that's largely due to the location of, basically at an entrance to the highway there at the Lincoln Tunnel. But there will be a small outdoor space, and we would at least like the ability to have, while there's no plans for any live music or DJ or anything like that, just some ambient sort of sound or music that would be sort of piped in through the wall type of thing is how.
Piped in through the wall?
Through like a parapet wall type of thing, or speakers in the ground. But I'm not talking about a stage. I'm trying to make a distinction between having a loud music situation with
Right.
having ambient music. And I'm not sure how to articulate that, other than that. That's what the applicant would like.
Why do you have to have music on this outdoor thing?
It's a pleasant amenity. It's just.
Pleasant amenity that could drive your upstairs neighbors.
Well, the upstairs
bananas.
neighbors, nobody wants to drive the upstairs neighbors crazy. They're our neighbors. But we also, they also have these non-opening windows with special, the music will probably be drowned out by the Lincoln Tunnel. But it's a thing we'd like to be able to have up in that space as part of the amenity.
No.
Oh, I'm sorry.
She was saying no relative to a different question.
Something else.
She was
Sorry, I'm
creating
sorry.
something else.
Wait, listen, sorry about that.
But I might feel the same kind of way, like how could we possibly, so for one, it's not that often that we see rooftop recreational spaces, and I'm aware of one in particular, a spa on 59th Street, or 57th Street, rather, that is in fact opposite, or adjacent to a very tall contemporary residential building where they cannot open the windows, and it's driving them absolutely crazy. So, I'm not thinking it's such a good idea to enter into this experiment.
Well, if we can come up with I guess, a solution that is somehow regulatable, I guess, if we could discuss that and maybe propose something, or the applicant may just simply decide that
Well, if sound engineers or something can show it doesn't migrate to the floor above, and so there are sound baffles, or I don't know what, maybe
basically
something
two
like that.
floors, right? So we're talking, as you demonstrated, you're aware of the sort of, the configuration of the space is such that there actually is, and just to clarify, there's no commercial space below on the floor below, on the third floor. There's commercial space on the first and second floor. Third floor is 100% mechanical space. Then the gym is on the fourth floor, and it has a separate entrance on 41st Street, an isolated entrance, the gym space. And the fifth floor is a combination of the sort of double height basketball court area and fifth floor space in the building, like that is a residential amenity space.
Right.
The only space where there are residential units that begin really on the sixth floor, then, I'm just pointing out that they're not windows that
Not
are,
sleeping
they're two
units.
floors.
Right.
There are spaces that are 2 floors
But
below.
for one, residential amenity space could be something like quiet space, a little library you go to. I mean, it's a residential amenity space, right?
It would be limited to the hours of operation of the PCE as well.
It's pretty late.
Till 10 at night.
Yeah.
Okay, I'm not gonna take this to the mat
Okay,
necessarily.
right, okay.
With respect to lighting, so all lighting will be, we don't have it, I think there's a lighting plan, it's sort of in flux, it's being changed, but we'd be amenable to having a condition, I guess, in any resolution that says all lighting will point downwards and inwards. So no lighting is going to be projecting outward from that space, and I assume also it would be able to go down or off, certainly after the hours of operation as well.
I think it should have shields that cover all of the light fixtures, that force all the illumination to go down to the ground level of or the terrace level, right?
Right. I think that is the plan.
Or it should be in bollards or something
Yeah.
level.
Nothing will be pointing up. The building it's not going to be lit from this space, and it's not going to be projecting outward across the street to other buildings or anything like that.
Right, but, so I think what you need to do is...
Do you want a note?
Yeah, we maybe even a diagram that shows what the kind of lighting options would go for. So in other words, you don't have to do a lighting drawing, but show the types of fixtures that would be used. So bollard types, lights that have that kind of shield that's more like a hat, right? That points the lighting down onto the ground.
Would we be able to show them, I'm concerned, I don't want to have to locate them in the space, but
No,
show that.
I didn't say
Would be I know, I
these
just want to
types of
clarify.
light.
That it would be, these are the types of things that we would use. And you'd like to see that then on a plan sheet?
Yes.
Okay.
With respect to the sound measures,
Attenuation, you mean?
right, sound attenuation measures. So I assume, I don't want to assume, but there's a note on sheet P5 and sheet P9. P5 sort of explains for the basketball court, see P9, and there's a detail of the
Spin studio.
floating,
Yeah.
sort of a floating floor, two different floating floors. There's a basketball floor that's on rubber, floating on rubber, I can't think of the word,
Oh,
pads.
yeah.
And the spin studio is floating on, it's a different kind of floor, but it's floating on springs.
Right.
And it also has a drop ceiling that has a spring suspended ceiling as well in the spin studio. And those are both shown on P9. And then all the other areas, the weight areas, all the other gym spaces have rubber matting of varying.
So to just make this clear, we often get plans that just indicate where the
Fine.
acoustical efforts are being made specifically. So it's kind of,
Completely understand. So I'll basically we'll give you a floor plan and a ceiling plan that will identify where there are sound attenuation measures and what materials are being used at those
correct.
spots.
It just makes it very clear.
I understand.
And right now, there isn't anything for the basketball court. And, I don't know what the frequency of somebody hitting the ceiling of a basketball court.
And there
with
is,
the balls.
right, it's not on here, but I understand there are special acoustical tiles in the basketball area,
Mhm.
and like I said, a suspended floor on the floating floor of the basketball court as well. So we'll do that as well then. So, okay. So those were, I think,
I think that's it, yes. And fire department, as you know, I think.
Yes.
Had a letter of no objection with caveats.
Yes.
Right? So that's more or less to, I think we'll include that because you're not going to be building this for a while, so you should be reminded that you need to have that.
Sure, we've sent that already to the pool design people, so they're aware of incorporating those things into their notes.
Okay. Okay. Are there any speakers on this? So then, if you could make those corrections to the drawings, if you're proposing some sort of, if you're coming up with a sound system that could persuade us, then persuade us, but otherwise, I just think it's safer not to do that.
Right.
And then, of course, just to show, you could have the architect just show a variety of typical outdoor lights that come with shields.
Sure.
Like a standard catalog
I
thing.
understand. I know exactly.
And they don't need to be those lights, they have to be, they often say or equal,
Right,
right?
okay.
So,
We'll put a note on there that
Yeah.
makes that clear, I guess. We're just concerned about being held to that, obviously.
Right.
Something like that, or.
something like that, so that in the future, when the neighbors come to complain to us, we didn't say we approve the light that points right up at their window. Okay, all right, so then,
We could submit that
I guess, yeah.
fairly quickly.
Could you do it by next Wednesday?
Sure.
That was a sure.
So
Okay.
the submission date would be next Wednesday, February 13th, for a hearing on March 5th.
21335. Thank you.
Thank
you.
Item number 2, 2017, 231BZ, 765 Pennsylvania Avenue, Brooklyn. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board and to respond honestly to board member questions? I've taken Leah already.
Good afternoon, Elise Boladair from Eric Palatnik PC on behalf of the applicant. I'll go through your comments. Firstly, I will correct the statement or clarify in the statement that yes, it's just for sale of gas and a convenience store, and that's what's on the site. For the storage container, we'd like to put a fence around it if possible, and we will provide that on the next set of plans. Vacuums will be removed as requested. We will put in plantings as shown on the previously approved plans and show pictures of those plantings. And additionally, we will file for the tree and show proof We will provide more photographs of the perimeter, the landscaping, the building. We will revise the drawings to show the sound attenuation around the AC equipment. We will revise the plans to, well, first we will correct the lighting on the site, and then we'll revise the plans accordingly to make sure that light does not go into any adjoining properties. And then lastly, there was no underground storage completed on this site, only direct fill.
There was no, sorry, there was no what?
I was told there was no underground storage tank removal.
Relocated or
Yeah.
anything like that?
Only direct fill, upgrade double wall buckets. I can't.
Say it again, upgrade double wall.
It was told in parentheses, double wall buckets. I can get more information about what that means, but
Upright double wall buckets?
they just said only direct fill upgrade.
I think the comment maybe is perhaps that the prior approved plans showed USTs and the current ones don't, like even in a dashed kind of line. So
Yeah.
to the extent you're able to put those back where they actually are to make the plans consistent again across time.
Okay.
And then that way you have a chance to verify what they mean by the double bucket, whatever you said.
Ask for more clarification what that means, but I'm not an engineer, so I don't want.
Right. You could get a little comment, a little paragraph from the engineer if you want. That way you don't have to stand on any, you're not representing a fact you don't understand.
Exactly, but, yep. And I think that was all the comments.
Okay, yeah, that's
I
it.
think there was restriped
Oh.
parking spaces.
Oh, yes, and we can restripe the parking spaces.
Okay, great. So the restriping though, do you want that done now?
I don't think that's necessary.
Okay.
Well, they were going to do planting.
Oh, they're doing planting, right, and we have time for them to actually do the planting.
And I was told that planting season begins on March 15th.
If we're lucky.
Well, the groundhog
Exciting,
didn't
okay.
see its shadows. Should be okay.
Did?
It
Oh,
didn't.
Didn't.
Yeah,
I don't-
so six-
Poor guy.
I can
He's
never-
traumatized since
Spring's
the
coming
last
sooner.
event.
All four of the groundhogs.
Every day's new weather, so I don't know.
Yeah.
And the concrete wall dimension you mentioned yesterday was 22
Oh,
feet?
Yeah, just.
Oh, I'll
just
correct
this
that in
needs
the
to be
statement.
Statement of facts,
Thanks.
yeah. Thank you.
I think that's it.
Yeah. Okay.
Got it. Okay, great.
Thanks. So, so are there any speakers on this? No. All right, so then, how soon?
So you have to
much
plan,
time?
right? So-
Oh, you have to, I'm sorry, yeah, you have to plan. We don't need provide photos, sorry, I'm just looking at what we said about the landscape drawings. Shrubs and trees need to be provided, provide street trees. Okay, so I think, yeah, you could just plant.
Because it's in compliance with the prior.
Yes. Yeah.
How about submission April 10th for April 30th?
Is that good? So a
Is that
March
enough time?
15 planting, I would say end of April to give them time to
Okay,
plan.
okay.
Yeah.
How about instead, submission of May 1st for a hearing on May 21st?
I guess there's nothing in between those.
There is something in between.
There is.
But it's April 17th submission.
It's, the idea is that you're going to be submitting photos of the planting installed. We want to give you a chance to
Understood.
organize.
May 21st just sounds very far away.
It
It
does.
is, I hope it's fun.
It does sound far. But that's the date.
Understood.
Okay, okay, that's the date. May 21st is the next hearing, May 1st submission. Thank you.
Item number 3, 2018-103BZ, 936 Avenue R, Brooklyn. This application has been postponed.
This is a postponed hearing.
No.
No.
Good afternoon, Lyra Altman from the Office of Lyra Altman. I want to let you know that we did submit, unfortunately, there appears to have been a computer error, and I apologize for that. What I did upon hearing about this is I printed new copies, and I brought them in myself today. Hard copies are already at your agency, and I will resend the electronic copy as well. What happens, just so you understand, when I send out my electronic copies, I actually CC Urban Cartographics, and they make my hard copies. There was a problem with the electronic send. He didn't receive it, neither did you. So I apologize for that.
Okay. But in terms of notice, don't we have to re-notice?
We did notify everybody, and of course...
No, on this.
For the
Here.
postponement, we need to.
You do, even if we're standing here right now, they've been alerted to today.
Well, They may have heard the hearing yesterday and know this was postponed.
There were no comments yesterday to.
Okay. Oh, no, I mean, I'm not saying that we shouldn't give people a chance, don't get me wrong, but people have been alerted to this. They could hear the comments yesterday, they could hear the comments today, they will know when it's been put on.
No,
I'm not
no,
trying
no.
to hide this from the neighbors, I apologize.
No, yeah, it's just our standard practice. Whenever they're postponed, we just issue a
We can
new-
certainly do it, I just
Yeah.
wasn't sure of the necessity since we did properly notify of this hearing.
Yeah,
of
understood.
course.
It's just for our very first hearing, we just do proof of notice again if it's been defective.
I can do that. I can do that.
Thank you.
So then you have to allow.
But, yeah.
I can have that go out, I mean, tomorrow. Have everything already.
You need to get a notice from us first.
Well, no, of course, we need to see what dates you have available. But I'm saying, don't hold up for my notification, I can get that out.
Okay, just keeping in mind that you have a second hearing that week.
And a big one, that's a really big one.
Yeah, okay. This one, you have a second hearing
I will point out that this application, for the record, is only a one-story addition. The only waiver we're requesting on this is rear yard, and it's one story. So this is not a very large application. Floor area is well below. I just want to let you know.
Weren't sworn in.
No, it's not for the purpose of arguing it, it was for the purpose of letting them know what we're going to be, yeah, exactly. For scheduling purposes, that this is not going to be a very controversial case, as it's a one-story addition.
March 7th.
Just that March is so full, we have special.
Right?
two special
15, yeah.
Okay, we could do March.
Okay, so next hearing is going to be March 26th. Oh, you're not
I can't do
available.
March
You're not
26th.
available March 26th.
I think you guys at this point are just teasing me, trying to put me on March 26th. See if
Well,
I'm
it's
paying
Sorry,
attention.
yeah, it's the most
It's always a
available
favorable
hearing
due
we
You're just trying to see
have.
if I'm paying attention.
It's the most available.
I don't want to not show up, that would just be very rude.
No.
Yeah.
April 9th.
Is there any way to do it on the 19th? As I said, this is not going to be a very large one.
I know, that's what you say, but we
Well,
also
no, the
have to
permitted
review
FAR is a
other
one.
cases.
Permitted FAR is a 125, we're asking for
Yeah, yeah,
.7
yeah.
something. I mean, we're well below
March 20th is a
1.0,
special
very small.
hearing.
No,
So
And it's one
yeah,
story only.
So April 9th.
We're going to have to go with April 9th. Unfortunately, we have a lot of special hearings in March. So April 9th, the submission's already done. We will generate a new notice of hearing for you.
Please, and if there's anything that you would like in addition to that notice of comments, the
We don't
examiner
know
lets me know,
yet,
it'd be
because we
my
haven't
pleasure to do
reviewed the
it.
case, right?
All right, Darrell will reach out to you if there's.
Of course, if there's anything I'm saying, is anything I would.
But I might say, you've had enough of these cases to know what it is we asked for. So if you want to provide them in advance of us asking for them, that would be well advised.
We're keeping 100% of the second floor. This is not going to be a very.
Well, we're not discussing it now, but I'm
Yeah,
just
no,
saying, you know what we asked
I know what you
for.
look for. I already double-checked this application. We do meet all the things that your board likes to see.
You're good.
Okay.
Great, thank you.
You are so good. Item number 4, 2018-106BZ, 124 Hastings Street, Brooklyn. Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before the board and respond honestly to board member questions?
Elise Fullader from Eric Palatnik PC on behalf of the applicant. Very happy we're at the end here.
Yeah, I don't know.
So firstly, I would like to say that we will look through the existing plans and make sure that they match with the survey, as well as the proposed, everything matches up with the survey. And we'll make sure that all the numbers are in one format. I think that we were requested on notice of comments to do everything by feet, and that's where things.
Yeah, it's feet and inches
Yeah.
versus feet
Yeah, I
and
think we
decimal points.
started in decibels, we were asked to do back to feet, and I'm saying I think that's where everything went crazy. For the joists, we wanted to ask if we could sister the joists, like we do in some applications.
Sure, but it's not about the sistering, was the drawings are indicating all the joists are going to be removed.
So
it's
as
not
a-
about sistering, it's
So I'm
about
saying now,
removal.
can we keep the joists and sister them?
So does she, no, it's not sistering. Sistering is when you put you have a joist that goes as far, and you want to continue it to go that far, so you add another one together and you link them, right? You're talking about raising
Or
them.
raise, whatever the term
okay.
is for.
Sure, you can raise just existing joists.
Okay.
But you have to indicate that, and you have to indicate that it's existing joists to be retained, but to be raised.
To be, okay, sorry, I got the
Right?
lingo confused.
No,
We
I
do both
understand.
Similarly, and I will explain that to the architect, because the architect was unsure how that could go about doing that, because he's not used to going, this is his first time at the BSA. And also, I apologize, he couldn't come, it was a little too late in the day.
Okay, understood.
And then lastly, DOB objections. I reviewed the DOB objection sheet. There are 3 flood compliance questions on there. I will submit the DOB objection sheet. And then already we got an appointment for March 5th at the DOB to resolve those flood requirements.
Okay, so that's good, but so if the DO, so the question is this, if I didn't realize until looking at the sections that the floors were being raised. So once the floors are being raised, you obviously don't keep the interior partitions in place. That's a physical impossibility, right? So now it's a gut renovation of a house. In order to raise the joists, you tear down all the interior walls and you tear apart the floor and now you lift the joists up, right? So I don't know what goes into the analysis of a substantial improvement, which then triggers whether or not you have to comply with raising, I mean, in your case, what you've got is the base flood elevation, and therefore the design flood elevation is a little bit higher than your existing floor, first floor. You're not proposing to raise the first floor, so as a result, if this was a substantial improvement, it would not comply with the regulations. You would need to raise the first floor, I don't remember what it was, a foot or 2 feet or something like that, right? And so I don't know that the DOB was aware, based on the drawings that may have been, I don't know what was provided to them, that this is a gut renovation, total gut. The only thing that's still standing are the sidewalls in a certain way, because all the joists, one at a time, are being lifted. So
So if we fix the plans first with the to be raised and then provide those to the DOB at that March 5th and then show you that those were the plans that we submitted to DOB, would that suffice?
I think so. You need to demonstrate to us that that the DOB objection sheet was aware, maybe, I don't know what was shown to DOB in order to get those objections.
Since we're going back to the DOB, I'm saying, can't we show you what was is being shown on March 5th? We'll do these changes before March 5th. Then we'll take these plans to the DOB on March 5th. And then we will show a confirmation that we went to that, because they do that little email with it. And unfortunately, all they do is examine our handwriting on the DOB objection sheet and show you what plans we submitted with an affidavit on March 5th.
Good.
Yep. So hopefully that'll take care of everything.
Okay, good. All right. Are there any speakers on this? Okay, so you have your objection meeting on March 5th, and then who knows what happens?
And we hope for the best, and
we can hope for the best and put you on like April.
Is it
April
possible
9th?
to get that March 26th?
Oh.
Because you said it was really open.
You're willing to give it, yeah. So
Yeah, we've been trying to sell it. No one wants to buy. Yeah.
So March 26th, the next hearing, submission March 6th.
26th.
But that's the next day after your review,
Your meeting.
Yeah.
You sure you don't want April 9th?
I'm sure I don't want April 9th.
Okay.
I'll really, 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 really hustle.
Okay. Thank you.
No plans on March 5th.
Okay. I checked if there were speakers. Are there any speakers? Yes. Okay, already checked. All right, good, thank you.
Thank you.
This concludes the public hearing for February 5th, 2019.